Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established amongst us for all generations. Yeah, that's right.
Announcements by the Speaker.
Honorable members, I have received communication from the Honorable Penelope Beckles-Robinson, member for Arima, who has requested leave of absence from today's sitting of the House. The leave which a member seeks is hereby granted.
Papers.
Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I have the honor to lay the following papers in the name of the Honorable Attorney General. The annual administrative reports of the Ministry of the Attorney General for the periods 2010-2011, 2011-2012, 2012-2013, 2013-2014, and 2014-2015. The annual administrative reports of the Ministry of the Attorney General and Legal Affairs for the periods 2015-16, 2016-2017, and 2017-2018. The annual administrative reports of the Office of the Attorney General and Ministry of Legal Affairs for the periods 2018-2019, 2019-2020, 2020-21, and 2021-22. Thank you kindly, Mr. Speaker.
Honorable Minister of the People, Social Development and Family Services.
Thank you very much, Mr. Speaker. Mr. Speaker, I have the honor to lay the annual administrative report of the Ministry of Social Development and Family Services for the period 2023 to 2024.
Urgent questions.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Mr. Speaker. To the Minister of Energy and Energy Industries, with respect to the offshore oil spill on May 1st, 2026, which the Minister only alerted the population about on May 10th, 2026, would the Minister inform this House whether he has been in touch with the Minister of Energy of the Bolivarian Republic of Venezuela to provide her with the details and information related to the said oil spill, which has negatively affected Venezuela?
Honorable Minister of Energy.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, given the limited time to respond to an urgent question, we did contemplate a full ministerial statement, but I'll try to address it in a couple minutes. Mr.
Spain North, there's no need for that.
There's no need
it's
to
too early in the day
excited.
for that. Let the Minister answer the question.
Very
it's
much.
too early in the day for that.
Mr.
Yes,
Speaker,
no.
Mr. Speaker, this ill-advised, ill-conceived question from the member for Port of Spain North, St. Anne's West is premised on several fallacies. First, Mr. Speaker, the oil spill in question of May 1st is deemed and was deemed to be a small spill for Tier 1 small spill. But I like using small spill because I want to link it to something else just now. A small spill. And Mr. Speaker, there is no policy or protocol for the Ministry of Energy to issue a public advisory or a press release in dealing with small spills. There is no, and I want to tell the Minister, between the years 2019 to 2021, Mr. Speaker, there were 76 small spills, of which the Ministry of Energy never issued one press release. Because press releases are there for when there is a tier 2 or tier 3 spill and it affects the shoreline, it affects the fisher folks and so on. But coming back to this main issue here is that, Mr. Speaker, upon receipt Saturday, May 9th, in the late evening, of a communique allegedly issued by the Republic of Venezuela, within hours, the Ministry of Energy issued a statement. Within hours,
Minister,
issued a statement.
2 minutes for the time, for the answer is up. Supplemental question?
Thank you very much, Mr. Speaker. Mr. Speaker, the question asks about informing the Minister of Energy of the Bolivarian Republic of Venezuela. Can the minister tell us if he even knows the Minister of Energy of Venezuela's name?
No. Whether you wish to answer it or not is predicated upon whether the question qualifies to be answered. Or this way north, I think you know better than whether to ask whether the minister knows the minister. Yeah, you can ask your second supplementary question.
Thank you very much, Mr. Speaker. To the Minister of Energy, has the Minister of Energy issued any direct correspondence from himself to the Minister of Energy for Venezuela?
Thank you very much. Right, Mr. Speaker.
That's the original question.
I welcome that because I will now deal with that. Mr. Speaker, the communique from the Republic of Venezuela was issued through diplomatic channels. It was not sent to the Minister of Energy of Trinidad and Tobago. Therefore, on the very night of May 9th, our statement from the Ministry of Energy was sent to His Excellency Alvaro Sanchez, Ambassador of Venezuela in Port of Spain. And this statement...
Minister! Minister, have your seat. Port of Spain not. Let me make it abundantly clear. It is too early in the day for that. It is too early in the day for that. No, hold on. Hold on. You have set a higher behavioral ethos in this parliament than what you are displaying this morning. It is way too early for this unbridled obstreperousness that seems to be want to pervade today. I am not having this kind of behavior this morning. It's too early in the day for that. It is too early in the day for that. There's absolutely no need for this bad behavior. Okay? Minister, you as well are too experienced to be drawn into that kind of exchange. All right? So let's move on. So we go now to the second question, the member for Ruka Lopino.
Thank you very much, Mr. Speaker. To the Minister of Homeland Security, in light of the disappearance, take pertinence to the question, please. In light of the disappearance of two...
This is not a glorified schoolyard. All right, so ask your question without editorial comment.
Thank you very much, Mr. Speaker. And I wish to pose my question with some silence from the other side. To the Minister of Homeland Security, in light of the disappearance of 2-year-old Angelo Tobias Plaza of Goodwood, Tobago, can the Minister provide an update on the TTPS's investigation into this matter?
Honourable Minister of Homeland Security.
Honourable Mr. Speaker, and again, thanks for the question from Ruka Lopino. Mr. Speaker, this investigation is continuing. Immediate search for the child continues. There are a number of agencies involved in this operation, including the Tobago Investigative Arm, the Fire Service, the Trinidad and Tobago Emergency Management, the Coast Guard, along with the Trinidad and Tobago Child Protection Unit and the Homicide. Mr. Speaker, as the investigation continues, we'll be able to update members of the public with the investigation. At this time, the child has not been found just yet. However, the investigation continues.
Aruka Lopino.
Thank you very much, Mr. Speaker. Supplemental question to the Minister. Minister, can you indicate at this point in time whether this matter is being treated by the TTPS as a homicide or a missing person?
Honourable Minister, are you in a position to answer that?
Mr. Speaker, I indulge the heirs of the Aruka Lopino member, and I said, the Child Protection Unit and the homicide is part of the investigation. I hope that involves your heir at this time.
Second supplemental.
Mr. Speaker, supplemental question to the Minister. Minister, having regard to the fact that the Victim Support Unit, the Child Protection Unit, Homicide Unit are all involved in the investigation of this very serious matter, can you inform the national public whether the TTPS is currently treating this matter as an unlawful homicide or a missing person?
I think that's been asked and answered. Let's move on.
Something wrong with the left ear?
Well, Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, the government is happy to report that we are in a position to answer all questions. There are questions in the order paper posed to the Ministries of Public Utilities, Ministries of Finance, Energy and Energy Industries, Homeland Security, and we will be answering all.
Member for Port of Spain North, St. Anne's West.
Mr. Speaker. Mr. Speaker, question number 68 to the Minister of Public Utilities.
Honourable Minister of Public Utilities. The Ministry.
Thank you, Mr. Speaker. Mr. Speaker, just as I answer this question, let me just indicate how wonderful it is to answer this question as the rising sun beams down on this Parliament. Mr. Speaker, this project was initiated on 5th March 2025, just 2 weeks prior to the announcement of the 2025 general election. Following the government's overwhelming mandate on 28 April, we took a deliberate decision to evaluate and advance projects that demonstrate clear value and meaningful impact regardless of location. Whether in Northwest or elsewhere, our focus remains on the holistic development of Trinidad and Tobago and ensuring that every investment delivers real benefits to citizens. Therefore, in keeping with this approach, Mr. Speaker, we ensure the continued execution of St. Anne's Well No. 3 under the Northwest Stabilization and Improvement Program, which was successfully completed in December 2025. The associate interconnection works are scheduled for completion on or before July 2026. Thank you, Mr. Speaker.
Member for Labrie. Member for Labrie, on behalf of the constituents, in particular of the St. Anne's and Cascade area, this well being completed in December 2025, can you please advise when the works are going to start with respect to the connectivity to the main water framework for that valley?
Honourable Minister.
Yes, Mr. Speaker, in my response, I did say that the associate interconnection works are on schedule for completion on or before July 2026. I want to add, Mr. Speaker, that the people of Upper Cascade, Monrepo, Lower Cascade, Koblenz, Mount Hololo, Aripita, they're going to see some benefit after July 2026, Mr. Speaker.
Thank you very much. Mr. Speaker, on behalf of those same constituents of Upper Cascade, Monrepo, and the upper areas of the valley, who we know are going to benefit, hence we are doing the project, can the minister, the member for Liberia, please tell them when the connectivity is going to begin?
Minister, have you answered that already?
No, he hasn't. He said it's going to finish in July.
No. Policeman North, I think the question has been asked and answered. You can move.
Mr. Speaker, the question is when is the connectivity works going to start, not when it is going to be completed. We're in the month of May, and no work has begun.
Right. Minister, if you could confine your answer to the commencement date.
Mr. Speaker, as I said before, the work was successfully completed in December 2025. The interconnection works are scheduled for completion on or before July 2026. Mr. Speaker, as soon as those completion works are completed, the people are going to get water.
For the Spain North.
Last question. I feel sorry for the member for Couva North, who's one of my constituents who gets truck-borne. Mr. Speaker, supplemental question to the member for Labrie. Member for Labrie, would you accept that the works began since 2024 and not, as you say, on the 5th of March 2025? Would you tell the truth and accept?
Minister.
Mr. Speaker, I am appalled by that question.
Yes.
First of all, if it was started in 2025, why was it not in 2024 as he suggested? Why was it not completed before he left office, albeit for 1 month? Albeit he was there for 1 month. He had all of the power, all of the authority to complete it before now. But he's coming now to rush
Mr. Speaker,
us and to make
Standing
us...
Order 29.5.
The objection is to relevance. You need to make up your mind. No, but you need to make up your mind which limb of 29.5 you're relying on, whether it's the 5-minute or the relevance.
Speaker, you could pick one and see how it goes.
I could pick one? The Martin Central, you've been here for 10 years. I haven't quite made a year yet. Yes, I'm happy you recognize that. So pick your poison. Relevance, overruled, Minister.
So, Mr. Speaker, again, the fact that a former Prime Minister...
All right, okay. Said overruled. Confine it, please.
Yes, a former Prime Minister who had all of the ability to not only begin, but to complete this work. That appalls me, but Mr. Speaker, I want to say this, Mr. Speaker. You're getting involved in other countries' business. I want to say this, and I'm glad you asked the question from the front and not from the back. I want to say this, Mr. Speaker, that if I accept that it was started in 2024, maybe it was because of the procurement process that it started in 2024. But the works to actually get the thing going did not start until after we took office in 2025.
Giving my friend from Labrie the opportunity. Is he taking ownership of that statement? And my point of order is he taking ownership? Because if he misleads the Parliament, there are consequences.
Honourable Minister, would you want to clarify that statement?
Mr. Speaker, I've been advised by WASA, we do not do the work ourselves, and therefore I've been advised by WASA that is what is happening. I do not go out there and dig up the ground and put on the pipeline. I have to be advised by the association, by the authority.
Okay. Question. Okay. Shagwanas East. I may not see you, but sometimes I hear you. For the Spain North, why are you so uncharacteristically chatty this morning? You all do know that all of this cuts into the 40 minutes, right? So let's move on. Number 75. The floor is yours, Port of Spain North.
Mr. Speaker, question number 75 to the Minister of Finance.
Mr. Speaker, I welcome this question because it allows this government to expose one of the clearest examples of the difference between announcement and achievement. Mr. Speaker, for years, the country heard about grand statements about dragon gas, cross-border gas, regional energy corporation, and the rescue of the energy sector. The former administration spoke as though gas was already secured. They spoke as though arrangements were already settled. They spoke as though Trinidad and Tobago was already in a position to benefit. However, the truth, Mr. Speaker, is that there was no completed fiscal framework to ensure that Trinidad and Tobago will earn its fair share from cross-border and across-border natural gas entering this country for use or processing. And that, Mr. Speaker, is the central issue. Trinidad and Tobago has a strategic advantage. We have decades of investments in pipelines, platforms, processing facilities, liquefied natural gas capacity, petrochemical plants, technical expertise, and an established gas-based industrial economy. But a strategic advantage is only useful when a government has the discipline and competence to turn it into revenue, jobs, foreign exchange, and national value. This government's fiscal policy is therefore clear. Where natural gas or other hydrocarbons enter Trinidad and Tobago for use, processing, liquefaction, industrial activity, or export, Trinidad and Tobago must be compensated. The country must not be treated as a convenient corridor. Our infrastructure must not be used without fair value. Our jurisdiction must not be taken for granted. Our people must not be left watching others monetize resources through a system that Trinidad and Tobago helped to build. Mr. Speaker, cross-border fields such as Laura and Manatee, Coquina, Manakin, are resources that straddle maritime boundaries. Cross-border fields such as Dragon in Venezuela are resources located outside of Trinidad and Tobago's exclusive economic zone, but may be developed by utilizing infrastructure in Trinidad and Tobago. The existing government-to-government arrangements with neighboring jurisdictions, including Venezuela, Barbados, and Grenada, do not themselves set out the specific fiscal terms for the importation of hydrocarbons into Trinidad and Tobago. That is a serious gap. It means that while the country had arrangements, discussions, and expectations, the revenue system and structure was still unfinished. Mr. Speaker, that is what this government inherited. A sector hungry for gas, industries under pressure, domestic production declining, and external gas opportunities being spoken about for years without a completed policy to determine how Trinidad and Tobago would be paid. Mr. Speaker, the former administration had years to settle this matter, yet when this government assumed office, the country still did not have a finalized fiscal framework for cross-border and across-border hydrocarbons entering Trinidad and Tobago. Mr. Speaker, this government is correcting that failure. We're establishing a fiscal framework that will ensure Trinidad and Tobago captures value from external hydrocarbons entering this country. Possible revenue arrangements may include fixed fees for the importation of hydrocarbons, commodity charges based on the volume of gas consumed, unit transit fees based on distance, reserved volume or consumed volume, and any other mechanism required to protect the national interest while preserving project viability. Let me be clear, Mr. Speaker. This government understands that energy projects must be commercially workable. We are not seeking to suffocate investment. We are seeking to ensure that investment does not take place at the expense of the people of Trinidad and Tobago. In January 2025, an interministerial committee chaired by the then Minister of Energy and Energy Industries was established to develop a fiscal framework for cross-border and cross-border resources between Trinidad and Tobago and other jurisdictions. Its mandate was to develop a possible fee structure, recommend who should pay those fees, propose draft language for any fiscal measures, and assess whether the proposed framework could affect energy sector development. Mr. Speaker, that committee was given 3 months. Its tenure ended before the exercise was completed. That fact speaks loudly. While the country was being told that cross-border gas was on the way, the fiscal architecture to protect the treasury remained unfinished.
Time limit is up.
Thank you, Mr. Speaker.
Thank you very much, Mr. Speaker. Mr. Speaker, on behalf of the citizens of Trinidad and Tobago, to the Minister of Finance, fiscal policy is a domestic issue and has nothing to do with Venezuela. After all of that long run-up, can the minister please advise the country what is the fiscal policy for the gas from Coquina, from the gas from Mannequin, and cross-border gas from fields such as Dragon?
Mr. Speaker, while the country was being told that I will answer your question. While the country was being told that cross-border gas was on the way, the fiscal architecture to protect the treasury remained unfinished. While the population was being given promises, the hard work of settling how Trinidad and Tobago would earn revenue had not been completed. Mr. Speaker, we are establishing a new fiscal review committee which will examine the full gas value chain. That includes production outside of Trinidad and Tobago, transportation across maritime boundaries, entry into this country's jurisdiction, processing, liquefaction, industrial use, and export. Along that value chain, Mr. Speaker, the committee will examine transport tariffs for the use of pipelines, processing tariffs for the use of offshore and related infrastructure, and a possible cross-border access fee to recognize the value of hydrocarbons entering Trinidad and Tobago's jurisdiction and using the country's energy platform. Mr. Speaker, that is where this government is different to the former administration. The member opposite, Mr. Speaker, is anxious today to find out. Sorry.
So let's go to the second supplemental.
Thank you very much, Mr. Speaker. Mr. Speaker, to the Minister of Finance, having only now a year later looked to set up this committee, does the government understand that they cannot now go and tell operators like Shell and BP, who have already run their commercial models, that they're coming now to impose fiscal terms? As usual, they're behind the 8 ball. What are they going to do?
All right. Can we distill that into a question?
Thank you very much, Mr. Speaker. I accept it has to be broken down a lot simpler for those on the other side.
Well,
would the minister please advise whether they have told BP and Shell that they intend to impose heavy fiscal terms on their commercial modeling? Maybe you'll understand that.
Honourable Minister.
Mr. Speaker, it seems that the member for Port of Spain North St. Anne's West has lost his way. He has forgotten where he is right now. He believes he's still acting Prime Minister. I would urge the member for Port of Spain North St. Anne's West to stay out of the business of the energy sector negotiations taking place in this country.
Minister, can I just ask you to, if you could provide a short, crisp answer to that question, if you can?
Mr. Speaker, the government, as I just described, of this country is involved in negotiations with substantial multinationals as it relates to this package and as it relates to our treatment with the oil and gas developments. Those developments are in negotiation and discussion stages. The member opposite very well knows that, but is seeking to ride the backs of the work of this government, which he failed to do when he was in office.
Supplemental.
Thank you very much. Mr. Speaker, to the Minister of Finance, is the Minister of Finance telling Trinidad and Tobago that he, as Minister of Finance, is taking instructions from the multinationals as to what should formulate our domestic fiscal policy?
I don't think that's a fair question. I don't think that's a fair question. I don't think that arises from any answer. I don't think it's a fair question. Fourth question, if you have one. Right, let's move on. We go to 76 now, and Port of Spain, no, this is a long innings. You're on next.
Thank you very much, Mr. Speaker. Mr. Speaker, question number 76 to the Minister of Energy and Energy Industries.
Very much. It would be my pleasure to return the House to calmness. Mr. Speaker, in response to question number 76 from the Honourable Member opposite, the response as follows. The government's policy as it relates to the allocation of natural gas from cross-border and across-border projects will be to adhere to the agreed allocation arrangements which would have formed part of the negotiated commercial arrangements prior. For future projects which do not have an agreed allocation, the government's policy will be to negotiate an allocation structure that is in the best interests of the Republic of Trinidad and Tobago. Thank you.
Full supplemental.
Thank you very much. To the Minister of Energy and Energy Industries, the Minister's reference to adhere to the prior commercial contracts, would the Minister confirm that these are the licenses for Coquina Mannequin and Dragon and those terms?
Honourable Minister.
Thank you very much. Mr. Speaker, the member for Port of Spain North, St. Anne's West has knowledge of prior arrangements for several of the across-border projects, and those arrangements are in place by way of license for 30 years, I believe, in the case of one gas project, and we will adhere to those arrangements at this time.
Member for Port of Spain North.
30-year license to which the Minister refers, is that the 30-year license that was negotiated and signed on December 2023 for Dragon Gas by the previous administration?
Honourable Minister.
Mr. Speaker, the member for Port of Spain North, St. Anne's West is aware of the answer to that question.
Mr. Speaker, the greatest of respect, it is not whether I have the answer for the question. Those on the other side seem to forget that they're answering to the population of Trinidad and Tobago.
To rhapsodize.
What is the point of order? What is...
All right.
April 2025. And prior to April 25 is when the member there and his team lost completely a license from the United States government, which we only retrieved 6 months later. And there's now no need for further arrangements on that front. You're aware of it. Why are you, carrying on?
Question 84, but in context, anyway. It doesn't arise. I was going to make an observation, but it doesn't arise. I better not do that. Question number 84, member for Ruka-Lopino.
Thank you very much. Mr. Speaker, question number 84 to the Minister of Homeland Security.
Mr. Speaker, relative to the question 84 posed by the member for Ruka-Lopino, I am constrained to invoke the provisions of Standing Order 28.3 of the Standing Orders, Mr. Speaker, out of deference for the work of the Trinidad and Tobago Police Service.
Ruka-Lopino.
Thank you very much, Mr. Speaker. Supplemental question to the Minister.
Well,
in his response.
hold on. Have a seat. If the Minister invokes the public interest exception in 28.3, and 28.3 is very clear, a minister may decline to answer a question if, in his opinion, the publication of the answer would be contrary to the public interest. What possible supplemental question could arise from the blanket invocation of the public interest exception? I need you to justify why a supplemental question arises in those circumstances.
Thank you.
And I don't wish to be regaled with the tired old story of accountability and all of that, which you've traversed here before, right? So you need to find some justification as to why I ought to permit a supplemental question on the invocation of the public interest exception.
Mr.
And
Speaker,
I'm required to direct it to me.
Mr. Speaker, on a point of clarification. Mr. Speaker, we are at questions on notice. And for the benefit of the viewing public, Mr. Speaker, the citizens of Trinidad and Tobago who are looking at these proceedings, these questions are filed in order to get the executive arm of the state to account for critical matters of governance in Trinidad and Tobago. I'm speaking to the Speaker. Please don't disturb me. Mr. Speaker, the question that was filed for the Minister was basically to ask the Minister whether persons have been charged under the Anti-Gang Act since the state of emergency and whether anyone has been charged in relation to the alleged plot to murder senior law enforcement officers in Trinidad and Tobago. Mr. Speaker, I'm talking to the Speaker. Mr. Speaker, these questions are in the public interest, Mr. Speaker, because, Mr. Speaker, this country is under a state of emergency based on these factors, and the people of Trinidad and Tobago are deserving of answers to these critical things. And when, Mr. Speaker, when a minister could come and invoke standing orders not to account to these basic principles and facts, Mr.
All right. I think, let's take it from this angle, okay? And everyone sat here collectively as a parliament and enacted these standing orders. The public interest exception, which allows a minister to decline to answer a question, whether in writing, orally, or urgent, appears numerous times in these standing orders. The fundamental question the entire body collectively has to answer is, if it were not intended for the public interest exception to apply, then why include it in these standing orders? The fact that it was included in standing orders, and it appears repeatedly. If you wish me to go through them with you, I can. Okay? There's an exception in the urgent questions, there's an exception in the written questions, and there's an written answers, and there's an exception in the oral answers. So each tier of questioning, the Parliament collectively as a body has given the minister the residual discretionary power to refuse, to decline the answer. I don't want to say refuse, because that's a strong word. But the neutral term will be to decline the answer. Can I just allow my Madam Deputy to sit whilst I... Decline the answer on the basis that it will be contrary to the public interest. As I've repeatedly explained before, the invocation of the public interest is not a binary process. Administrative reasoning, by its very nature, and Port of Spain North and Port of Spain South are two members who are especially familiar with the concept of polycentric reasoning in administrative decision-making. Port of Spain North is smiling because he knows that it's not a binary process. There are many considerations which apply to the invocation of the public interest. I see you looking at the clock, but it is you who invited this ruling, on it. Because I told you, and I've repeatedly said it before, I, as presiding officer, I do not have the power to go behind the invocation of the public interest exception, which is contained and littered all across these standing orders. In a court of law, as Port of Spain South will tell you, where the public interest exception is invoked, a judge at common law has the discretionary power to say, let me see that material and I will make a decision based on the fairness of the trial. There are no fairness concerns here. So I have no power to go behind the invocation of the public interest. All right? So let's not take up more of the 40 minutes and let's move on. The invocation of the public interest seems to be an absolute bar, the way these standing orders are constructed. So let's move to the next question, which will be question number 85. Okay, shall we? Member for Aruka-Lupino.
Thank you very much, Mr. Speaker. Let us hope that the Minister takes paternity for this question. Question number 85 to the Minister of Homeland Security.
Homeland Security.
Mr. Speaker, I'm hoping that the member for Aruka-Lupino would listen with his left ear. Mr. Speaker, in accordance with the Trinidad and Tobago Police Service, 11 persons have been charged in relation to murders committed in 2026. Investigations are continuing, and this number, according to the investigators, will certainly go up. Thank you, Mr. Speaker.
Thank you very much. Supplemental question to the Minister. Minister, having regard to the fact that we have approximately 135 murders committed so far during this year, with most of the days in this year being under a state of emergency, can you state whether the current state of emergency and the extensive powers given to the police are bearing fruits on police investigation in solving the vast majority of murders that would have taken place in 2026?
I'm not permitting that. It is so outside the box of the question that was asked and the answer given. So unless you have another supplemental, let's move to the second supplemental.
Minister, having regard to the fact that it is only 11 murders or persons charged for murders out of the 135 murders committed in 2026, what is the Ministry of Homeland Security and the TTPS doing to improve the solve rate of murders in this country?
If you had intended to be given permission to ask those questions, what you ought to have done, yes, it's a supplemental, but yes, but response doesn't form part of the original question. Your original question is, can the minister state how many persons have been charged to date for murders committed in 2026? What part of that contemplates allowing you? I did not ask these questions, you did. You formulated your own questions, and you ought to formulate your questions in accordance with the rules. This is a very simple question, requiring a one-line answer which the minister has given. If you want to ask further questions about the efficacy of policing and measures and countermeasures, ask another question, but it does not qualify under the rules to be asked as a supplemental.
Mr. Speaker, on a point, you have indicated to me, Mr. Speaker, quite respectfully, that I ought to formulate my questions in relation to the rules. Mr. Speaker, those questions were filed with the Parliament and they go through an approval process. You approve those questions to be on the order paper. And therefore, Mr. Speaker, I want to make it abundantly clear that these questions that are appearing on the order paper are well within the standing orders of this Parliament?
They are. They are. No one is denying that. What is impermissible is to thereafter seek to broaden the scope of the original question you asked. That is the impermissible part of it. I am not saying that the questions are in breach of any standing orders. The supplemental questions are because they seek impermissibly to broaden the scope of the original question, which we all know is contrary to the standing orders. So unless you have a third supplemental, I intend to move to the next question, 86. Shall I move
next
to...
question. Next question.
Next supplemental,
Yes.
third, right?
No. Next question.
Next question, 86. All right. Member for Ruka Lopino, question number 86.
Thank you very much, Mr. Speaker. Question number 86 to the Minister of Homeland Security.
Honorable Minister of Homeland Security.
Mr. Speaker, and again, thank you for the question, Aruka Lupino, as usual. Mr. Speaker, Home Invasion, Self-Defense and Defense of Property Act and the Defense of Property Act 2025 was ascended to on December 16, 2025, and subsequently proclaimed in law on January 20, 2026. According to information from the Trinidad and Tobago Police Service, a total of 69 reports of home invasion has been reported as of April 19, 2026, since the enactment of this legislation. In previous years, Mr. Speaker, incidents now classified as home invasion would have been recorded under categories of robberies, burglaries, break-ins, larceny dwelling house. It is anticipated that with the introduction of this new legislation, Mr. Speaker, and for the corresponding period and the provisions of the defense of property, these incidents will decline over time. The Trinidad and Tobago Police Service remains committed to its mandate to ensuring public safety and continued to implement measures aimed to strengthen its capacity to provide a response effectively to home invasions. Further, Mr. Speaker, 25 persons have been charged under the Act during the same period. Mr. Speaker, investigations continues and additional persons would be placed before a court of law to be dealt with according to law.
Thank you very much, Mr. Speaker. Supplemental question to the Minister. Minister, having regard to the fact that you have indicated that since the enactment of this legislation in January 2026, and having regard to the fact that there are 69 reports since the enactment of this law, can you indicate, as specified in Part B or 2 of the question, how many persons have been charged under this legislation?
Minister.
Mr. Speaker, it seems like the air is a problem today. I don't know if it's the air in here. I know, Mr. Speaker, I just mentioned 25 persons have been charged to date. And Mr. Speaker, there's an addition. The investigation is continuing. As you would have seen in the Central Division, a number of persons would have been arrested and a number of persons would have left the earth suddenly. Mr. Speaker, as a result of that, the investigation continues and a number of persons was identified as participants in home invasion. So the numbers will certainly go up, Mr. Speaker.
Still question to the Minister. Minister, can you explain what is the meaning of persons who would have left the earth suddenly?
Honourable Minister.
Mr. Speaker, what was meant is that there were persons conducting home invasion in Central, and because of their behavior, they would have invited their own deaths.
That's it. Shall we move on?
Public Business, Government Business Bill, second reading.
Honourable members, the debate on the second reading of the following bill, which was in progress when the House adjourned on Friday, May 8, will be resumed. A bill entitled to provide for a system of parole and related matters. Member for Lupino.
Thank you very much, Mr. Speaker. Mr. Speaker, on the last occasion during this debate, two of my colleagues, Port of Spain North, St. Anne's West, and Port of Spain South, would have contributed, and I want to align myself with many of the observations, if not all of the observations that they have made in this piece of legislation, and commend them for the great work that they have done in drawing the public's attention to this very critical piece of legislation and its benefits and potential shortcomings if, as a parliament, we are not careful in the way in which we pass legislation, in the way in which we prepare institutions, Mr. Speaker, when we engage in these types of business to improve our criminal justice system. My both colleagues, Mr. Speaker, would have reiterated the opposition's position that from a philosophical perspective, we are in support of introducing parole in Trinidad and Tobago, as has been done in many countries in the Caribbean, in the Commonwealth, in the United States of America. But as they have indicated, the issue of parole is not a silver bullet that will address many of the intractable problems within our prisons. And if we are not careful in implementing such legislation in Trinidad and Tobago, many countries like Jamaica, that has parole over the last 20 years, since its inception, did not realize a reduction in their prison population. And they would have gone on many occasions to their parliament to enact many pieces of amendments to their parole legislation. And not even that, Mr. Speaker, unfortunately, Jamaica at this point in time is still grappling with the issue of prison overcrowding, overpopulation, however one has to refer to it. The Minister of Justice would have regaled this Parliament and the national community with some very interesting statistics on the matter. And I must say that his contribution in itself was not a bad contribution, I would say. Not a bad contribution. But, Mr. Speaker, the Member of Parliament for Toco Sangre Grande entered in this debate and would have taken the issue and the issues in this bill to a completely different level that generated a lot of public discussion, even in today's newspapers. And I want to align myself with my colleague from Port of Spain North, St. Anne's West, who would have termed his contribution as perhaps one of the worst in the history of this country, Mr. Speaker. You see, Mr. Speaker, I was very surprised when the member for Toco Sangre Grande entered the debate, and for 30 or perhaps the most part of his contribution had nothing to do with this very important piece of legislation. But he pointed to two serious matters that took place in Mova and in Belmont, where we had quadruple murders, and the minister put on the record of this Parliament in this very debate, Mr. Speaker, that the two unfortunate matters were linked. And then he went on to link the Member of Parliament for Port of Spain North, St. Anne's West as having knowledge of what he is saying. Mr. Speaker, as parliamentarians, as members of Parliament, we have to be very careful what we say here, because sometimes we can breach the standing orders, as you know, we can be hauled before the Privileges Committee, but oftentimes what we say has serious implications in the national community, so much so that it generated headlines in one of the major newspapers in this country, the comments for the Member of Parliament for Toco Sangre Grande. And, Mr. Speaker, yesterday, following the contribution of the member for Toco Sangre Grande, it was reported in the Guardian newspapers where, quoting from the member, it says at page 5, During his contribution in Parliament last Friday, Defense Minister Wayne Sturge said the two incidents were linked, referring to the two murders or mass murders. He said then, I am sure he, the member for the area, Stuart Young, knows that the murders yesterday, April 7th, are connected to the murders in Lady Young. The quadruple murder, it is connected, and we know where they are from. We know, we have seen all the wakes and all the crime. We know Bella Road is in play. We know Serrano Road is in play. Mr. Speaker, the police investigating these two serious incidents are now on record, including, to an extent, the Commissioner of Police is saying that they are now distancing themselves from the comments of the Member of Parliament for Toko Sangre Grande on this very serious matter in this debate, Mr. Speaker. And the police have indicated that they have no evidence whatsoever that the two murders are connected. But interestingly, Mr. Speaker, in today's Express newspapers, the minister, who is a member of the National Security Council in this country, and that is the reason why he has opened up this debate where we in the opposition cannot ignore the gravity of what he said and put on the Hansard in this debate. Because he is the Minister of Defense and he is a member of the National Security Council of the government of Trinidad and Tobago. And the minister, responding to the Express newspapers, said that two intelligence officers from two national security agencies in Trinidad and Tobago give him intelligence information that what he said in the Parliament in this debate was in fact correct, contrary to what the police have told the people of Trinidad and Tobago to refute what the minister has said. The minister, a member of the National Security Council Trinidad and Tobago, saying that two intelligence officers reported to him that what he said in this debate was correct. And you have to ask yourself, Mr. Speaker, whether the Minister of Homeland Security is also a member of the National Security Council and whether they speak to each other. Because, Mr. Speaker, because the gravity of what is being said and what would have been placed on the Hansard in this debate cannot be ignored, Mr. Speaker. It cannot be ignored. And I want to say to the government, especially the Member of Parliament for Toko Sangre Grande and the Minister of Defense, that he ought not to be reckless in the way that he discharges his responsibility in this Parliament and outside of this Parliament, where these very serious matters are concerned, Mr. Speaker. And once again, the opposition wishes to reject out of hand the statements made by the Minister of Defense, the Member of Parliament for Toko Sangre Grande, as it relates to these two very serious matters in Mova and in Belmont. Mr. Speaker, this debate and this bill is a very important evolution in our criminal justice system. The opposition would have indicated through our two speakers that we are prepared to support the government on this critical piece of legislation. We believe that it will contribute to reform in our criminal justice system. But we also served caution, Mr. Speaker, because in looking at other jurisdictions, as I've indicated a short while ago, Jamaica, for example, not being a good example, but in the United States of America, in England, in Australia, in South Africa, there are many countries who grapple with the issue of parole, and many of them saw some level of improvement, and others did not see the type of improvement that they expected when this piece of legislation was passed. And what I want to do, Mr. Speaker, in this debate is to go through a workflow of what this bill is like and the impact of this bill if and when it is passed in the Parliament, so that the ordinary man and the ordinary woman, and even for us here in the Parliament, debating and wishing to contribute to this debate, can have an understanding that when this parole bill is passed, what and how it is going to be implemented. Mr. Speaker, allow me to give a personal experience I had a couple of years ago in the 12th Parliament. There was a joint select committee that I was part of that examined the issue of unproclaimed legislation in this country. And being a member of that joint select committee, I was really shocked that many pieces of legislation that were passed, or bills that were passed between the period 2010 and 2023, I think it was, the vast majority of them were unproclaimed. And when we call the public servants and the various state agencies to explain why those critical pieces of legislation, data protection, for example, were not proclaimed, we identified a number of institutional deficiencies that prevented critical pieces of legislation from being implemented. And I'm raising that red flag to the government, hoping that it takes on board some of the recommendations, that if we are not careful, this very important parole bill may, God forbid, be another piece of legislation that looks good for the government to boast that they have achieved the passage of this critical piece of legislation, but it might perhaps be one of the pieces of legislation, while being passed in this Parliament, remain unproclaimed because of institutional deficiencies in Trinidad and Tobago. Because when you pass those pieces of legislation, it is not for the Parliament to implement the legislation. It is those state agencies, the public sector agencies, and in this case, the Prisons Authority, the Judiciary, the Trinidad and Tobago Police Service, the Parole Board, all of these institutions, if they are not resourced, and if they are not equipped, and if they are not prepared, and if they do not go through the necessary institutional rehabilitation, then the legislation would just remain on paper, and the people of Trinidad and Tobago will not see the benefit of this piece of legislation. And it is that reason, it is for that reason, the opposition is asking the government to refer this bill to a joint select committee, because we are prepared to support it. Refer this bill to a joint select committee of Parliament, and let us call in the experts from the prisons. Let us call in the judiciary. Let us call in the Trinidad and Tobago Police Service and all of the other state agencies that are critical for the full operationalization of this bill, Mr. Speaker. Let us go to a joint select committee for a very short period of time, so that all of us sitting as legislators, as parliamentarians, members of Parliament, senators, independent senators, can examine those issues, so that when this bill is passed, we are almost certain that it can be fully implemented in Trinidad and Tobago. Mr. Speaker, it starts by an offender with a definition of someone who was convicted for an offense with a conviction term of 10 years or more, or life sentence. And that offender is received into the prison. After a specific period of time, Mr. Speaker, a rehabilitation needs assessment is conducted. The offender is approved to participate in a rehabilitation program by the Prisons Authority. And once he successfully completes this rehabilitation program, he is now eligible for parole based on the period as specified in this bill. The offender, he applies for parole, his rehabilitation is certified, and he now applies for parole. The legislation proceeds then to name a superintendent in the prison who prepares a case history on the prisoner. The superintendent of prison prepares a case history, a prison conduct report, and, listen, Mr. Speaker, a psychological and psychiatric evaluation of the prisoner. That is the process. So he must be convicted of an offense or a crime, 10 years and over. He has to participate in an approved rehabilitation program. And then, based on the amount of time that he served in the prison, he is deemed to be eligible for parole. And then the superintendent of prison, according to the bill, he then prepares a report. And that process includes a psychological and a psychiatric evaluation. Once that is done, Mr. Speaker, the application then proceeds to the parole board. Once it is constituted and appointed under the piece of legislation. Once the parole board receives the application for parole, according to the Act, a notice is then sent to the offender that the application has been received, and then a notice is sent to the Commissioner of Prisons, it is also sent to the Commissioner of Police, and all other interested parties, including the victim, that an application has been made to the parole board for parole by the offender. Mr. Speaker, if you go to clause, let me take you to clause 17 of the bill. And clause 17 of the bill talks about the board and the quorum of the board and disclosure of interests. And then, if you look at clause 20, it talks about parole for offenders, where the board then undertakes a comprehensive process to look at the application that was made by the offender. And it takes quite a lot of time. When the board receives the application, Mr. Speaker, it sets the matter for a full hearing. And the hearing can take a long period of time. But the bill makes a very interesting, there's a very interesting provision, clause 21, where it states that the board, clause 21, just forgive me, Mr. Speaker, that the board, having received an application for parole, can now invite witnesses, can now invite victims to participate in the proceedings. What I did not see in the bill is whether or not the notice to be issued by the board has the force of a witness summons in the court. So the board issues a notice to the victim, issues a notice to the parole officer, issues a notice and invite persons to participate in the proceedings. But the question that must be asked is that when those notices are received and invitations received from the board, do those notices and invitations have the force of law, where those persons must participate in the proceedings, Mr. Speaker? The board then determines whether the offender qualifies for parole. And if the board determines that the offender qualifies for parole in accordance with the bill, the board then considers the application. After, Mr. Speaker, the board considers the application, guess what happens after? The offender is still not entitled to parole if the board is of the view that the offender qualifies to be placed on parole. The board then forwards the matter to a court for further determination. So after a lengthy process, psychiatric test, psychological test, preparation of a case report by the prisons authority, referral of the matter to the board undertakes a further comprehensive investigation into the matter. And if the board determines that the offender is entitled and qualifies for parole, then the board refers the matter to a court, and a recommendation to the court for further determination. A court, according to Clause 21, a court shall have the authority to receive and consider the recommendations of the board for the grant of parole to an offender in accordance with the provisions of this Act. I'm pointing to Clause 21(1). 2. Where a court receives a recommendation under subsection 1, the court may, before ordering the grant of parole, require the board to provide any report or documents that it considers relevant as part of its consideration, and any person or witness who may have an interest in the outcome of the grant of parole to appear before the court to be examined. And the commissioner, meaning the Commissioner of Prisons, shall assign such number of suitably qualified and trained prison officers. I'll refer to that. I'll come back to that in a short while. So after a lengthy process, getting the matter to the parole board, then the board makes a recommendation to the court, and the court undertakes, Mr. Speaker, its further investigation to determine that. Mr. Speaker, the legislation did not say what precedent the court is going to give to these matters after such a lengthy process. And you don't expect the legislation to say that. But we are saying, Mr. Speaker, that we know what happens with matters before our courts. Not too long ago, we saw someone being released on murder, being placed on a murder charge since 2020. Took 5 years to get to this point. Not too long ago, Mr. Speaker, in this debate, I'm not getting out of the realm of this bill, is the point that I want to make. That persons who file notices to contest for traffic violations, they are getting court dates for 2031, Mr. Speaker. So when the court receives a report from the parole board, then at what point in time is that matter going to be determined by the court? Is it going to take 1 year? Is it going to take 2 years? It is going to take 3 years? Because the government, as the minister is saying, is depending on selling this piece of legislation as one that is critical for reducing prison overcrowding and all of the issues that are involved in prison overcrowding, including persons who commit crimes and conspire to commit crimes within our prisons, Mr. Speaker. And these are some of the operational issues that we must take into consideration when determining these matters. And it falls squarely to what we are recommending. Let us go briefly into a joint select committee. Let us understand whether or not the Prisons Authority is prepared to undertake the very serious responsibility of parole as is being envisaged in this piece of legislation, whether the court is also prepared, whether the Trinidad and Tobago Police Service, and if they are not, so that we can make a recommendation or recommendations that institutional strengthening and institutional overhaul where it is necessary so that these institutions can prepare, Mr. Speaker, for what we expect of this piece of legislation. Mr. Speaker, the court then determines whether or not the offender is placed on parole. And if the court considers the recommendation and grants either partial parole or refuse, and if it is granted, it could be temporary or work release parole, the offender then participates in employment, community service, personal development programs, and etc., etc. But, Mr. Speaker, I read out a very important clause, Clause 22, where the Commissioner shall assign such number of suitably qualified and trained prison officers to be parole officers as he sees fit for the purposes of this Act. Mr. Speaker, the question then, therefore, is what is expected of a parole officer when someone is granted parole? Let me take you to Clause 33. If the court decides to grant partial parole, a partial parole order made in respect of an offender shall require the offender to comply with the following conditions of release. The offender if he is granted parole by the courts, upon the recommendation of the parole board, he has to satisfy certain conditions of release. On release, immediately report in person to the designated parole officer. Who is the designated parole officer? A prison officer. What is the government, or what are we doing to ensure that prison officers who are deemed parole officers are properly trained, are properly educated to be able to undertake the critical functions as is being envisaged under this piece of legislation? He must immediately report in person to a designated parole officer, report to his parole officer as instructed by that officer, remain at all times in such area as is specified in the order, Mr. Speaker, obey the law and keep the peace at all times, as far as possible, refrain from associating with any person whom he ought to reasonably know to be involved in a crime, as soon as possible after his arrest for any subsequent offense, or after being questioned by the police, inform his parole officer of that occurrence. At all times have on his person a copy of the order and produce it upon request for identification to a police officer. Report to a police station if as instructed by his parole officer. Not own, possess, or have the control of any firearm, pepper spray, or other prohibited weapon. J, not possess or have the control of any tools or other implements except if and as authorized by his parole officer. K, remain free of dangerous drugs and alcohol, and shall subject himself to random testing for any dangerous drug and alcohol as directed by his parole officer. And KL, if on work release, shall observe the curfew of the community-based residence to which he is assigned. And upon returning to the community-based residence to which he is assigned, subject himself to such searches as may be necessary to promote the security, good order, and discipline at the community-based residence. Subclause 2. A partial parole order made in respect of an offender may require the offender to subject himself to electronic monitoring in accordance with the Administration of Justice Electronic Monitoring Act 2012, to refrain from associating with children, a victim of the offense for which the offender is sentenced, and any other person or class of persons as the court considers necessary, to comply with conditions relating to the finances or earnings of the offender, to participate in a rehabilitative or other type of program, to take, Mr. Speaker, very interesting, to take prescription medication that is prescribed by a medical practitioner, not to enter or refrain in specified places or areas at specified times or at all times, or to comply with such other conditions of release as the court considers necessary. Mr. Speaker, I took my time to read out the vast responsibilities being placed upon a parole officer who is a prison officer in accordance with this piece of legislation. And therein lies a key deficiency that I would like to red flag in this bill. Mr. Speaker, I have to be very careful in what I say, because let me say from the onset that I believe that the vast majority of law enforcement officials are law-abiding and they go about their daily responsibilities. Mr. Speaker, how much time do I have? Thank you. I'll take my additional time. Thank you very much, Mr. Speaker. I won't take that whole 15 minutes. But they have law-abiding, the vast majority of them, Trinidad and Tobago police officers, prison officers. Mr. Speaker, we do have in this country problems in our prisons service. As a matter of fact, Mr. Speaker, the main reason given for the calling of a state of emergency in Trinidad and Tobago is because of alleged criminal activity within the walls of our prisons. And even, Mr. Speaker, as this country continues to be under a state of emergency, we are told on almost a regular or weekly basis of preventative detention orders being issued for prison officers who are allegedly involved with criminal gangs. Even as we speak, Mr. Speaker, we have heard and continue to hear on a weekly basis of illegal activities where contrabands are placed within the walls of our prison and prison officers being identified, Mr. Speaker, for some of these criminal activities. And if the government is saying that it intends for the prison authority to play a central role in the administration and in the operationalization of this bill, I do hope that the Minister of Justice or the Attorney General, in responding to my contribution, can at least ease the concerns of members of the public and the opposition as to what is being done and what we are prepared to do to ensure that we prepare the prisons authority when this bill comes into play, that we do not have a continuation of illegal activities taking place within our prisons. Because if we do not do that, Mr. Speaker, this very serious matter, then parole is destined to fail. It will be garbage in and garbage out, Mr. Speaker. And the integrity of the system can be compromised from the very start, Mr. Speaker. You are depending upon a parole officer to play a critical role in the administration and in the implementation of this act. And therefore, it gives us an opportunity to work with the Prison Officers Association, to work with the managers and the executives of the Prisons Authority, to modernize the prison service and to weed out corruption from within the prisons, so that when this bill is passed and parole officers are appointed, that the very system of parole is not contaminated because of our refusal to treat with some of the issues within our prisons. And the same must be done, Mr. Speaker, for the Trinidad and Tobago Police Service. The same must be done in speaking with members of the judiciary, because those arms of the state are critical for the efficient and full implementation of this very critical piece of legislation. And if we do not do that, Mr. Speaker, then we will fall just as the Jamaicans are doing in struggling with the issue of parole, just as what is happening in South Africa, where their failure to address some of the institutional dysfunctions, like the prisons and the police, before implementing this critical piece of legislation, parole would have never worked because of failure to address some of these issues, Mr. Speaker. And therefore, I'm asking the Attorney General and the Minister of Justice, and by extension the government, to take on board some of the recommendations we are making on this matter. To have this bill examined by a joint select committee of the Parliament in the upper and lower house, so that we can examine the bill, examine some of the institutions to ensure that they are prepared for parole. Because if we do not take our time, Mr. Speaker, to do that, then I dare say parole may just be an example of a legislation passed by this Parliament that could not have been properly implemented, that would not have resulted in full integration of prisoners and convicted persons within our society, that would not have resulted in reducing prison overcrowding, and would not have the impact and the effect that we are boasting that it will have once this bill is passed in this House. I also want to take the opportunity, Mr. Speaker, to ask the Attorney General, to employ the Attorney General, that this is the House of Representatives. This House comprises elected members of Parliament. We are not squatters. We are not appointed, Mr. Speaker. Nobody sent us here to perform any favor for them. We are not trespassers, Mr. Speaker. We are elected by members of our constituency, and therefore we ought to be given the respect so that when we make recommendations, I'm seeing my colleague from Shugwanas East looking at me with with a degree of admiration, Mr. Speaker. There's a degree of admiration. And I know she's being enlightened by this contribution, Mr. Speaker. I hope she does have the ability to respond. Let the Attorney General sit down and let the Minister of Justice sit down. Respond to my contribution here. I know you can add some essence to what I'm saying here today.
Feelings are not as misguided oftentimes as
I
your
don't have
submissions.
misguided feelings, Mr. Speaker. But, Mr. Speaker, we are elected members. And I have and I take some level of objection to that when we make recommendations here, we are told, well, it can be taken up in the upper place. The senators are not elected. Elected people must be given the respect, and when we make recommendations, those recommendations must be taken as though for what it is, that we are empowered by our elected constituents, Mr. Speaker, who elected us, to represent their interests in the passage of laws, Mr. Speaker. And therefore, I have a serious concern when the Attorney General will say, well, yeah, you have a good point, but we will take it up in the Senate. No. If we have a good point, make the amendments here, because we are elected members of Parliament, and when it goes up to the Senate, they can do as they wish, Mr. Speaker, but we are the elected members, and the business of lawmaking is core to our function here in this Parliament. So we are not opposed to it. I would have gone through some of the operational issues, Mr. Speaker. If we are not cognizant of those operational issues, the bill will not come into effect in this country. I am asking the government to take on board some of the recommendations that we in the opposition would have made in this debate, have the matter referred to a joint select committee where we can even get unelected senators to come and participate in the lawmaking process, so that at the end of this session in the lower house, if it goes up to the Senate, it is passed in the Senate, we have a product that is highly likely to benefit the people of Trinidad and Tobago. So with these few words, Mr. Speaker, I wish to thank you for my opportunity to contribute in this debate.
Honorable Attorney General.
Mr. Speaker, I'm seldom at a loss for words, but I must confess that the last comment left me at a loss for words. And for this reason, the legislative process in a bicameral system allows for the participation of, and this is not John Jeremie write this. This is not the Attorney General write this. This is the Constitution framers. And I would have thought that it was Constitutional Law 101. For those of us who went to university, that is our first year course. I would have thought that it was Constitutional Law 101, that laws are not passed until it's bicameral, not unicameral, okay? So laws are not passed until the elected, to use the accent and the intonation of my colleague from Aruka Lopino, has his say and the other house, the other place that our Constitution framers decided was integral to our governance, had their say. In the interest of time, if certain recommendations are made in one house or the other, because it happens in the other place as well. But my friends on the other side have discovered a new industry, and that industry is to propagate amendments. And more than that, it is to propagate solutions which always boil down to one thing. Refer this bill to the Joint Select Committee. I have said before in this place and in the other place that the Joint Select Committee is often a place where legislation goes to die. Now, I want to tell my friend from Aruka, Lopino, that this legislation is not going to a joint select. The legislation is going to be passed in this House today, and it is going to be enacted. It may be passed with amendments. Those amendments will be taken in the other place, as it is constitutionally proper. Now, having said that, I want to turn to another comment that was made, and that I want to drill down on that Joint Select Committee comment. Now, it's often said that facts are stubborn things. Now, these are some stubborn facts, colleagues. This bill was actually prepared in the year 2021. Guess who was in office in 2021? My friends on the other side who have gone silent all of a sudden, mumbling among themselves. They are responsible for the legislation. That's point one. That is stubborn fact one. Stubborn fact two. That bill that was prepared in 2021 had 27 clauses. Colleagues, look at the bill in front of you today. How many clauses do we see? 27 clauses. You know what was done between their bill and our bill? We made it better. We kept, well, we have to because we are better people. We made it better, and we cleaned up the drafting, we rearranged some clauses, and essentially the structure of the bill is what is before us today. What was good for the goose in 2021, we say may not have been good for us today, but something is better. Something that is better is before us today. Now, Mr. Speaker, I want to frame my contribution today within the context of second chances, because that is what this bill is about. And that lies in a belief that is not inconsistent with absolute force, because absolute force is what this government has brought to bear against the criminal elements. More on that in a while. You see, colleagues, this country right now is at war. No borders have been crossed, to use the words of Kennedy, and there are no marching troops. But we have declared a state of emergency. We have renewed that state of emergency, and we have declared a state of emergency again. That is our declaration of war. Mr. Speaker, it's been said that the purpose of all war is, in fact, peace. We seek peace. Peace across the length and breadth of this country. In every village, town, and city, and in every neighborhood. Even as we wage what Augustine described to be a war of necessity, a just war that is aimed at securing a lasting peace for all of our citizens, we say clearly that we are not prepared to descend into the anarchy that characterized their dying days in office. We are not to be prepared to do that. Ours is not a one-dimensional approach to the war against gangs and the criminal elements. They know, as much as they pretend not to know, that by now our targets in this war are gangs, criminal enterprises. And those gangs, I agree with my colleague from Toko Sandigrandi, are sometimes located in Bella Road, Serrano Road, and so on, where he and I have roots. And the member for Port of Spain North, St. Anne's West has none. But it should come as no surprise to them, because they know this. They know this, that the gangs are also located in West Moorings, in Goodwood Park, and in some of the other places. I would not say who are the representatives for those areas. But what I would say is this. And those who wish to send copies of Hansard to the Commissioner of Police, he got his yesterday. He was supposed to get it since last week. He got it yesterday from our sitting whenever. This is what I'm going to say now. I am authorized by the Commissioner of Police to say that last Friday, a member of one of those gangs in that community sparked a national security incident such that all of us in this parliament were protected to a higher degree, and certain officials in the government were given additional protection. I am authorized by the Commissioner of Police. Don't worry to send Hansard to him. I spoke to him and he said I could see that. Now, as in every war, Mr. Speaker, we will have bad days. And quite recently, we have had, in fact, a couple truly terrible days. Days in which we saw the murder of innocent children, a 9-year-old girl, a 2-year-old baby. We grieve with these families. And we grieve with all of the families who experience inexplicable loss of loved ones in this community. For us, every innocent life loss is a tremendous loss. They are not just statistics, not rhetoric. They are valuable children of God for whom we mourn. But because of this, we see as our job the attainment of peace. But it has to be peace through war. They have left us no alternative. And it has to be peace for the benefit of all law-abiding citizens. We will not be deterred from our mission. The bill before us seeks parole, as many of my colleagues have been at pains to point out, as a way forward to avoid repeat offenders, recidivism. It is a critical part of any developed justice system. The country cannot wait any longer. It waited between 2021 and 2026. This is 2026. We are passing this law today. It is not going to a joint select committee to die.
Whilst you have this lull in your presentation, can I just acknowledge the presence of students of the Rio Claro East Secondary School? Honorable Attorney General, you continue.
Mr. Speaker, I said at the beginning that facts are stubborn things. And some historical facts are more than stubborn, they are immutable. It is a historical fact, and I am speaking now, I'm joining the debate, and I am speaking after attacks were leveled against my colleague, the member for Tokosa and the Grande. It is a historical fact that what he said, that the member for Port of Spain North St. Anne's West was Minister of National Security for just about 3 years under the PNM, 2018 to 2021. That's fact number one. It's a historical fact that for 2 of those years, 2020 and 2021, this country was under lockdown due to the pandemic, and their governments, I would say, psychotic approaches, which saw people locked out of the country for close to a year, in some cases more, locked in their homes, losing family members who were cremated, they could not have anything to do with their sending off, losing their homes, their properties. We lived in isolation and under curfews. But you know what didn't subside in their state of emergency? With the curfew they had, with the lockdown that they had, with sending people home and telling them, do not leave your houses. Crime. Under those conditions, even under those conditions, the member was unable to bring the murder rate down to any significant degree. 517 murders in 2018, that was before. 539 in 2019, when the pandemic was just beginning. 403 in, I know what I'm talking about, you know. You might not understand what I know, but I know what I'm talking about. 539 in 2019, when the pandemic was just beginning. 403 in 2020, with all of the lockdowns in place, curfews, a jump to 452 in 2021, while still under those conditions. Well, all of that paved the way for a leap in 2022 to 605. That is a fact. Facts are stubborn things. Mr. Speaker, based on those statistics, under his tenure, the conditions were favorable for the breeding of gang-related crime and criminality that not only persisted, they bloomed as soon as the restrictions were lifted. And that is what my friend and colleague, the member for Toko Sandy Grande, was alluding to. So I'm not dealing with the nasty insults about how he looks or whatever. As far as I'm concerned, he's no different from me. He looks like me. Let me go no further than that. Okay? There are some people who are not one of us. That's all that I see. But apart from the insults, even worse is the fact that the member for Port of Spain was a member of the National Security Council, and the government that saw the record high for murders in Trinidad and Tobago's history, 626 in 2024. These were the hallmarks of his tenure and his involvement in national security. They are the medal which will forever hang like an albatross around his neck. I say it, the member for Toko Sandy Grande said it. He said more about Bella Road, and I'm coming to that because he's entitled to speak to Bella Road and Serrano Lee. So his is a legacy of failure, a legacy of bloodshed, a legacy of empty promises and hollow rhetoric. He can come here and shout as much as he wishes to. That is his legacy. When my colleague from Toko Sandy Grande said on Friday, much to the chagrin of the member, that he was the worst minister of national security, that was an inference to be drawn from the stubborn facts. The only debate on it was whether his successor, the sleeper, was in fact the absolute worst. That's a debate. So I don't think I could be taken to Privileges Committee for that, but I'm happy to go. Well, Mr. Speaker, these are not my words alone, you know. Those are words that I am speaking in the Parliament of Trinidad and Tobago today. Those are not my words alone. I read from an article an opinion piece published on May the 10th, 2 days ago, in the Trinidad Express. The Trinidad Express. We know that they are not our friends. But hear what they have to say in their opinion piece. And the title is Political Amnesia Again. This is what the author says, and I quote, "One wonders that former Prime Minister," to which I add for thee, former Minister of National Security, former Minister of Communications, former Minister in the Ministry of the Attorney General and Legal Affairs, and former Minister of Energy and Energy Industries has for breakfast. Now, those are their words. I don't care, I don't wonder. They go on, and I quote, "He seems to have conveniently forgotten that under a PNM government, of which he was a key member," well, we know he was Gary Sobers, "we had what many critics consider to be," this is the Express, I'm quoting from the Express, "one of the worst ministers of national security in the history of the country." Those are the words of the Trinidad Express, not my words, the words of the Trinidad Express. Now, the author goes on to say that, repeat what I said. "Under that Minister of National Security, Trinidad and Tobago saw its high ever murder toll over 6/20/2024. Now, I'm not sure it was him they're referring to. In fairness, it may have been Sleepy Joe. That minister in February 2022 was quoted as saying the infamous words. This is, I know, the sleepy one. "My duty is not to ensure that people feel safe and secure." That's Express, February 2022. But I want to tell them something. This Prime Minister sees it differently. She thinks that it is her core responsibility and the core responsibility of this government to ensure that the people of Trinidad and Tobago feel safer and secure. It is a hallmark of her existence, a pillar of her political platform, why she is here, and what we are committed to do. But I want to go back to the Express, because the author goes on. I don't know what the author had with him. I know it wasn't my friend from Toko Sandy Grande. And of course not me, I wouldn't be involved in this kind of thing. The author goes on to ask, "Do you remember that, Mr. Stuart Young? Do you remember when the 4 Peterkin siblings were killed in September 2023? Is this the author speaking? During the tenure of your PNM government, do you remember that your Minister of National Security refused to resign despite public calls for him to do so?" Yes, there's a quotation mark. And the author concludes with some sage advice to the member, which he would do well to follow. He says, "Mr. Young should follow the advice of the elderly about putting brain in gear before putting mouth in motion." take it up with the Trinidad Express. Now, here are some more facts, Mr. Speaker. We have been in office for a year and some days. And during that time, the murder rate went from the record high of 626 just a few months before them to 370 in 2025 under us. It is a historical fact, therefore, that the member for Toko Sangre Grande, along with the Minister of Homeland Security and this government, has had demonstrable success in the war against gangs, some of whom, as I see, are their friends. Our battle will not be won in a single day. Since 2015, when those opposite took office, the rate of gang-related crime has skyrocketed consistently for a decade. The foundations that underpin the institutional crime in this country cannot be dismantled overnight. We will continue undeterred in our mission to take those foundations apart. Parole is an essential part of our strategic initiatives, and we will pass this legislation, as I have said, today. Now, the Member of Parliament for Toko Sangre Grande, as he says, and I'm making a complete defense of the member. He grew up in Serrano Road and Bella Road. This is not a backdrop for political gimmick, walking in a cap and a red sneakers at certain time of the year. It is a street on which, Bella Road is a street on which the Constantines, related to the Constantine family, the Clarks, related to the Clarks family, the Crosses, related to the Cross family.
Do you want your 15 minutes? You're almost at it.
Yes, thank you. Mrs. Once lived and tried. Mrs. Cross took care of me when my parents were at work as a child, when I was in primary school. I know. It is a place where Keith Shepard, the journalist, and the Simons called home. They don't know that. They visit it. They don't sleep there. The member for Toko Sangre Grande slept. He lived there. He knows what it is like to be a citizen of Bella Road, as I do. No red sneakers and red cap and red jersey could make you a citizen of Bella Road or Serrano Road. They allowed guns, drugs, and disenfranchised youth to roam freely, destroying our community, and we are now reaping that whirlwind. But you know what? We are determined to fix the problem. And we fix the problem by creating a proper justice system in part, and by creating proper means of engaging youth in that area. They are not props, like if they are some sort of Potemkin village. They are not props to be put up at election time. They are real people. I have aunts and uncles still living there, as the minister has aunts and uncles still living there. With those few words, Mr. Speaker, I take my seat.
Honorable Minister of Justice.
Mr. Speaker, to take off, thank you for the opportunity, and to take off where the Honorable Attorney General has left. Our country, Mr. Speaker, he has indicated, and we all know what is the state of play in this country with regard to crime. And we are taking steps, multi-pronged approach to solving this problem in this country, Mr. Speaker. I want to go a little further from what the Attorney General, from where he left off, as to the history of this bill. My learned friends are asking for this matter to be sent to a joint select committee. Mr. Speaker, I want to read out into the Hansard the bodies and institutions that we have reached out to before we came to this bill. We sent a list, we sent the bill, received submissions from the Trinidad and Tobago Police Service, the Law Association of Trinidad and Tobago, the Vision on Mission, the Criminal Bar Association, the Trinidad and Tobago Prison Service. And I want to pause there for a while because a lot of talk from Port of Spain South, Port of Spain North, Lupino on the prison service, saying they are not resourced, they don't have sufficient technical knowledge, they don't have enough persons. Mr. Speaker, we took into account all their submissions and all their contributions before we came to this bill. I don't know if I'm speaking out of turn, but my good friend and colleague, Minister of Homeland Security, the very efficient and hard-working Minister of Homeland Security, who answers all his questions correctly and properly. Within a few months, Mr. Speaker, the prison service is going to enlist, how many? 800 new prison officers in it. You're talking about resource? Young people coming with talent will be properly trained. 800. This is what this government is doing in this country, Mr. Speaker. We are not leaving the prison service to flounder. We are not leaving the police service to flounder. At every step of the way, we are supporting them and giving them resources. Mr. Speaker, we also got submissions from the Public Defender's Department, the Ministry, the Judiciary, because there's a lot of talk on the other side about the judiciary not knowing what is going on. They will have a lot of cases, what they will do. The judiciary submitted a very long and detailed submission, Mr. Speaker. A very long, I have it before me, in response to the queries. And they have indicated in no uncertain terms, Mr. Speaker, their support for this legislation. They've indicated that rehabilitation is central to the modern penal reform efforts, and parole reform often focus on providing offenders with the opportunity to rehabilitate while still under supervision. They talked about managing reliance on incarceration. They talk of the whole of sector collaboration. The judiciary talked to us. They talked about the whole of justice sector approach involving integrating prison services, probation, parole, mental health support, and community service. We engaged everyone, Mr. Speaker. We also engaged the Director of Public Prosecutions, the Assembly of Southern Lawyers, and the Tobago Law Association. Some didn't submit. Most of them gave their submissions. And here we are today with a bill, as indicated by the Honorable Attorney General, that moved from 27 clauses. Look how many clauses. We expanded, we consulted. And you want us to go now to a joint select committee for what purpose? It is not going to serve any useful purpose. But I'll go a little step further, Mr. Speaker. The question of parole, Mr. Speaker, didn't start in 2021, Mr. Speaker. The question of parole in this country was started to be considered since 2001. There was a task force report created 2004, adopted by the government in 2007. When the People's Partnership was in office, we created a bill in 2011. Since 2001, and we're in 2026, some 25 years, the parole bill has been developed. We come to Parliament, we consult everybody, and you're telling us now, Senator, a joint select committee after 20 years, 25 years? Mr. Speaker, I ask them to withdraw that submission with respect. They should withdraw that submission. This bill had a slow, long process for 25 years. The concept of parole. Because, Mr. Speaker, since 2001, enlightened people in the society who prepared that task force report were saying that punishment is not the only way to go to solve crime. You have to have punishment, you must have deterrence, you must have rehabilitation, you must have reform, you must have engagement for public safety, and all of these thoughts were there. We are here, brothers and sisters, colleagues, with a bill that is going to transform the criminal justice system. It is going to keep us in tandem with modern thoughts on penal reform and how to fix prison. And it doesn't come alone, Mr. Speaker. We had a reform of the Probation Act recently. We have this, we have the Victim Rights Bill that is in the Senate. So there's a whole menu of legislation that we are bringing to the Parliament to help change the criminal reform system, because we were left in a very bad state. And in 1 year, we have done all of this, Mr. Speaker. 22 pieces of legislation, 19 assented to, and this is going to be the 23rd, Mr. Speaker. Mr. Speaker, one of the points raised by my colleague from Port of Spain South, he was saying that Clause 24 in the bill undermines judicial discretion. The parole board, by giving its decision, undermines judicial discretion. But I'm sure if he read the full bill before him, he would know that cannot be a proper statement. Why? Because after the parole board makes a recommendation, Mr. Speaker, it goes back to a court. So if it goes back to a court, and a court is reviewing everything and all the evidence, and the court has the capacity to ask for new information, how that could undermine judicial discretion? That certainly wasn't a submission that was well thought out. And Mr. Speaker, that is another submission I will ask them to kindly withdraw. Mr. Speaker, a big point that was raised by Port of Spain South and I think also by Port of Spain North, and I'm just trying to get the exact wording of what was said. And Mr. Speaker, it was basically on the question of victims. They were saying that the victims is not at the center of the process. He said that the bill nods. This is what the word he said. It nods. And it is a perfunctory nod to victim. A perfunctory nod to a victim. What is a perfunctory nod to a victim? It means that you're tipping your head, you're just giving it a pass, but you're not taking into consideration the fullness of a victim under this bill. Mr. Speaker, obviously, and I want to make the point, obviously that submission was made without proper consideration of the bill at hand. Because I'll tell you, Mr. Speaker, at every stage in this bill, victims are given prominence. Let us start with section 26.1, Mr. Speaker. I'll just take you quickly through. 26.1 of this bill, and I will read. Subject to subsection 2, the board shall, upon receipt of an application for an offender for partial parole, fix the date, time, and place for the partial parole hearing of applicant, and shall give at least 30 days written notice of such date, time, and place to A, offender, B, the commissioner, C, Commissioner of Police, D. Look what he said in the notice to D. The victims of the offense committed by the offender or such relatives of the victim as the board thinks fit.
Yeah, read the bill.
I mean, you ain't perfunctory nod. The parole board invited everyone, and the victims, he said, come forward. Come forward. I take you to 27, 1C, Mr. Speaker. The board at the partial parole hearing of the offender shall hear any oral submissions made by the offender or any other person appearing before it. The victim is given a chance to speak. Not only speaking to the board, the offender is right there. He's telling the offender, what you did really hurt me. You should not have done that. The offender will be talking back to him, boss, I was grunting, I make a thief, I beg your forgiveness. There's conversation going on at the parole board. What is that? Not healing? That's not restorative justice. Parties are coming to go together to exchange their views as to what happened. But let's go a little further, Mr. Speaker. I take you to section 33.2. Under section 33.2, Mr. Speaker, let's see if we get that quickly here. 33.2. When the parole board is making an order, a parole order, partial parole order made in respect of an offender shall require or may require the offender to refrain from associating with the victim of the offense for which the offender is sentenced. So you're making a parole order, you're stepping outside and you say, hey, you heard the victim, you heard his relative, you shall not go within half a mile. You shall not interact with the victim. Or they may say, you can't interact with the victim. How is the victim being given a perfunctory nod? Mr. Speaker, 34.5. I don't want to read everything, but more importantly, I want to take you to section 40 of the Act, Mr. Speaker. 40. Of proceedings before the board. A person can apply for hearing of the board and shall not be granted permission to do so where, in the opinion of the board, the presence of the person is likely to adversely affect those who have provided information to the board, including victims, relatives of the victims, or members of the victim's family. And most importantly, 47, Mr. Speaker, victims or the relatives of victims shall be entitled. This is the parole board. Perfunctory, not, Victims or the relatives of victims shall be entitled, A, to appear at hearings of the board and to make oral or written submissions on the parole of an offender. And this may be done in the presence of the offender or in his absence. Where in these provisions can this be interpreted to be a perfunctory nod? Or you're not paying attention to the victims? You can appear, you can make your submissions, you can talk. They can make also written submissions, Mr. Speaker, by way of an affidavit where they choose not to attend a hearing for parole, because sometimes a crime is so rough that you don't want to relive the experience. You don't want to see the man who committed the offense, who may have hurt and injured you or your family. So you don't want to come in person. The bill is allowing you to make written submissions by affidavit to the parole board. We have taken the care and opportunity, Mr. Speaker, to ensure all sectors of the criminal justice actors are taken care of in this bill. And to ensure that when this bill is passed, Mr. Speaker, everyone is served, the whole of society is served. Now, Mr. Speaker, that deals with that question on the issue of victims. Then there's the whole question of somehow this parole board does its business in secret and in camera. Mr. Speaker, when the Mercy Committee sits, according to Section 87 of the Constitution, it is done in camera. It is not done in full glare of the public. And the Mercy Committee sits, you have a constitutional provision. You have the DPP, the AG, the chairman. You have 4 persons selected by the president sitting on the Mercy Committee, Mr. Speaker. And you make decisions. And after these decisions are made, you send it to the president and it's enforced. What is the thing about you having it in secret? And furthermore, it is even not in secret because after the decision made, it goes back to the court. Where's the secrecy? The court hearing is in full public, and you can get information. There's no secrecy at all. I don't know why this is being sold to the public, that somehow this is some cabal, done in secret, nobody knows what's going on, it has no judicial discretion, all of which completely untrue, Mr. Speaker. What's that?
That's how PNMs operate, so they feel we're doing the same thing.
In a moment of silence.
Can't defend that, you know.
Mr. Speaker, there are numerous other points that are raised by my friend, which I don't think are essentially very substantial. There was a case raised by my friend about Farfan and his state, Aaron Howells. It undermines judicial sentencing discretion. I have read that case. Our people have read the case over and over. I can't find anything in that case that has any relevance to what is before us. There was an argument that The bill sets up parole for people who have 10 years and over, but it should be for smaller sentences. Mr. Speaker, there's the question of the remission. So how it works is, if you are sentenced for 1 year and you go to prison, as soon as you go in, the officer in charge calls you and said, this is for a year. Under remission, if you behave good, you're going to get half a year off. You're going to spend only 6 months in prison. If it's more than a year, you will get 1/3 of your sentence off if you behave well and there's industry. You perform well, you show that you're willing to change, you get 1/3 off. So there's a question of remission. It's already built into the system. What the parole bill is giving you now, Mr. Speaker, is an added impetus. So if you have 10 years and you go in, as soon as you get in, the prison officer calls you and says, listen, under this parole bill, 10 years, you can get partial parole after 2.5 years. Partial parole. After you spend quarter of your sentence. But here we're going on. For you to get partial parole, these are the things you have to fulfill. You have to change. You have to go to rehab programs. You have to say that you are sorry. We have to show that you are sorry. You make an application, and after 2.5 years, you are given a chance for partial parole to come off. In the current system of remission, you do not have any rehabilitative exercises or programs inside. The prison authorities wrote to the Ministry of National Security since 2019 saying the remission thing not working. The prisoners and them fooling us. They are masking their intentions. They're saying they're good, but they're really changing. And there was no system of evaluation and monitoring of that process. So therefore, you had a revolving door. You had 58% recidivism, repeat offending. They're going out and they're coming back inside. Under this system that we are putting into place, Mr. Speaker, we are monitoring you, we are evaluating you, and you have to show development. We are going to have psychiatric, psychometric testing, psychological testing on you, so that the best chance we have of rehabilitating you will be in place. And that is for partial parole. Real parole, half your sentence. After 5 years, you are getting to come out. So under those circumstances, the system is not foolproof, and I appreciate what Aruka Lopino said. Worldwide, there are problems with parole, but this is the best system that we can try. We have to put our best foot forward. This is 25 years in waiting. The time has come. The Honorable Prime Minister has given us a task, criminal justice reform, and we are on the ball. If there are problems, Mr. Speaker, as we are certain there will be problems, we will have to deal with it when the time comes. My friend made a submission from Port of Spain, so there is no provision within the Act that says where the money is going to come from, how it's going to be spent. Which Act provides that? Which Act tells you where you're going to find the money and where you're going to spend it? If there is a request by the prison system that says this is parole, we need X amount of dollars, we make an application to the Ministry of Finance and we get it and we put the provisions in place. It is, Mr. Speaker, really and truly the best system that we can find. As we stand at the close of this debate, Mr. Speaker, we are not merely deciding on the passage of a bill, we are deciding on the kind of society we choose to be. The legislation before us does something profoundly simple, yet profoundly transformative. It refuses to accept that a prison sentence ends where hope ends. It insists that rehabilitation is not an abstract ideal, but a practical pathway. one that equips individuals with skills, structure, accountability, and dignity so that when they return to society, they return changed. Without rehabilitation, and Mr. Speaker, without rehabilitation, I have went through the last occasion, a penal reform and transformative unit at the Ministry of National Security was almost disbanded. There was one person there doing project management work. All the rehabilitation in the prison was done by NGOs, and the poor prison officers just had to supervise and manage. There was no central rehabilitation system. There was no monitoring and evaluating. There was no modern rehabilitation programs being brought in and monitored. We had no experts coming in and telling the prison authorities, this is what is happening in Sweden, this is what is happening in Denmark, this is where it is producing results. It was left, the rehabilitation efforts was left in the hands of the prison officers. They did a tremendous work. But they said, we need resources, we need help. This was not there. So, Mr. Speaker, without rehabilitation, release becomes a revolving door. We see it in numbers, yes. However, more importantly, we see it in communities that bear the weight of repeat offending and in families caught in cycles that feel unbreakable. Recidivism is not a correctional statistic. It is a societal failure loop. Mr. Speaker, justice system is measured not by how it punishes wrongdoing, but by whether it succeeds in preventing its return. If we are serious about breaking cycles of crime, then we must also be serious about creating pathways to do so. This bill is one such pathway. Let us seize this historic moment to build safer, stronger, and more resilient communities for all our citizens. I urge this chamber to stand united in support of this landmark legislation. I so beg to move.
Honourable members, the question is that a bill entitled An Act to Provide for a System of Parole and Related Matters be now read a second time. Those in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Provide for a System of Parole and Related Matters.
Honourable Minister of Justice.
Just looking for the procedure. Yes, Mr. Speaker. On the 68-1, sorry, I got it here, Mr. Speaker. Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Parole Bill 2026 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Parole Bill 2026 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Any against? The ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause. Yeah. Make sure that observant in your submissions. I think you're ready. Ready? Keisha?
Yeah. Clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
Miss.
Okay. The question is that clause 3 now stand part of the bill. Honourable Minister of Justice.
Mr. Chairman, the opposition, I just want to address the amendments proposed by the opposition en masse. We have submitted, Mr. Chairman, what we consider to be very important and substantial amendments. We have heard the utterances from the mouth of the Honourable Attorney General, which in our view causes us some dismay because it is, in our view, a total disregard for the elected members and this process that we're engaged in. But we do not intend to waste the time of this Parliament by advancing this when we have already heard that there'll be no. So we are putting it on the record that these are our amendments, and we are putting it on record that these are our amendments, Mr. Speaker. We have understood the position taken by the government, and we do not. And Mr. Speaker,
perhaps there might be the need for some clarification.
Yes, Mr. Speaker.
I think early on there was an original list of amendments circulated which purported to come from the Honourable Minister of Justice. We are now advised that that extensive list has been withdrawn. The only proposed amendment which purports to come from the Honourable Minister is an amendment to Clause 42. What has been sought, I'd be very grateful if I could perhaps have your attention
yes,
for a minute
please,
or two.
You have my undivided attention.
Very grateful, thank you. So it might make the exercise, we might truncate the exercise and make it slightly more productive. So the proposed amendments...
Mr. Speaker, I think it is necessary for the benefit of the listening public that we go through the proposed amendments clause by clause so the opposition can explain the rationale behind each one.
Yeah, all right. If you didn't preempt me, that is what I was proposing to do.
Yes.
As prescient as ever. Well, I'm happy you're not elevating yourself to that level. All right, let's move on. All right, so insofar as the circulated amendments emanating from the Honourable Minister is concerned, we have one which proposes at 42. I am to take it that your proposed amendments remain as circulated from May 8.
Yes, Mr.
And those proposed amendments are confined to 16, 19, 20, 21, 22, 23. I'm saying this for ease of reference so we can move through the collective clauses of the bill which do not require further elucidation.
Agreed.
So that we can save some time.
Agreed.
23, 39, 40, 42, 55, and you propose a new clause at 60.
Yes.
Right? And that's confined. So if the very efficient clerk, we could rearrange how we do things now, and we can move fairly quickly along. Okay. So that having been withdrawn, we can perhaps now take collectively clauses 1 to 15.
Well, 3, we did 1 and 2. Right?
We did 1 and 2, so can we go now to 4 to 15?
3.
3 to 15, thank you.
Clauses 3 to 15.
The question is that clauses 3 to 15 stand part of the bill. The question is that clauses 3 to 15 now stand part of the bill. Those in favor say aye. Any against? The ayes have it. Clauses 3 to 15 now stand part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. Port of Spain South.
Thank you, Mr. Chairman. Mr. Chairman, it is the submission of the opposition that at clause 16 subsection 1 be amended and a new subsection 1 be substituted and read as follows. No action shall lie against a member of the board, a parole officer, or any person acting under this act for acts done in good faith in the execution of their functions. However, such immunity shall not extend to acts of gross negligence, willful misconduct, bad faith, or abuse of power. Mr. Chairman, the rationale for this amendment, or this suggested amendment, is that it will clothe the members from liability only in circumstances that does not involve gross negligence, willful misconduct, bad faith, or abuse of power, instead of a carte blanche coverage from immunity.
Honorable Attorney General, Honorable Minister.
We thank the member for the space. So the proposed amendment is rejected. The standard clause reads as it does in the bill, and it does precisely that in respect of good faith, requiring the threshold to be good faith. That is our view, and that is our policy.
Okay, Port of Spain South, you've heard the position, right? I propose to put the question.
Yes, Mr. Chairman, I do.
All right, the question is that clause 16 be amended as circulated. Those in favor say aye. No. No. I think we all accept that that was an error. Come on. All right.
Chairman.
All right. Let's, it's lunchtime. Let's stop the pointless posturing. Let's put the question now. The question is that clause 16 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. All right, the noes have it. 17 and 18. The question is that clause 16 now stand part of the bill. Those in favor say aye. Any against? I think the ayes have it. Clause 16 now stands part of the bill.
Clauses 17 and 18.
The question is that clauses 17 and 18 stand part of the bill. The question is that clauses 17 and 18 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clauses 17 and 18 now stand part of the bill.
Clause 19.
question is that Clause 19 stand part of the bill.
Mr. Chairman, we have recommended that there be an amendment to Clause 19, subsection 1, and that paragraph 5 be deleted and substituted with a paragraph that reads that it should require the carrying out of standardized and evidence-based risk assessment and risk management activities subject to multi-tiered professional review by appropriately qualified personnel. The rationale for that amendment is because Clause 19(1)(f), as it reads now, just stipulates that it requires the carrying out of risk assessment and risk management activities in relation to an offender and does not specify, in keeping with international practice, that there are multi-tiered professional review things that can be done by appropriately qualified personnel in relation to the offender, and we would like that to be made pellucidly clear in the bill.
Honorable Attorney General, Honorable Minister.
Thank the member for participating. So the amendment is rejected. We think that the words capture the policy of the Act. We do not know of, have not seen any such international benchmarks. We think that the suggested substitution is too granular and would require a number of amendments to the Act. It's rejected.
All right, I propose to put the question. The question is that Clause 19 be amended as circulated. Those in favor say aye. Aye. Those against say no. All right, the noes have it. All right, the question is that Clause 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 19 now stands part of the bill.
Clause 20.
The question is that Clause 20 stand part of the bill.
Mr. Chairman, the amendment to Clause 20 requires, in our view, that the period as it relates for the eligibility for parole be extended to persons serving smaller sentences, that is, sentences less than 10 years. That would be in keeping with the philosophy that we would want to have persons convicted out of prison, particularly those who have gone in not hardened and not are more susceptible, and they would benefit from an early release because their crime is not as egregious as others, and that has not been considered by the draftsman in this legislation. Consequently, we propose the amendment as follows: that eligibility for parole shall extend to offenders serving sentences exceeding 2 years, subject to the statutory risk assessment and compliance with rehabilitative requirements. And the next, subsection 3, the Act shall contain a schedule specifying offences and categories of offences to which parole eligibility applies. And the schedule may distinguish between offences eligible for ordinary parole consideration and offences requiring enhanced judicial scrutiny or additional statutory safeguards. Mr. Speaker, that second amendment puts some clarity to offences that can be considered serious enough that consideration ought to be given for enhanced judicial scrutiny, and separating those which are not so serious, and there may be even some offenses that may be considered not at all akin to parole, and the government may want to consider putting a schedule of offences that attracts the possibility of parole. And that is the rationale for this amendment.
Honorable Attorney General.
We thank the member for Port of Spain South for useful amendment. If I was to take subclause 3 first, the idea of a schedule is not offensive. Of course, there's no schedule here, so that's not before us. The idea is not properly fleshed out, so we have to reject that. And in respect of subclause 2, we just want to point out that remission is available to all inmates. If I could just say, at the risk of incurring the wrath of my colleague from Aruka, Lopino, this is a matter that I believe that we will look at in the other place. Have we been there before? No. Right.
I heard what he said. He said this could be dealt in the other place. Talking soft. May I? Mr. Chairman, may I intervene? Am I allowed to intervene? When one looks at the practice in the Caribbean and other Commonwealth countries, 10 years seems a bit extreme. Is the Attorney General saying that he is going to give consideration to reducing the period of time, as is the practice in many other countries?
Well, the present position is that remission is available to all inmates.
I'm talking about in accordance with this legislation, because this limits it in the context of this legislation.
We will look at it. So I'm not making a commitment.
I'm not asking you to commit anything. I'm just asking,
and that's precisely
in the context of what's happening in the Caribbean.
Another house. It gives us the opportunity to reflect on these matters, some of which we don't pretend to be.
There's no need for you all to be so rude. We're discussing something serious here. They don't understand it anyway. Thank you, Attorney General. You've made your position clear.
No. My colleagues are having an important discussion. It is just that they were.
Okay, I propose to put the question. The question is that clause 20 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. All right. Honourable members, the question is that clause 20 stand part of the bill. Those now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 20 now stands part of the bill.
Clause 21.
Question is that clause 21 stand part of the bill.
Mr. Chairman, the proposal here is a reinforcement proposal, really, because what this does is to leave it open for some doubt to exist relative to the parole board and its vires. We understand that judicial review will lie to someone who may be adversely affected, but that is not included in the legislation. So the person will have to go to court for a court to validate that right. Yes, Mr. Speaker, because it is not here, so there will be, it's not here, a parole board may decide that it is acting in a certain manner that will require that person to have recourse to the court. If we include 21.3, a new 21.3, it removes any doubt that the judicial authority remains supreme in matters affecting liberty, and therefore the parole board will have a guidance in the legislation that would let it know that it is subject to judicial authority. In those circumstances, Mr. Chairman, we recommend that a new clause 21 subsection 3 be inserted and reads as follows. for the avoidance of doubt, judicial authority shall remain supreme in matters affecting liberty, and any decision of the board shall remain subject to review, confirmation, or oversight by the court in accordance with this act. We reiterate that we understand that a person will have the normal common law right for judicial review. However, if it's included in the legislation, it will remove any doubt and may obviate the need for judicial action. That is the rationale for this suggestion.
Honorable Attorney General.
Chair, again, we recognize the suggestion of the member, but he premised his suggestion by using the words for the avoidance of doubt, which we think does not exist in the draft that is before the House, so that unfortunately we have to reject this proposal outright. But with respect.
Okay. The question is that clause 21 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. Noes have it. The question is that clause 21 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 21 now stands part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. For the Spain South.
Mr. Chairman, the suggestion here relates to the augmentation and beefing up of a parole officer. As it stands now, the commissioner shall assign such number of suitable, qualified, and trained prison officers to be parole officers as he sees fit for the purposes of this act. It makes no provision, Mr. Speaker, for such an, Mr. Chairman, for such an important person to have the qualifications, or it does not stipulate what qualifications such a person could have, save and except a prison officer and what qualifications goes with that. We are suggesting, in order to give this teeth and in order to give the parole officer to have a suitably qualified parole officer doing a very critical job and performing a very crucial function, that we include a clause that says a parole officer shall possess qualifications in social work, psychology, criminology, behavioral science, or a related discipline, and shall be subject to statutory certification and continuing professional training requirements prescribed by the regulations. Mr. Chairman, this ensures that suitably qualified persons, other than those assigned by the Commissioner of Prisons, are made parole officers in a very significant activity that will affect either the continued incarceration of offenders or the early release. We think it's important enough to be granular and to have these persons certified, and that is put within the legislation. And that is the reason for our proposed amendment.
Honorable Attorney General, on the proposed amendment to clause 22.
Chair, with respect, it's not accepted. We prefer the existing definition. We think that the job descriptions of the officers will provide the required qualifications.
Thank you.
Mr. Chairman, I'd just like to ask the Attorney General a question, please. Is there any particular reason why you're limiting parole officers to prison officers? Why not other professionals? Don't the prison officers have other important work to do? And they're already short-staffed? And they don't have this kind of specialized training. Why limit it? Why not expand the categories?
General.
Okay. I've had to take instructions from my client, the minister, who says that at present the prison officers are the pool that he would look to. It may be that in the future that pool will be expanded, but that meets the exigencies of the moment. Is that it?
Mr. Chair? Thank you. Minister, don't you think it is prudent to have a formulation under that provision to allow the Commissioner of Prisons to be able to recruit or appoint parole officers outside of the pool, given the real constraints that can be brought to bear on prison officers?
I think there's a new piece of legislation, as you're aware. That is a pool that we are working with. As it starts to roll out, if that becomes necessary, certainly, I think that will be a way to go. But we have to work with the pool that we have now, and we want to extend it beyond that for the time being. But for the proper running, it may be necessary down the road, and we will certainly look at that.
But why not give yourself that flexibility at this point in drafting the legislation, so that if the situation arises, you don't have to come to Parliament for...
It may be flexible, or it may be a restriction at this point in time. So we will run it for that period of time. We have a first-year review. We have to come and present a report to the Parliament. We will see how it runs. If it becomes necessary, and any other amendments that we would bring for the proper functioning of the board. That's what we see.
Mr. Chair, to the Minister of Justice. Minister, every year for the past 15 years at the budget time and during that budget period, the prison service is seriously short-staffed. I am sure you have the figures. Normally, they are operating at less than 2/3 of the establishment, not because of their fault, not because of the government's fault, but because of the Public Service Commission's failure to appoint prison officers. That's one. So you're dealing with an immediate short staff. You're now adding a whole parole system to that burden. The Prison Officers Association on a weekly basis cry out for help and resources. The second point is it that you're telling us by starting with the cadre, limiting yourself to start with the cadre of prison officers, that they're prison officers who currently have the necessary qualifications that are required to be parole officers?
Thank you, member. I don't know if you were out of the chamber when I was closing, but I did indicate the Minister of Homeland Security has indicated that by July, we'll be taking the first tranche of new prison officers in, and certainly but in the next few months thereafter, 800 officers will be recruited. And out of that, we will be certainly creating a line of officers dealing with parole under proper training and guidance.
Thank you very much.
And just to put in, that didn't come just so. That was done in consultation with the personnel department and so on.
Thank you very much, Minister. I'm glad to hear that. But every year, there are normally 2 batches of new prison officers who are passed out and join the prison service in the hundreds. So what you're seeing is not abnormal. There is a significant attrition of prison officers leaving, of prison officers retiring, etc. The figure, what was the figure? You said 800 new ones are being taken on by July?
No, there'll be a first batch and then a subsequent.
But what is the total batch that you had indicated? Was it 8 or 600?
It will be the total amount.
Within which period of time? When? When?
Mr. Speaker, as we stand, Chairman, this evening, by tomorrow, we'll get a definite word as to if the training could start as early as next week.
But how many are you looking at?
Mr. Speaker, Mr. Chairman, I just have one point.
I'm just trying to establish, is it above the normal?
Mr. Chairman, I have a point of order. In the stage of committee, we deal with the clauses of the bill, not the policy. That is the debate.
But we are dealing with the
those
clauses
matters.
of the bill.
All of my colleagues opposite had an
amendments.
opportunity to ask all of these questions. They asked none.
Is ram it here?
This is to deal. No, this is not Chinley either. This is not Chinley either or your brother. Who get?
Chinley or my brother.
Or your brother. Right? So
relax yourself.
Relax yourself. And none of my family get locked up for drugs or ammunition. So relax yourself.
And which of my family got locked up for drugs and ammunition?
But Mr. Speaker, this is
enough of that.
This is of the bill and not the policy.
Right. I think we've had enough of that. I think we've discussed this at nauseam.
Chair.
Necessary information.
Right. And I
before
think
she woke up from her slumber.
Chair.
That is unacceptable. Port of Spain not withdraw that. Withdraw it.
What did I say? Before he woke up from his slumber?
No, I heard you.
Before he woke up from his slumber?
I heard what you said. Port of Spain North.
Withdrawn.
And apologize.
The right pronoun is not
And
used.
apologize.
For what?
What you said, and you know what you said.
Apologizing for that.
Port of Spain North.
You asked him to apologize. Did you ask him to apologize for his utterances? Until he apologizes, I'm not apologizing.
No.
This one-sidedness. I am not apologizing.
No. I heard what you said.
Did you hear what he said? Calling family name, you heard that?
I did.
Okay, so call on him to apologize first in the sequence of things.
That was in response to what you said. Let's not let this degenerate. You know what you said.
So what am I apologizing for?
You know the offensive and prejudicial pronoun you called the member. Come on, withdraw it and apologize. You know what you did.
I withdrew it already.
Right?
I have withdrawn it and corrected it.
You know what you did.
I'm not
And I'm
apologizing.
calling on you
I'm not
to
apologizing. I've said I'm not apologizing.
Port of Spain North, I am calling on you to apologize for using that gross
what?
Pejorative, and I am not going, hold on. You know what you did. I heard you. The response from the member for Barataria was in exchange to you hurling what you know. Hold on. You call someone's name, you hurled it at him, he responded, okay, fair enough. That is normal banter. Hold on, I'm not inviting you to respond as yet. What you responded thereafter and degenerated to, and you know what you did. You know what you did. You made a highly inappropriate, sexualized comment towards the member, and I'm calling on you. Yes, I heard you. I heard you. I heard you. You know what you said. You purported to call the member by the wrong pronoun. You know that. I don't want to repeat what you said.
May I
but
respond
you know
now?
that. So the rest of it I can ignore. You all were trading barbs, that's fine with me. That's okay. You want to call each other by names and so on, that's all glorified schoolboy banter. But the mischaracterization of the member by a gender offensive name, and I'm trying to be very neutral here, by a gender offensive misdescription, I will call it, That is uncalled for.
Which I have withdrawn. But Mr.
But I
Speaker,
want
on
you
a
to
point of
apologize.
clarity, is it that the Speaker in the chair is now going to accept the hurling of insults to one's family in here?
No, I'm
and
not
also with
accepting that.
lies? Is that where we are?
I'm not accepting that. What I said
I
is that
apologize if he apologizes.
I can understand that banter passing back and forth of that
But
nature.
what grabbed your attention to demand an apology is the use of a pronoun.
As inappropriate, sexualized
For us to move on,
misdescription.
I withdraw it and apologize.
Very well. You'll be well advised.
Mr. Speaker, may I refer your attention to Standing Order 55-4C?
Yes, and that is why I asked for the standing order. The member was well advised, albeit he might have reluctantly done so. He said in the interest of moving on that he will apologize, withdraw and apologize. I can understand the need for members to perhaps engage in some exchange of barbs. I can understand that. It happens to the best of us at times. Those of us who come from the culture of litigation, it happens to the best of us at times, sometimes in a more restrained environment. But what you call the member, hold on, I'm not inviting a discussion. I normally, I'm very, 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 how shall I put it, somewhat slightly indulgent on trading of barbs. But what you did there, by calling the member by a highly inappropriate, gender-biased, and in a pejorative manner, is inappropriate and unacceptable.
Mr. Speaker, I'm sorry, but that cannot be worse than calling somebody's family member's name in the Parliament.
All right, let's move on. I propose to put the question. San Fernando East, I'm not inviting you to address me.
Mr. Speaker, if I...
Mr. Speaker,
Mr. Speaker, if I may, on a point of order...
apologize? He did. Let's move on now. I think we've had enough of that.
Mr. Speaker, on a point of order, please. Mr. Speaker, standing order 48-4. I'm asking for your ruling in relation to the member for Bataria Sanwan using offensive and insultive language to the member for Port of Spain North, Sentence West in relation to saying that his family members were arrested.
Listen.
In light of saying, please, Mr. Speaker, in light of saying, Mr. Speaker, for the issue of fairness in this House, I'm asking for this member to withdraw and apologize, please, to the member for Port of Spain North, Sentence West.
Hold on. I dealt with all of that. I don't want to prolong this issue. Is the member for Port of Spain North going to apologize to the member? We're going to go back into all of that for what originally sparked this furor?
Mr. Speaker, I have asked for ruling on this particular issue.
Come on. All right? Barataria, in all fairness, can I just ask you to withdraw and apologize for the reference to family members with guns and drugs? Please.
Mr. Chairman, I apologize. Mr. Chairman, I withdraw and apologize that I made a factual statement that none of my family members have been charged with drugs or ammunition.
Let's not.
That's a purely factual statement.
Okay.
I can't say for anybody opposite.
Let's move on. I propose to put the question now. I think we've exhausted enough time on what...
Clause 22.
The question is now that clause 22 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. Okay. The noes have it. Honorable members, the question is that clause 22 now stand part of the bill. Those in favor say aye. Those against say no. No. The ayes have it. Clause 22 now stands part of the bill.
Clause 23.
Question is that clause 23 stand part of the bill. Port of Spain South.
Mr. Chairman, I am obliged to you. Clause 23, 1 and subsection 2 together makes it a requirement that when a parole officer, as soon as it's reasonably practicable, conducts an assessment, a rehabilitative assessment, that officer would then recommend appropriate rehabilitation programs for the offender that would best assist in his rehabilitation. And there's a penal clause if the offender does not abide by the recommendation and attends the appropriate clause, in that the offender shall not be recommended for the grant of parole unless he participates in the program prescribed under the subsection 1 herein before mentioned. The issue that the opposition has, as it happens in courses that are offered by COSTAT 1 year, not offered by the next, the parole officer may be in good faith recommend some course for the offender to participate in, but the state does not fund the course, the course is discontinued, and therefore the offender is unable to participate in those courses, and the offender acted in good faith, the parole officer acted in good faith. In those circumstances, we are respectfully recommending on this side that a new subsection 3 be included that reads as follows: no offender shall be denied parole, penalized, or prejudiced solely by reason of the state's failure to provide rehabilitative, educational, vocational, psychological, or treatment programs required under this Act. What this will do, Mr. Speaker, it will insulate the process from any vagaries that may occur to a recommendation made in good faith by a parole officer, but that the offender was unable to access because maybe the course simply does not exist. Therefore, we are recommending and we are seeking an amendment that covers the offender, because this is a fundamental issue, because the offender shall not be recommended if he does not successfully participate in all of the program prescribed. Supposing he wants to participate but is unable to participate because the courses or whatever programs simply do not exist, that means that he will be denied the opportunity for parole. And this is the rationale for this, in our humble view, very sagacious amendment.
Honorable Attorney General.
Chair, we thank the member for the suggestion. We are confident that the appropriate courses will be available. The legislation as it is drafted requires that the parole officer shall, as soon as is reasonably practicable, conduct whatever with a view to determining appropriate rehabilitation programs. That those programs are condition precedent. We do not think that the legislation needs to be amended, and that is our policy, so it's rejected.
Thank you. The question is that clause 23 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. The noes have it. Honourable members, the question is that clause 23 now stand part of the bill. Those in favor say aye. Aye. Those against no. No. The ayes have it. Clause 23 now stands part of the bill.
Clauses 24 to 38.
Question is that clause 24 to 38 now stand part of the bill. The question is that clauses 24 to 38 now stand part of the bill. Those in favor say aye. Aye. Any against? Clauses 24 to 38 now stand part of the bill.
Clause 39.
The question is that clause 39 stand part of the bill. For the Spain South.
Mr. Chairman, the simple addition to this clause is a new subsection 3 that would remove all doubt that when it comes to one of the conditions of release, in keeping with the theme of the sanctity of the victim, that a clause be included that gives the parole board that unfettered and unequivocal power to impose exclusion orders, and that is why we propose a new subsection 3 to clause 39 that reads, for avoidance of doubt, the board may impose non-contact orders, exclusion zones, or other protective conditions for the safety and dignity of victims and their families. That's a simple rationale for our respectful amendment.
Again, I thank the member. If you look at the section 6, subsection C, 6 relates to the functions of the board, and it says the board is to, well, the Act actually said the functions of the board are to make recommendations to a court in relation to the conditions on which parole is granted to an officer. We think that that is a function that is best left to the court, so that we do not accept it. Thanks.
All right, the question is that clause 39 be amended as circulated. Those in favor say aye. Aye. Those against say no. The noes have it. Honorable members, the question is that clause 39 now stand part of the bill. Those in favor say aye. Aye. Any against? No. The ayes have it. Clause 39 now stands part of the bill.
Clause 40.
The question is that clause 40 stand part of the bill. For the Spain South.
Mr. Chairman, the efficacy of victim impact statements have been applauded by the courts, used in several sentencing exercises, and has shown itself to be almost a cathartic release sometimes for victims. In fact, respectfully, in restorative practices, it is part of what the experts call the transfer of power, because it is said at the time of the commission of the crime, the offender has all the power. But when it comes now to the victims saying and expressing their views, the power shift occurs. And that is an important part of the healing for victims. In those circumstances, apart from the being present, because some may not want to be present, apart from written submissions, a victim impact statement is different from that. And we are asking that clause 40, after 7, we include the phrase to make a victim impact statement at hearings of the board. A victim impact statement is different from a submission by way of affidavit. It is different from appearing at the hearing. And in those circumstances, we ask that that be included as a proper restorative justice practice.
Honorable Attorney General.
Chair, the recommendation is not accepted. We think that 47, if you read 7A in conjunction with B, 47 allows victims or the relatives to be entitled to appear at the hearings of the board and to make oral or written submissions and then B, to make written submissions by way of affidavit where they choose not to attend. And we think that that is sufficient. That's our policy, so it's not accepted.
All right. The question is that clause 40 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. Noes have it. Question is that clause 40 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Clause 40 now stands part of the bill.
Clause 41.
Question is that clause 41 stand part of the bill. Question is that clause 41 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 41 now stands part of the bill.
Clause 42.
Question is that clause 42 stand part of the bill. Yeah. And I think both sides are adding them on this amendment.
I see no more, Mr. Chairman. We are.
Umar
I'm glad at least 1 out of 12 was accepted.
Umar nodded.
Homer nodded, I see. All right, so the question is that clause 42 be amended as circulated. As circulated by the Honorable Minister of Justice. You want me to put it on the record, right? Yes. Okay, and also as circulated, in terms as circulated by the member for Port of Spain South. Does that sufficiently meet your requirements? Yes. Right. So the question is that clause 42 be amended as per the circulation as outlined. Those in favor say aye. Aye. Any against? The ayes have it. Clause 4. Yes. Honourable members, the question is that clause 42 as amended now stands part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 42 as amended now stands part of the bill.
Clauses 43 to 54.
Question is that clauses 43 to 54 stand part of the bill. The question is that clauses 43 to 54 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clauses 43 to 54 now stand part of the bill.
Clause 55.
Question is that clause 55 stand part of the bill. What is Spain South?
Mr. Chairman, the report coming from the board to the minister 3 months from the end of each financial year, we have there are really two available prerequisites, two numbered prerequisites, which is that report shall include the number of offenders released on parole, the number of offenders whose parole was revoked during the financial year, and the reasons for such revocation. We say on this side, in order for there to be proper audit and therefore recommendations that could improve the system, that such a report should have other stipulated data in it, apart from the broad omnibus clause, such other matters the board thinks fit. And as we legislate here as parliamentarians, we are suggesting and recommending new subparagraphs and moving out the C that exists now and replacing it with the following: that the report shall contain the number of offenders whose parole was suspended, the rates of recidivism among parolees, the number of parole applications received, the number of parole applications denied, any recommendations for legislative or administrative reform. The key here Mr. Chairman, is trying to get it right. If we want an audit that will guide us in going forward, these things that we are suggesting here, we say are necessary to properly assess the efficacy, how the thing is working, how the bill is working, how many people have reoffended, how many people have applied, how many people have been denied after their application. This could only enhance the working of the bill, and therefore we have made this respectful submission. And if it is accepted, consequent upon that, there will be the renumbering from C to H, because our recommendations will change the numbering. And that is the purpose of this recommendation.
Honorable Attorney General.
Chair, this is one of the 3 recommendations out of 60 or so that we have thought about. I'd like to think about it some more, and I cannot accept it this afternoon, so it has to be rejected, but we will look at it in the Senate.
Okay. The question is that clause 55 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. Noes have it. The question is that clause 55 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Clause 55 now stands part of the bill.
Clauses 56 to 59.
Question is that clauses 56 to 59 stand part of the bill. Question is that clauses 56 to 59 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 56 to 59 now stand part of the bill.
New clause 60, Office of the Parole Ombudsman.
The question is that new clause 60 be read a second time. Those in favor say aye.
Aye.
Those against say no.
Mr. Chairman, there seems to be some ambiguity.
60?
It's our recommendation. If you accept it, just say aye.
Oh.
Right, so you have to discuss why he wants that.
Okay.
So what are we going to do? Just say.
All right. For the Spain South, can you
elucidate a little?
Invite you to make your case for the inclusion
Yes.
of a new clause 60?
The role of the Office of the Parole Ombudsman is by no means a novel role. I think it is there in the New Zealand model. It's there in the Canadian model. I don't want to mislead your committee, Mr. Chairman. And we say an independent Office of the Parole Ombudsman for something so important as parole. It gives I think it gives the offender a real chance of challenging any decision which he or she feels is systematically unfair, and it will, of course, have the coverage of an independent reporting to Parliament, and it's a forward-thinking amendment, it's a forward-thinking clause, and in those circumstances, we are suggesting that it be included and that the 59 clauses be augmented to have 60, which will include this clause. There is hereby established an independent Office of the Parole Ombudsman charged with investigating complaints, auditing parole procedures, reviewing systematic fairness, and reporting independently to Parliament. These are my submissions, Mr. Chairman.
The Honorable Attorney General.
Chair, we are unable to accept the new clause. We think that clause 55 provides for the submission of the report of the operations to the minister and thereafter to Parliament. But then also, if you look at clause 8 of the bill, the board is to be independent and not subject to the direction or control of any person in the performance of its functions and in the exercise of its powers under this Act. We believe that that provision comes close to trenching on Section 8. So it's rejected.
All right, that takes care of the clauses. We move now, there's one schedule.
The schedule?
Right. The question is that the schedule now stand part of the bill. Those in favor say aye. Any against say no. The ayes have it. The schedule now stands part of the bill. Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Those against say no. The ayes have it. The bill as amended will now be reported to the House. That's it? Honorable Minister of Justice.
I didn't put it, I hope not. You walk over it.
Thank you, Mr. Speaker.
You walk over it. You're already walking over the thing.
Seem to have lost my script, Mr. Speaker, but the bill was if you'll just give me 1 minute, please.
I think if you look behind you, in true Solomonian style.
Mr. Speaker, I wish to report that the Parole Bill 2026 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Parole Bill 2026. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable Minister of Justice.
That a bill entitled An Act to Provide for the System of Parole and Related Matters be now read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Provide for a System of Parole and Related Matters be now read a third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it.
An act to provide for a system of parole and related matters.
That's it, Keisha. That's it. Honorable members, it's now 1:34. I propose to suspend for lunch. We've had quite a productive session, save and except one or two minor skirmishes, which were adequately and amicably resolved. So let's keep it like that. After we resume, we will resume. The House is now suspended. We'll resume at 3 o'clock. Thank you very much.
Speaker.
All right. You ready to go? AG? Honorable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters, be now read a second time. Mr. Speaker, give me a second. We on this side have recognized, as I said earlier this morning, the urgency of the moment, and in recognizing that crime poses an existential threat to us, the government believes that the reform of the criminal justice system must be given absolute priority. In doing so, we seek to ensure that a balance must be appropriately effected between the implementation of punitive measures and the availability of rehabilitative measures within the criminal justice system. The provisions of this bill are intended to modernize and enhance the criminal justice system by affording persons who were previously convicted of minor offenses the opportunity to have a clean slate in order to move away from a life of crime and to meaningfully reintegrate into society. It must be noted that the proposed provisions will not apply to all offenses. The objective is to create conditions for work, travel, and reform of those who can be saved, and therefore to reduce the incidence of recidivism. In that, it bears a similar end state objective to the bill which we debated this morning. The history of this bill clearly demonstrates that our colleagues on the other side have had very little concern in improving the lives of citizens whose personal records have been tarnished by minor criminal offenses. And I intend to prove that even to them. The bill has its genesis from a policy prepared by them in 2021. On the 13th of January 2021, the then Attorney General, in response to a report of the Joint Select Committee, informed this House that legislation would be introduced to allow minor convictions to be expunged from a person's criminal record if they do not reoffend during a fixed rehabilitation period. Based on that policy, the Law Reform Commission, as it must be, or as it can be under the law, was instructed by the then Attorney General to draft legislation to give effect to their policy. The Criminal Records Rehabilitation of Offenders Bill of 2022 was then prepared. That bill contained 27 clauses. The bill before this House today contains what? 27 clauses. Though arranged differently, with one additional clause to deal with the issue of savings. Now, I apologize to the House this morning. I got the numbers mixed up in the sense that the Parole Bill did not contain 27 clauses. It was this one which contained that. So don't rush to carry me to privileges for that. But listen, I don't care. I don't care about that. Go ahead. I said that to amuse you, and you jumped, and you were amused. Mission accomplished. Mr. Speaker, that was 4 years ago. But my colleagues, they did nothing. This government is here to give hope and to restore dignity to persons who have been disadvantaged by a minor criminal record. I want to treat with the local condition first. It's important to bring to the attention of the House that the power of pardon for offenses exists in this country. It's contained in sections 87, 88, 89 of our Constitution. And those sections provide for the presidential power of pardon and the establishment of an advisory committee on the power of pardon. The advisory committee reviews presidential pardons, including those for those persons who desire to have their criminal records expunged. Other applicants include prisoners who desire early release from prison, and those who wish to have their sentences reviewed. As a matter of fact, last week I had an application from someone who had committed a particularly grievous murder. I put that in a special place for my colleague, Mr. Maharaj, Honorable Minister Maharaj, to consider. I would not be considering it. The responsible minister, after consultation with the committee, advises the President on whether a pardon should be granted. So in essence, Mr. Speaker, there already exists in our criminal justice system something, a method, by which a person's convictions may be dealt with. I am informed that there is a substantial backlog of matters currently before the committee. The Minister of Justice is actively working on reducing that backlog, but what he might not know is that that backlog existed, or it started to exist around the year, I don't speak behind people's backs, 2019. And it was a fact that was known then, but nothing was done about it. So you have to go back and ask the person who was responsible in 2019 about that issue. Now, there are other pieces of legislation. The Dangerous Drugs Act, which is Chapter 1125, was amended in 2019 by the Dangerous Drugs Amendment Act, which is Act number 24 of 2019. to allow a person convicted for possession of not more than 100 grams of cannabis, not more than 14 grams of cannabis resin to apply to the Commissioner of Police to have such conviction expunged from his criminal record. Section 5, large D3 of the DDA states that a person's criminal record for such an offense shall on application be expunged by the Commissioner of Police. Now, it doesn't give him a discretion, it says shall on application be expunged. Across the region, the expungement of criminal records is governed by statutory frameworks that reflect a shared commitment to rehabilitation, but differ in their administrative structures and eligibility rules. Jamaica's legislation is one of the more developed, allowing individuals convicted of minor offenses to apply for expungement after a defined period of good conduct. Applications are reviewed by a board. Once granted, the conviction is treated as if it never occurred, meaning that it is removed from the criminal record and does not need to be disclosed for employment or other purposes. In St. Kitts and Nevis, there's a more limited statutory scheme where expungement is possible, but subject to stricter eligibility criteria and to longer waiting periods. That process is overseen by a committee. Serious offenses are excluded, reflecting a cautious approach to balancing rehabilitation with public safety. Grenada has adopted legislation which permits expungement for certain offenses, but its system is discretionary, requiring applications to be assessed by designated officials who consider the nature of the offense, the sentence imposed, and evidence of rehabilitation. In Grenada, too, a board has been established to facilitate the expungement of records. In Grenada and St. Kitts, similar models are followed. Eligible convictions can be expunged after a period of good conduct and then removed from the criminal record, but serious offenses are not eligible. Barbados provides for expungement through legislation, but its approach is more restrictive. Fewer offenses are eligible, longer waiting periods before an application can be made are prescribed. However, once granted, the conviction is removed from the record. In Barbados, too, a board is also responsible for expunging criminal records under the legislation. The board informs applicants in writing whether their application is approved or rejected and provides written reasons for any rejection. Mr. Speaker, the comparative analysis shows that while all Commonwealth Caribbean countries recognize that expungement is a valuable tool for reintegration, processes may vary. They may vary in terms of how much discretion is given to administrative bodies and how wide the eligibility net is cast. What is to be noted is that none of the regional jurisdictions use a judicial body. Now I'll turn briefly to the international position before turning to the legislation itself. In the United Kingdom, there is, and there has been for some time, a royal prerogative of mercy. Now, the royal prerogative consists of the power to grant pardons and reprieve Traditionally, the monarch had absolute power to pardon and to release an individual who had been convicted of a crime from that conviction and the intended penalty. Today, however, the monarch only grants pardons on the advice of a government minister, so that pardons are issued subsequent to conviction. A pardon does not eradicate the conviction, but simply removes the penalty which was imposed. There's legislation as well to go along with the monarch's power. There's the Rehabilitation of Offenders Act 1974, which introduced a system of spent convictions in England and Wales and in Scotland. The Act provides for the rehabilitation of offenders who have not been reconvicted of serious offenses for specified periods of years. To penalize the unauthorized disclosure of their previous convictions and to amend the law of defamation. The Act was created to support the rehabilitation into employment of reformed offenders who have remained law-abiding citizens. In this jurisdiction, there are certain similarities with the UK Act. The UK Act in Section 5, as our Clause 5 of the bill, which is before the House, deals with excluded sentences. Under the UK Act, a sentence of imprisonment for 4 or more years, a sentence of life imprisonment, a sentence of preventative detention, and a sentence of detention during the state's pleasure or for life, amongst others, are all excluded sentences, and therefore these sentences can never become spent. In Canada, the royal prerogative of mercy is the King's prerogative, which is exercised by the Governor General. It forms part of the clemency provisions, which are similar to ours, granted in exceptional circumstances in deserving cases related to federal offenses. It acts as a safety valve when other legal avenues are exhausted, prioritizing justice, humanity, and compassion over strict law. There is legislation, the Criminal Records Act, which provides for the suspension of the records of persons who have been convicted of offenses and have subsequently rehabilitated themselves. A recorded suspension allows a person who was convicted of a criminal offense to have his criminal record kept separate and apart from other criminal records, but he must complete his sentence and demonstrate that he is a law-abiding citizen. There is in Canada, however, in the Human Rights Act, we do not have, of course, a developed jurisprudence in that respect, a prohibition against discrimination, and that is a discrimination against conviction for an offense for which a pardon has been granted. So that's a human rights matter. And, Mr. Speaker, I do know that in Canada, the law provides for the suspension of the criminal record, whereas the bill, which is before us, seeks to provide for the expungement of a person's criminal record, but only in specified circumstances. I turn briefly to a summary of the bill, which is before us. As I have said, it has 28 clauses. In clauses 1 to 5, the bill treats with preliminary matters when it is to come into effect by proclamation, and for example, what are the definitions which apply to certain expressions, convictions, proceedings before a court, and the like. Clause 3 of the bill identifies the purposes of the bill, which is to provide for certain criminal convictions to be spent. Clause 4, to provide that the act will not apply to a person who has been convicted of an offense listed in the first schedule. The offenses listed in the first schedule are called excluded offenses because of their gravity and seriousness. Some of these offenses include murder, manslaughter, kidnapping, rape, trafficking in a dangerous drug, treason, and the like. Clause 5 provides for sentences that are excluded from rehabilitation. It builds on clause 4.2. 6 to 13, 6 seeks to provide that after a specified time, convictions for certain offenses should be regarded as spent, and the convicted person becomes a rehabilitated person. 7 deals with convictions in a foreign jurisdiction and states that the act shall apply in like manner as it applies in relation to a conviction and sentence in Trinidad and Tobago, but conditions must be met. Clause 8 makes reference to the second schedule, which sets out the respective rehabilitation periods applicable for specified sentences. For non-custodial sentences, for imprisonment not exceeding 6 months, imprisonment exceeding 6 months, imprisonment exceeding 18 months. In clause 8, there is a provision which speaks to consecutive and concurrent terms of imprisonment. That clause basically gives effect to the rehabilitative nature of the bill, treating consecutive terms of imprisonment of detention of young persons and imposed in respect of offenses a person committed in the same factual scenario as one sentence. The subclause clarifies that all these different terms of imprisonment and periods of detention shall be treated as one sentence for the purposes of the bill. That clarification is important, especially because the bill is time and offensive sensitive. Clause 9 seeks to give effect to the broad aim of the Act, that is, to place a rehabilitated person in the position that he would have been in had he not committed the particular offense. The clause offers further support for a rehabilitated person by restricting the evidence which may be given in proceedings before a court. It even states that a court shall disregard any information inadvertently disclosed by a person during proceedings that relates to his past, previous, spent convictions. Clause 10 seeks to provide for certain exceptions relating to the disclosure of spent convictions in relation to criminal proceedings. Clause 11 identifies instances where the disclosure of spent convictions may be warranted. A rehabilitated person, once requested to do so, must disclose particulars of a spent conviction when seeking to become a member of a professional body of any of the professions specified in the third schedule, such as lawyers, doctors, teachers, nurses, things that you'd normally expect, when seeking particular forms of employment as specified in the fourth schedule, such as employment in the civil service, police service, insurance companies, commercial banks. And then when seeking to become engaged in any business of the type specified in the fifth schedule, such as that of a firearms dealer, stockbroker, or real estate. In clause 13, I've skipped 12, it permits, clause 13 permits of a rehabilitated person bringing an action in defamation against any person who maliciously publishes matters imputing that the rehabilitated person committed or had been convicted, charged, or prosecuted for an offense which was the subject of a spent conviction. That is consistent with some of the international precedents. In clauses 14 to 19, clause 14 empowers the High Court to hear applications for the expungement of spent convictions, to grant or reject such applications, and it sets out the factors that the court is to take into account in arriving at its decision. In clause 17, there is a provision which prevents persons from filing multiple applications for the same spent conviction once they have already applied for or appealed a High Court decision regarding it. Essentially, this ensures a one-time process per conviction. Clause 19 is one of the more important provisions in the context of the legal status of the persons whose convictions have been expunged. Such a person would now be deemed to be a person who has never been charged with, prosecuted for, convicted of, sentenced for the offense to which that conviction relates. In the last part of the bill, that is part 4, clauses 20 to 28, we deal with a number of miscellaneous provisions. Clause 20 protects the prerogative of mercy vested in the President of the country. It says that the bill shall not in any way affect any right vested in the President under Section 87 to grant a pardon. There are cases in which the work of the Mercy Committee has been castigated, and I suppose those cases provide further justification for the bringing of legislation to treat with this matter. Now, in my speaking notes, I see I have, and I did not prepare my speaking notes in the hour that I broke between lunch and now, but I will just read what is in the speaking note. I think I have to read it. Please read it. Okay. It says, in an article published by the Trinidad and Tobago Guardian entitled Young, Mercy Committee Inactive, the former Minister of National Security, Stuart Young, you realize that I'm speaking with, I'm trying to keep it down. I don't want him to pick on my friend over there. Well, their television, I think there are all sorts of televisions and so on all over the place. we should have no comment from Pitt. Don't you think so? The former Minister of National Security, Stuart Young, himself, I had lunch. I came here. I'm quiet. I am going through my notes.
All right, Diego Martin.
The former Minister of National Security, no comment from Pitt, hush. The former Minister of National Security, Stuart Young, himself acknowledged that there were at that time hundreds of requests before the Mercy Committee. Now, this is the 13th of March, 2019. That's almost 10 years ago, fellas. He promised to address the backlog. But, of course, this is an article in the Trinidad Guardian. Now, I made no notes on my notes, but I think that that's a promise made, but a promise never kept. So that, as usual, my friends on the other side refuse to act on the promise. But the government and the minister has taken up the baton, and the bill is here for the consideration of the House this afternoon. If I could just conclude by saying that there are some constitutional issues. We looked at them. We believe that the bill must be enacted with a simple majority vote. It is the view of the government that it does not interfere with any rights or freedoms guaranteed under Section 4 and 5 of the Constitution, and that it does not trench on the right of any of the other arms of the state. Mr. Speaker, the bill is part of our effort to reform our creaking, neglected justice system. It reiterates the government's commitment to modernizing the criminal justice system. It fosters conditions for attacking the problem of repeat offenders. It treats with crime in a holistic manner. And I dare say it answers the questions, the criticisms of those who say that the state of emergency is your only answer to crime. By providing a structured pathway, we provide for the expungement of criminal records for those who have demonstrated genuine reform. We dismantle the invisible barriers to employment, housing, insurance coverage, and ultimately social reintegration. The bill represents a critical step in our mission to build a more just and inclusive society. We are choosing to replace a cycle of perpetual punishment with a system of rehabilitation and redemption. As such, Mr. Speaker, I urge all members of the House, including the very few opposite at this time, late time in the afternoon, to support the bill and to return to the promise that they made in 2019 to bring relief to these citizens. Mr. Speaker, I thank you and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters to be now read a second time. Member for Laventille West.
Thank you very kindly, Mr. Speaker, for the opportunity to contribute to a very important bill that is before this Honourable House, Mr. Speaker. Mr. Speaker, let me start off by saying right away that the opposition supports this bill 100%, please. Further to which, in looking at the 28 clauses in the bill before this Honourable House, there are some suggestions and some matters we wish to just raise for consideration as we move forward, please, Mr. Speaker. Mr. Speaker, the Criminal Records Rehabilitation of Offenders Bill 2026 seeks to give a second chance to many of our nation's citizens who may have had some minor infraction with the law and would like to get their life back on track, have better access to employment opportunities, have better access to educational opportunities, as well as to just have a free spirit in terms of going ahead with life, having these, in most cases, minor offenses, following them for the rest of their life, Mr. Speaker. Mr. Speaker, I want to refer to an article from the Ministry of Justice and Constitutional Affairs from Jamaica in relation to a publication in relation to their version of the Rehabilitation Bill, where they speak about the benefits of expungement. And this publication, Mr. Speaker, is entitled The Expungement of Criminal Records. On page 2 of the publication, Mr. Speaker, and I read, benefits of expungement. Expungement of a criminal record is an excellent way for an individual to close a chapter on a past mistake. It can provide persons with peace of mind, freedom to pursue career opportunities, and access services that may not have been available to them by virtue of their criminal records. One such example, Mr. Speaker, is securing jobs. The most valuable benefit of expungement is securing a job, a promotion, or retaining the job of an individual currently occupies. Employers may conduct background checks before hiring a job applicant. These checks would reveal an applicant's record of arrest, conviction, and probation status. Having a criminal record in most cases would be unfavorable. Mr. Speaker, even for a lot of the basic jobs in terms of entry-level positions in many of our state enterprises as well as private entities, you would find most citizens will have to produce what we call a certificate of character from the Trinidad and Tobago Police Service. And that, Mr. Speaker, would include any convictions whatsoever, including simple offenses such as perhaps obscene language, common assault, simple larceny, some of the minor offenses, please, in terms of the scale, Mr. Speaker. And what you find is from the moment you have any conviction recorded on your criminal record, it prohibits you and prohibits a lot of citizens, Mr. Speaker, from gaining access to simple jobs, Mr. Speaker. And that is why we stand here in support of this bill, and will seek, Mr. Speaker, in our delivery on this side, to only point to some aspects of the bill that can be strengthened. So, Mr. Speaker, one of the first clauses I would like to bring to the attention of not only the House, but for the members of the listening and viewing community, is in relation, Mr. Speaker, Clause 17. And Clause 17, and I will just quote from the bill. Clause 17, subsection, no further applications. A person who has made an application under Section 15 or appealed under Section 16 is not entitled to make any further application under Section 15 in relation to the spent conviction of that application. Mr. Speaker, whilst we agree in relation to an appeal, if you have gone through the first application before the High Court and for some reason you are denied and you wish to appeal that decision, Mr. Speaker, if you take it to the next step to have it appealed, then by all means, we don't want to overburden the judicial system with appeals on natures coming back of matters coming back of this nature. But in relation to an applicant who have laid an application before the High Court, and whether by some, it can be some procedural error, you may have litigants in persons, you may, whether it is some technical aspect that made the court decide, in the High Court decide, that this person is not, they are not granting that person the declaration of the spent conviction, thereby expunging their record. To have the court deny that and not have an opportunity sometime later thereon, if there's any change in circumstances, to reconsider an application may, Mr. Speaker, be very detrimental to many citizens. And I want to suggest, Mr. Speaker, in relation to Clause 17, and we will circulate the proposed amendment for consideration, that whilst we agree in relation to not giving applicants the right to reapply after an appeal has been determined by the Court of Appeal, we do not agree, Mr. Speaker, in relation to when a first application is denied, that that person also does not have an opportunity sometime later to make an application again. And I would get into what considerations, Mr. Speaker, would be relevant in relation to Clause 17 amendment. Mr. Speaker, what we essentially propose in this amendment is to delete the entire Clause 17 and insert the following. So 17, subsection 1, creating a new subsection, would agree in relation to a person who has appealed under Section 16 is not entitled to make any further application under Section 15 in relation to the spent conviction of that application. But subsection 2 would go on to say, Mr. Speaker, a person who has applied under Section 15 and has not appealed under Section 16 is not entitled to make any further application under Section 15 unless he can establish that there is a material change in circumstances. And for the benefit of the listening and viewing population, Mr. Speaker, I just want to use the High Court decision, which my friends opposite should be very familiar with. It's the case of T. Ferguson and Ishwar Galbaral Singh and the Attorney General. It's a decision by Mr. Justice Andre Mondesir, and it's dated December 22nd, 2010. In that case, there was an application for bail. And, Mr. Speaker, as you would know, pursuant to the Bail Act and to the common law principles in determining bail in Trinidad and Tobago, in order to show that, once you make an application for bail, and that bail application is denied, You can't just come Monday morning and say, I am going to reapply. I'm going to reapply for bail. You must establish that there is indeed a material change in circumstances. And we think, Mr. Speaker, that principle, Mr. Speaker, would be very useful in this circumstances in terms of persons applicants reapplying for some in relation to their application being denied on the first occasion. So I'm going to go to paragraph 28 of that judgment, Mr. Speaker, and I quote. It is clear, therefore, that having regard to the true common law test, what is required to be shown is that there has been a material change in the relevant circumstances. What is or is not relevant will, of course, vary from case to case. But the question of relevance is and must be in relation to the issue of bail and the applicant's entitlement to same. The duty is on the applicant to not only state but demonstrate to the satisfaction of the court on a balance of probabilities that since the previous refusal or denial of bail, there has been a material change in the relevant circumstances. It must be material in the sense that it is not a mere trifling change, so that these courts would not be inundated by or constrained to entertain repeated and legally frivolous applications based on speculation, conjecture, or on matters that have already been decided in previous hearings. It must also be relevant in the sense that it must have some relation or bearing or impact upon the issue of bail and the applicant's entitlement to same. I therefore direct myself accordingly. Mr. Speaker, this principle, whilst it refers to bail, can easily be adopted into this present bill before us as it relates to clause 17, thereby giving the court the power not for any applicant to simply reapply and the court and a judge has to spend time sitting down listening to these applications over and over again. But when you make a renewed application for bail, and in this circumstance, you would have persons making a renewed application pursuant to section 15 of this bill, clause 15 of this bill, Mr. Speaker. You would have persons making renewed applications and saying, here's what. On the last occasion, I was denied having my record deemed as a spent conviction and therefore expunged. This is why I want you to reconsider 2 years down the road. I want you to reconsider because I have now joined a community group. Or I made a mistake on my first application in the rehabilitation period in which I made the application for. The bill provides that the time in terms of when the rehabilitation period being from when your conviction is served, the end of it. Let's say a litigant in person decides that they can't afford to hire an attorney to make an application before the High Court in order to have their record expunged, and that lay person decides that they are going to be a litigant in person, make the application, and they may make it on some procedural error, please, Mr. Speaker. In that case, it is possible that we can allow for these situations, Mr. Speaker, to allow persons to actually access justice in some of the most serious cases, please, Mr. Speaker. So that's our first recommendation in relation to same, please, Mr. Speaker. And Mr. Speaker, whilst we are on whilst I'm on the topic of representation in terms of persons having to either make the application for themselves or through, Mr. Speaker, the issue of, even if they can't afford an attorney, I want to implore the government to consider, firstly, in relation to the Public Defender's Department of the Ministry of the Attorney General, now, and in relation to the legal aid and advisory authority, that when this bill is proclaimed, that it would require as well some consideration from a policy directive to allow citizens who cannot afford to make these applications pursuant to this bill to approach the legal aid, and to have legal aid once they assess these citizens and know that they are not of significant means in order to afford making an application such as this, that the state can provide some assistance through the legal aid authority. Further to which, as I said, concerning the public defender's department, there may be some situations where a public defender may have been appointed in a matter where, let's say, for example, the rehabilitation period passes the 3 years. They have represented that person before. They understand it's a first-time conviction, and that person, having not been able in the first place to afford an attorney to go through their original trial, it means, therefore, they may be in the same position, especially having a conviction recorded, that not only that they keep a record of same in relation to the persons who would be able to make the application, but to also provide for the relevant human resource within the public defender's department for applications of this nature to be made. And I know that as well in terms of the Ministry of Justice, which these agencies as well would fall under, that proper consideration can be had foreseen. Mr. Speaker, and whilst we call on the state and the government to consider these, I also want to make a call as well to the Law Association and to attorneys in private practice, because we may find ourselves in positions where there are persons, especially young persons, who may have made the mistakes. We have looked at the aspects which we commend wholeheartedly in relation to young offenders under the age of 18 finding themselves convicted of these offences, and once a 3-year period passing in relation to a summary conviction, that they are able to make an application for a spent conviction, or in relation to an indictable proceeding waiting until they reach 23 years to make an application. For consideration to be had on a humanitarian call on the Law Association as well as private attorneys to consider representing these, especially young persons who may have found themselves in this position, cannot afford an attorney to make this application, to simply assist in this matter, please, Mr. Speaker. Because, you see, it's all well and good to have good legislation. It's all well and good for us to debate this in here, and every member understands what each clause says and understand the application, and we go to the Senate and it's the same thing. And the President proclaims, Her Excellency, proclaims the bill, and then you find the vast majority of citizens who this may apply to simply are not aware of it, because maybe they're not in tune with the Parliament or with current affairs. And two, even if they know about it, they simply cannot afford it. So that is in relation to my client call for some civic duty from the legal fraternity, as well as for consideration from the government concerning the available resources that they already have. Further to which, please, Mr. Speaker, I think in clause in clause 9, subsection 4, subsection B of the bill, let me just read briefly from this section, Mr. Speaker. Yes. So in relation to section 9, 4B, we have, subject to this act, a conviction has become spent, or any failure to disclose a spent conviction shall not be a proper ground for dismissing or excluding a person from any office, profession, occupation, or employment, or for prejudicing him in any way in any office, profession, occupation, and employment. Mr. Speaker, we may have arms of the state that they too may not be aware of these provisions in this bill. And therefore it is incumbent, because this bill doesn't only speak to aspects of the state entity not being able to consider spend convictions, but also for private employers. Therefore, it would be incumbent upon the government to make the necessary sensitization program to roll out the aspects of the bill to inform entities. You may have supervisors in some state agencies, you may have private employers who may want to bring up a conviction of someone who has had it expunged. Either deny them opportunities because of same, either dismiss them because of same, either prohibit them from getting promotions because of same. And that, Mr. Speaker, would work against not only private employers, but against the state. Because you may have, you may find yourself in a position where these private citizens now are taking action against the state for breaches of these clauses, especially as it relates to clause 9, subsection 4B, Mr. Speaker. So, Mr. Speaker, so that is another point that we wish to draw to the Honourable Attorney General, the Honourable Minister of Justice, in terms of their rule out concerning, pre-proclamation of this bill, so that persons are aware. Mr. Speaker, the Dangerous Drug Amendment, I want to move to the Dangerous Drug Amendment Bill that was passed. And by way of clause 26, Mr. Speaker, 26 and 27, I believe. Yes, clause 26 and clause 27, you have the repeal of the Dangerous Drug Amendment Bill, the section 5, section 5D, 3, 4, and 5, I believe, Mr. Speaker. Mr. Speaker, if we look at clause 26 of the bill, it reads, and I quote, section 26, section 5D, 3, 4, and 5 of the Dangerous Drug Act are repealed. Section 27, clause 27 of the instant bill states, and I quote, notwithstanding the repeal of section 5D, 3 and 4 of the Dangerous Drug Act by section 26, an application which is pending before the Commissioner of Police at the date of the commencement of this act shall, if such application has, at that date, not been concluded, be continued and concluded under the Dangerous Drug Act, as if section 5D, 3 and 4 of the Dangerous Act had not been repealed, Mr. Speaker. Mr. Speaker, if we go to the Dangerous Drug Act, what you would find in relation to the said sections, Mr. Speaker, and I have it here. So section 5D 3, Mr. Speaker, provides that notwithstanding the provisions in section 50K of the Police Service Act, any offence on the criminal record of a person prior to the commencement of the Dangerous Drug Amendment Act 2019 for the possession of not more than 100 grams of cannabis or not more than 14 grams of cannabis resin shall be expunged by the Commissioner of Police. This bill, in 2019, a product of the People's National Movement, which we have started in terms of the process for allowing persons who have convictions for possession of marijuana under 100 grams to have their records expunged. it gave the Commissioner of Police the power to have the criminal record of citizens who have found themselves being convicted either prior to the enforcement of the Dangerous Drug Amendment Bill or thereafter, to make an application to the Commissioner of Police. It's a very simple process, Mr. Speaker. Mr. Speaker, that process can start and finish within 1 month. You simply write, you have your extract of the case being decided. In the extract would include the date that the charge was laid, the date that either the guilty plea was entered and the sentence was delivered, or in cases of when they go to the trial, when you were found guilty. And if it happens that the amount of marijuana in the person's possession and they are found guilty of it is less than 100 grams or less than 14 cannabis resin, you simply put in the application to the commissioner, the extract, your basic details, you write a letter showing the circumstances, and within a matter of weeks, Mr. Speaker, your criminal record is expunged. You can go back to the police station, you make a new application for a certificate of character, and it comes back showing that you have no conviction in relation to that aspect. That, Mr. Speaker, is a very simple process. It's a process that is inexpensive. You can simply write a letter. You can get the help of a friend. You can go to a representative to ask for some assistance. In some cases, Mr. Speaker, when you go to certain employers, I remember a constituent telling me that they applied for a job, and they didn't realize that there was even an option, that their one conviction that they had concerning marijuana possession from years ago, more than 10 years ago, that they could have made the application to the commissioner to have it expunged. And that employer, thankfully, was able to not only guide that young constituent to make the application to the Commissioner of Police, but also was able to help him write the letter, submit it, and within a short period of time, he was able to get his expungement. Mr. Speaker, what this bill proposes, unfortunately, this clause 26 and 27, is that it makes the process for the simple offense of possession of marijuana under 100 grams to now go through this refined process by way of making an application to the High Court in a specific format. You may have to, of course, hire an attorney, make the relevant submissions in front of the court, and then the court will treat with your application. Mr. Speaker, even in cases where you don't have let's say a 3-year wait period, when you can literally make the application, Mr. Speaker, right away in order to get access to justice. If we have a process that is working, we have a process that is working for a category of persons, why further complicate it by making these same citizens who would have originally got their expungement from the Commissioner of Police have to make a full application to the High Court with certain conditions in order to get the same expungement? Yes, Mr. Speaker. In relation to, Mr. Speaker, this expungement aspect, now we understand that one of the limitations, Mr. Speaker, of the section 5D of the Dangerous Drug Act, it speaks to why the record would be expunged, that in order for, in terms of the
minutes.
Thank you very kindly, Mr. Speaker. I will avail myself. Yes, Mr. Speaker. And in relation to the dangerous drug, in relation to the dangerous drug amendment, the only limitation I could have found in that section would have been the fact that you have to make an application concerning the pardon. So which means it may have been better use of our time and for citizens' time in relation to that section to perhaps bring a later amendment to the Dangerous Drug Act, whereby it allows for once the Commissioner of Police expunge your record under that subsection, that the same protection that are afforded to citizens that we propose to afford to citizens in this bill would be the same in terms of persons not being able to rely on it in court proceedings relative to bad character, that they are not able to employers are not able to ask nor demand that you answer those questions. And even if you answer and say that you have no convictions when your record is expunged, then you are not considered to be doing anything that is detrimental, Mr. Speaker. So I urge the Honourable Attorney General, Minister of Justice, and the government to consider leaving that power vested in the Commissioner of Police to deal with the expungement of this under the less than 100 grams, and simply strengthen it by way of a further amendment, perhaps to the Dangerous Drug Act. Mr. Speaker, in relation to the Rules Committee of the Judiciary having to meet to do their part, I want to employ, because many times, Mr. Speaker, even in cases where, for example, a JIPA provides for the Rules Committee to meet and to develop certain rules relative to admissibility in some aspect, there are still some vagueness in relation to, for example, as it relates to a JIPA and how the masters interpret some of very limited points in relation to admissibility of evidence. For example, if statements or disclosure is made and filed in a magistrate's court and is transferred pursuant to AJIPA to the High Court for consideration for a sufficiency hearing, that little loophole in terms of whether those statements filed in the magistrate's court or the district court, as we now call them, whether that would be admissible before the High Court without certain aspect. But the bill provides, AJIPA provides, Mr. Speaker, for the Rules Committee to treat and deal with same. And I'm asking, especially because this bill, Mr. Speaker, would provide for many of our vulnerable citizens, many of whom may not be able to afford to make the applications, to hire attorneys to make the applications and so on, to make just a plea to the Rules Committee to really try to simplify the process to ensure that we have justice not only on paper but in practice, and by way, Mr. Speaker, of a very simplified process so that citizens are able to access it, Mr. Speaker. Mr. Speaker, in relation to the schedule, I've looked at some of in the first schedule, I've looked at some of the excluded offenses, one of which is unlawful wounding. Mr. Speaker, unlawful wounding, they are different in terms of different provisions relative to the Summary Offences Act, where there will be different versions of either unlawful wounding, malicious wounding. They are different, please, Mr. Speaker, in terms of non-malicious wounding, please, Mr. Speaker. That's the wounding in terms of unlawful wounding. Some of these offenses can come from a simple fight. And persons, so let's say a 19-year-old, a 19-year-old, just for example, you have young citizens who may get themselves in a fight. Or you have, even if they are not under the age of 18, but they are young adults, they get in a fight. Some breakage or disturbance in the continuity of skin, and or there's some slice or whatever the case may be, Mr. Speaker. And that person may be convicted and may have been sentenced to community service, or may have been sentenced to a fine, or may have been sentenced for a simple imprisonment for some months. it's very unlikely, Mr. Speaker, that you may find persons in this condition, the charged and convicted of this offence, who would spend significant amount of years in prison unless the aggravating factors are such, Mr. Speaker, that they have done it already. They have been convicted of offences of a similar nature. They show no remorse, that kind of thing. So because of that, I think that offences such as the unlawful wounding, Mr. Speaker, ought not to be included in the excluded offence, to make some opening and provisions for citizens who may find themselves at a very young age getting into these issues and giving them a second chance at rehabilitation, please, Mr. Speaker. Mr. Speaker, I want to suggest that in addition to the excluded offences, that offences under the Representation of the People Act should be included in the excluded offences, please, Mr. Speaker. I think that as parliamentarians, as persons who go through the election process, if we have citizens of this country who threaten the very fabric of our society in terms of how we elect a democratic government and parliament and so on, that if persons are in fact convicted of these serious offences, that this should not be afforded to them. In relation to, similarly, Mr. Speaker, in relation to the third schedule, there are certain professions which I agree 100% with every single profession listed. So you have, for example, in terms of attorneys at law, things sure that if you are applying to be a member of the bar, that you have to meet certain threshold and that you can be considered a person of good character and those considerations. So to be able to allow some citizens to apply to be doctors, dentists, pharmacists, land surveyor, accountants, etc., I agree with that they should be excluded in relation to the professions. So we agree with the fourth schedule. In relation, Mr. Speaker, to the fourth schedule, we agree to the second and the third schedule. In relation to the fourth schedule, in terms of offices of employment, Mr. Speaker, I want to suggest to the government to consider setting an example to this country, whereas, Mr. Speaker, you have this being applicable in terms of these pen convictions not being considered whatsoever in relation to certain offices and certain professions, that under offices of employment, that we include the House of Representatives, Mr. Speaker, and the Senate, all members, so that this too, in setting the example, that we will hold ourselves to the highest standards, Mr. Speaker. So, Mr. Speaker, in all, Mr. Speaker, in principle, we support this bill. I am grateful that the Honourable Attorney General would have acknowledged that the process would have started in 2022. It is better late than never. It is good law. It was good law then, Mr. Speaker, and it is good law today. Mr. Speaker, this is what we must do as representatives, not look for the petty issues, Mr. Speaker, but when we ensure that it's in the best interest of the citizens of the Republic of Trinidad and Tobago, that we come together, we lend our support to strengthen bills, to produce proper legislation. And with those few words, Mr. Speaker, I thank you very kindly for the opportunity to contribute to this debate. Thank you very much.
Maharaj,
Thank you very much. Thank you very much, Mr. Speaker, for giving me the opportunity to rise in this very important debate that deals with a very progressive piece of legislation, one of a kind that has ever reached the attention of this Parliament. And it took a United National Congress government to bring such a piece of progressive legislation. To do what, Mr. Speaker? This bill The aim of this bill, the ultimate aim, is to give persons a second chance. That's what the bill does, you know. It gives them a second chance at life. The People's National Movement has been in power for many, many decades in this country. Many decades. And the law as it stands is that as soon as you have a conviction on your name, it appears on your criminal record. Any conviction. Once a court of law, criminal jurisdiction, has a sentence, a conviction, it appears on a person's criminal record. Many persons go for a job. They apply for a certificate of character. And when they present a certificate of character, and it appears that the person has a criminal record, the reality is that the employer is going to be very hesitant to hire that person. And many a times, Mr. Speaker, this applies to very young people. Offenses that they may have committed while they are under the age of 18, not fully appreciating the risk in terms of their behavior when they become an adult and they can work in the workplace and so on. But we as a government appreciate that fact. And that is why we decided that this is going to be one of the first pieces of legislation that we bring to this Parliament to give, in particular, young people a second chance at life. Those opposite wasn't taking that on, Mr. Speaker. As much as they talk about that they were trying to fix the criminal justice system and so on, they left it a grinding halt. Right now, I believe the Minister of Justice buy up all of the WD-40 in this country to try to loosen up the wheels of justice. The rusty wheels of justice. He is trying to grease the gears so that the criminal justice system can be moving and working again after my colleagues opposite have crashed it because of mismanagement in the last 10 years, Mr. Speaker. In the last 10 years. Just 1 year into government, the Ministry of Justice, the Ministry of the Attorney General, brought several pieces of far-reaching legislation that will assist judges, litigants, attorneys at law, the prison service, and other arms of the protective service in trying to get the criminal justice system into a place where we would like it to be. This bill is one. This bill is one, my colleague is reminding me, where many developed countries, where we would want to be, have introduced certain measures like this to give people a second chance. Because when the young man or the young woman who cannot get a job because they may have committed an offense in their earlier years, you leave them on the streets. You leave them idle. And what happens with idle hands? What happens? This bill is telling you, okay, for a period of time you have behaved yourself. We understand you have a conviction, but you behave yourself. You have rehabilitated yourself on your own, which means that the propensity to offend again may be very low. Measuring all of those factors, putting it into a piece of law now is saying that, listen, we will clear your record, go out and work. Go out and work. Go and look for meaningful employment. Don't continue a life in which you would have impulses to commit criminal offenses. Don't do that. Go and have meaningful employment. So therefore, what the bill does is gives those people that second chance. And it is clear. When you look at clause 6, in particular subsection 4 and 5 of the bill, it says this. Notwithstanding subsection 1, where a person under the age of 18 years at the time of conviction of a summary offense has not been convicted of any other offense between the time of his 18th and 21st year, or an indictable offense and has not been convicted of any other offense between the time of his 18th and 23rd year, then for the purpose of this act, that person shall be treated as a rehabilitated person. And it goes on. And the conviction shall either in any case be treated as spent and subject to subsection 5 shall be expunged from the record and no application is be required to be made under section 15. Subsection 5 now says that the parent or guardian or the person can make an application to the Commissioner of Police for the expungement of the criminal record from that person's name. So we put it very clearly here that the young people are at the center of this government in terms of giving them that second chance. We put it in law. What they did they do? You allowed people not to have jobs because they could not get a particular period of their sentence expunged in terms of their criminal record or something. They didn't do it. You know why they didn't do it? Because they were busy doing other things. They were busy taking care of the big boys and the big girls. They wasn't studying the young man and the young woman on the street. They were busy ensuring that, the big boys and the big girls pocket fat, while the young people pocket empty. But we have said on this side that when the UNC wins, everybody wins. When the UNC wins, everybody wins. And this piece of legislation here, Mr. Speaker, is twofold. We are saying, one, that after the effluxion of a particular period of time, your conviction is considered to be what? Spent. When the conviction is spent, the court will then, after an application is made to the court, will then expunge the record. And in the cases of children, the power vests in the Commissioner of Police. You know what their solution to all of this was, Mr. Speaker? They're boasting about this dangerous drugs thing, about this dangerous drug act, and how it would have been so marvelous, it would have freed up all of these cases and spaces in the criminal courts. And they talk about the Commissioner of Police would have been able to expunge convictions and so on from the records of individuals who would have been charged and convicted. I'll give you the statistics, Mr. Speaker. But what they did is that they were encouraging young people to engage in the smoking of marijuana. That is what they were doing. That is their policy, What we are going to do, Mr. Speaker, and the Prime Minister is very clear, very, very clear about this, because we are looking at the science of it, that we are going to increase the age of the use of marijuana. 25 years old. 25 years old. You all didn't want to do that. But I'll tell you, my friend from Laventille West was boasting. We should leave the power in the Commissioner of Police to expunge the criminal records. That's what he said. Leave it in the Commissioner's hands. Well, your very own former, and maybe former Attorney General, the one who lies a lot, Reginald Amo. Sorry.
There's no need for that. No need for that.
Mr. Speaker, I take your guidance. Yeah. The one who is internationally known, Mr. Reginald Amo. Guardian article, Mr. Speaker, dated the 9th of September 2024. Guardian article, 9th of September 2024. AG, this is Reginald Amo. 45 people had marijuana charges expunged since December 2019. 19, 20, 21, 22, 23, 24, 45 persons. After you were saying it was so easy, Laventille West, you just had to write the commissioner and he will expunge your record. Just write him and you'll see how quickly it could get done. The next morning, you'll go and apply for a criminal record and it will get done. That is what he said. So it's very difficult to believe the submissions of my colleagues opposite, because the article goes on to say this, Mr. Speaker. It says that before the Act's proclamation, it talks about, this is the Dangerous Drugs Act, former Attorney General Faris Al-Rawi had stated that the law could benefit over 85,000 people who had been charged with marijuana possession over the past decade, as well as 101 incarcerated individuals, including 14 children in rehabilitation centers. In response to a question from Independent Senator Paul Richards about how many persons benefited from this provision, Amos said, and the article quotes, "As it relates to non-prisoners, the Trinidad and Tobago Police Service has informed us that to date, 46 applications for expungement have been received. Of these, 45 have met the criteria, were processed, and have had their records expunged. One remaining application is pending clarification regarding the quantity of drugs involved in the charge. Efforts to resolve this issue are ongoing." No, but leave it in the commissioner's hand. Because my friend opposite from Laventille West is saying, you just write the letter. A friend can help you write the letter. The commissioner will watch the letter, and in the morning you go back, apply for your record, and the conviction or the charge is gone. And they want us to believe that when on the public record, their own Attorney General is admitting only 45 persons benefited from that from 2019 to 2024. Rubbish. We are using here, Mr. Speaker, a modern framework where we are giving the independent judiciary under rules of court, under a particular legislative framework for a judge in the High Court to determine whether or not to remove the record from the criminal records of the individual. So therefore, you can see things might be happening a little faster. These applications, Mr. Speaker, you very well know, is not contentious. They may very well be heard in chambers, and a judge can decide these matters in chambers. Very, very simple matters. It's not complex. Unless you require additional evidence and so on, then you may have a hearing. But these are matters that can be determined in chambers. So what is the complaint? What are you upset about? We are saying leave it in the hands of the judiciary. Because when you look at section 50, clause 15 of the act, of the bill, it talks about the procedure. Subject to this part, a spent conviction of a rehabilitated person shall be expunged from the record. A person who has completed his rehabilitation period and is eligible to have his spent conviction expunged in accordance with this act may make an application to the High Court for an order that his spent conviction shall be expunged from the record. And the act goes out to explain everything. One, it must be made in writing and include the following: full name and age of the applicant, the offense of which the applicant was convicted, the sentence imposed by the court in respect of that conviction, the date and place of that conviction, the court before which the applicant was convicted, the date on which, where applicable, the applicant completed the serving of the sentence, and shall include the date on which any period of disqualification, disability, or prohibition ceased, and the extent to which any condition attaching to such sentence has been complied with, the date from which the conviction was treated as spent, any other written representation on which the applicant relies in support of his application, and any other relevant information as may be required by the rules of the court. So this is not a complex application. This is not a difficult, groundbreaking application. We understand that persons who may have been convicted may not have the means. My friend talked about legal aid and so on, public defenders and so on. But the legislation itself is making it a very simple exercise and application to go before a judge. Very simple, very, very simple. And you know that based on the rules of court, there will be set deadlines for compliance and so on. And therefore, you can track the application before a decision is being made by the High Court. So I can't see why my friend is so concerned that we are removing the jurisdiction of the commissioner and putting it into the court and so on. Now, you see, I wouldn't go down that road when it comes to Commissioner of Police and the PNM, Mr. Speaker, because they have a penchant for determining who should be commissioner, who will be commissioner, interfering with the process and so on. And we are not engaged in that kind of behavior on this side, Mr. Speaker. Because one day Bliss had the list and the next day Bliss gone with the list. The list gone? Yeah, right? And they're gone. Now, Mr. Speaker, they have another clause here, 17, that he wants us to remove clause 17 and so on, and he has an amendment. My friend from Laventille West, I have not seen the amendment circulated. Hopefully we'll see that amendment and we will treat with it then. then, Mr. Speaker, I think it's very beneficial for the listening public to understand what we are doing here. At Clause 4 of the bill, it says this. 4.1 says, notwithstanding Section 6, this Act shall not apply to a person convicted of an offence set out in the first schedule. Now, when we go to the first schedule, it lists several offences here. Several offences. It lists murder, so this bill will not apply to murder. It will not apply to treason. I'll get back to treason. It will not apply to piracy or hijacking, conspiracy or soliciting to commit murder, manslaughter, shooting or wounding with intent to do grievous bodily harm, unlawful wounding. You know, my friend is saying, Mr. Speaker, that we should remove unlawful wounding from this list. I don't know why. I find that is a very serious offense of unlawful wounding. If somebody is convicted of that, he said, no, we should still pardon somebody of that in terms of this particular bill. That is what he's saying. Assault occasioning bodily harm, robbery, robbery with aggravation and armed robbery, arson, kidnapping for ransom, knowingly negotiating to obtain a ransom, rape, grievous sexual assault, sexual intercourse with female under 14 years, sexual intercourse with female 14 and 16 years, sexual intercourse with male under 16 years, incest, sexual intercourse with adopted minor, sexual intercourse with minor employee, sexual intercourse with mentally subnormal person, trafficking in a dangerous drug, possession of a dangerous drug for the purposes of trafficking, possession of more than 100 grams of cannabis or more than 14 grams of cannabis resin, offenses under the Anti-Terrorism Act, Firearms Act, Trafficking in Persons Act, Proceeds of Crime, Interception of Communications Act, and several sections of the Children's Act, Chapter 4601. And all of these offenses, as listed as 31 excluded offenses in Schedule 1, are very serious offenses. So as a government, we believe that persons who have committed these offenses ought not to benefit from this particular piece of legislation. This is really to help those persons who can face a series of rehabilitation and so on with respect to less serious crimes, that they may have committed. Now, Mr. Speaker, I want to get to a particular offense here. And my friend says in his submission that we should include an offense under the Representation of the People's Act in terms of offenses that deal with threatening the democratic process. And that offices of employment should also include members of the House of Representatives and so on. Now, I want my friend to be very careful when he makes submission like that. Because treason is a criminal offense. In fact, treason is defined as a person owing allegiance to the state who, whether in Trinidad or elsewhere, forms an intention to levy war against the state or to overthrow the government or the Constitution of Trinidad and Tobago by force and manifest such intentions by any overt act, and that person is guilty of treason and is liable to suffer death by hanging. That is the offense, and that's the sentence. Now, my friend has to be very careful when making such a submission like that. Because there's information that may have suggested, I'm reliably informed, that on the night of the elections, on the 28th of April 2025, that there may have been communication by certain persons in Trinidad who may not have appreciated the results of the democratic process and may have conspired with persons belonging to criminal gangs to interfere in the democratic process. So I want to warn my friend from Laventel West that when he makes those submissions, he must be exceedingly careful, because the information suggests that those types of conversations and communication may have been happening on the night of the election. My friend has to be exceedingly careful, Mr. Speaker, because if somebody is convicted of treason, know that is a record for life. And know that the sentence is death by what? By hanging. So you must be very careful when you make those submissions. Because treason is something you must tread very lightly with. Must tread very lightly with. You cannot, because you don't like the results of a particular election. Because you don't like the results of the election, that you are going to engage in communication with the criminals in this country to undermine the democratic process that would have taken place, that you participated in. So again, Laventil West, be very careful of the submissions that you make. Be very careful, because we probably know more than what you think we know. Right? We probably know more. And I'll leave that right there, Mr. Speaker, because there may be more to come on that particular conversation. There may be more. There may be more. So persons who engage in that conduct will not be beneficiaries of this particular piece of legislation. We must set a proper example in this country, Mr. Speaker, that persons who engage in that kind of conduct will not benefit from progressive pieces of legislation like these. San Fernando West, you're not too smart to do them kind of thing. So, San Fernando East. You're not that bright. Now, Mr. Speaker, when you look at the bill and the construct of the bill, it deals with this. It deals with what is determined as a rehabilitation period. Now, in court, somebody applies for bail, somebody is making a plea in mitigation for a sentence and so on. Once you realize that the offense is 10 years or older, no weight really is attached to that. But in this case, what we're doing is that we have truncated periods of rehabilitation based on Section 8 when read together with the second schedule of the bill. So in Section 8, it deals with the periods of rehabilitation and what is determined as a spent sentence. So a non-custodial sentence, the rehabilitation period is 3 years, for a sentence of imprisonment not exceeding 6 months, 5 years, a sentence of imprisonment exceeding 6 months but not exceeding 18 months, 8 years, and a sentence of imprisonment exceeding 18 months but not exceeding 3 years, 10 years. So we have looked at various periods in which a person will be considered to be rehabilitated. And after this period of rehabilitation, only then they make the application to have their criminal record expunged from the Criminal Records Office. And there are other criteria, Mr. Speaker, with respect to this, and the Attorney General would have gone through most of it in terms of his presentation while he was piloting this particular bill. Mr. Speaker, it also goes on in terms of we have to be very practical when we deal with this bill, because we cannot have a system where we are asking the court and the Commissioner of Police simultaneously, when the court makes the order for the expungement, that you serve the Commissioner of Police with the order to remove it from the person's record, but it doesn't appear on the record. Again, another major step that this government took under the Ministry of Artificial Intelligence and Public Administration is that they introduced something called Verified TT under iGov. And Verified TT would have recently entered into a memorandum of understanding with the Trinidad and Tobago Police Service. So now that you can have your certificates of character, your COC, being issued in an electronic format. That is progressive governance. That is progressive governance. If someone sees what a COC looks like, is a receipt, you know, with a blue stamp on it, right? Yes or no, right? We are doing a progressive piece of work in terms of having you issued with an electronic COC certificate with a barcode on it. So therefore, the person who it is presented to can verify the authenticity and also verify that this is an authentic, real document and up to date, because it will also have a stamp in which it was issued, the date it was issued. And I want to commend Minister Dominic Smith. I want to commend the member for Tunapuna and the board of IGOV and the public servants in IGOV for such a progressive move. These progressive moves, Mr. Speaker, could only happen under a UNC government. A UNC government. They have had us backwards for over 10 years, Mr. Speaker. Over 10 years. Over 10 years. Then, Mr. Speaker, we have another application, another submission being made by my colleague in terms of he agrees with the third schedule, but he wants to also deal with the fourth schedule. And I think it's important to address the professions and the offices of employment in the third schedule. Now, once a person's record has been expunged, it doesn't appear. But what the bill does, Mr. Speaker, is this. At clause 11, it says this, that there may be disclosure in limited circumstances. At clause 11, it says, a person shall, if requested to do so, disclose in relation to himself particulars of any specific conviction. A, when seeking to be made a member of a professional body of any of the professions specified in the third schedule. B, when seeking to be appointed to any office of employment specified in the fourth schedule. Or C, when seeking to become engaged in any business of the type specified in the fifth schedule. And let's look at what those are. It deals with 1, attorneys at law, 2, medical practitioners, veterinary, surgeon, dentist, optician, pharmacist, land surveyor, certified or chartered accountant, teacher, registered nurse, and registered midwife. So, for example, the doctors and the lawyers and so on, they have pieces of legislation that govern, such as the Legal Profession Act and the Medical Profession Act and so on, that regulates conduct and discipline of those persons. In respect of the offices of employment, disclosure is required for the civil service, the JLSC, educational institutions, including schools, private schools and special schools, healthcare and medical institutions. The police service is important. I think that is very important. Hotels, insurance companies, banks, juvenile correctional centers, security service organizations, and unit trust schemes. But because these things are disclosed, Mr. Speaker, it doesn't mean that the persons are denied from employment. It means that there is now full appreciation of the character of the person. In fact, they have looked at the legislation and they would have gone through that period of rehabilitation if they don't reoffend and so on. And therefore, I think it's very important, especially in those types of professions, that this particular disclosure is made when it comes to these matters. Because when you look at the nature of businesses, such as dealing in bonds and other securities, firearm dealers, stockbroking, real estate agents, and security service organizations. And then here again, Mr. Speaker, my friend makes another interesting submission. He said, under offices of employment, we should include members of the House of Representatives. And I assume that he also means senators, that he should include persons in those employment, elected and maybe appointed persons who represent and make laws and so on in terms of records. Now, Mr. Speaker, there's a very serious offense in this country.
He's baiting you.
My friend from Oropich East is saying that I'm baited. I don't know what he means by that. But, Mr. Speaker, there's a serious offense that deals with witness tampering. Misbehavior in public office. Now, if a person, let's assume a member of parliament, a senator, engages in conduct such as witness tampering, hypothetically, of course, engages in conduct of telling a witness what to say, putting in the witness statement what she wants the witness to say, advising the witness what he should put in the statement, and then sitting as a judge and jury in a tribunal or whatever. That is misbehavior in public office. That is witness tampering. Now, my friend is lucky we don't have that offense in the first schedule. It's not an excluded offense. So maybe somebody who is convicted of that may still be able to serve on the PNM benches, but they wouldn't be able to serve on a UNC bench. They wouldn't be able to serve on a UNC bench, right? They will not be able to serve on the bench. So again, my friend make a submission about thwarting the democratic process and treason and so on. And I want to tell him to be careful. I want to tell him to be careful of making submissions by including members of the Senate and House of Representatives here.
Barataria?
Yes, sir.
Your normal time is up. Do you want 15 minutes?
To speak up. Because what may end up with my friend is that he may very well bait somebody to fall in the hole that he dig in. You may very well do that. So be very careful, again, Laventil West. I mean, you're a young man in this house, with the submissions that you make. Because your words here are recorded for history on the Hansard. Now, Mr. Speaker, there are other particular matters in the bill that deals with the custody of the records and so on. And you see, San Fernando East, you may not appreciate what we're doing here. So you should listen very carefully. There's a lot of words, there are a lot of sentences, and there are a lot of pages in this bill. Spend your time reading. And big words and so on. Now, Mr. Speaker, there's also a part of the bill that weighs in terms of confidentiality and so on, that deals with clause 21, in terms of unauthorized disclosures and so on. I know I may not have the full appreciation or all of the information may not be seized of it, but I believe that one individual may have brought a case against the state with respect to certain information that the police would have had on their record, and that would affect certain transactions and so on that persons make. Those matters, Mr. Speaker, we have treated within this particular piece of legislation when it comes to unauthorized disclosure and so on of persons' criminal record and official record, specified information and so on. Mr. Speaker, we also look at clause 22 in terms of the exclusion of employment and so on. And those are very, very important safeguards that are included in the legislation. And at the last clause, at clause 28, it deals with the Attorney General being given the power to make regulations. And my friend always complained about this, that we are only they're accusing us of bringing legislation with negative resolution. In this case, Mr. Speaker, clause 28.2, the Attorney General may by order, subject to affirmative resolution of Parliament, vary the circumstances in which spent convictions may in fact be disclosed. So that will also have this parliamentary scrutiny when it comes to those regulations that govern that particular part of the legislation, which is very important and deals with issues of privacy and confidentiality. Mr. Speaker, I want to lend my support to this piece of legislation. I want to commend the Attorney General. I want to commend the Minister of Justice, also the Minister of Homeland Security and Defense, and most importantly, our Prime Minister for ensuring that this piece of legislation, Mr. Speaker, would have seen the light of day to find itself in this particular Parliament, Mr. Speaker. And therefore, this piece of legislation is commended for all to support because it is progressive, it will help the young people, and most importantly, as I started, Mr. Speaker, it will give persons a second chance at life. I thank you very much.
St. Anne's East. Yes.
Thank you kindly, Mr. Speaker. It is an honor to be able to stand in the House and to contribute on what I think is a very important piece of legislation. This Criminal Records Rehabilitation of Offenders Bill 2026 acknowledges the potential for rehabilitation and renewal among our citizens. And, Mr. Speaker, everyone on this side agrees with that concept, every one of us on this side. And as an MP, it is a normal thing, Mr. Speaker, to encounter persons who, from time to time, have been affected by the long shadow of criminal records. And it happens in all spheres of life, Mr. Speaker. You meet people who speak to you about their experiences. For example, there's a parent who came to me some years ago about her son. She is spending her pension to support him because he was released from prison and cannot get a job at this time. I also experienced a father coming to me. Very sad situation because the family is now broken. His wife stayed with him during the time of incarceration. However, when he came out, she expected that things would improve. Things actually did not because he could not be employed. So while she would have spent her time supporting him while he was inside, when he came out, the family broke up, and it was a very, very, very sad situation. I've spoken to many young men in particular, who come to me because they are turned away from even menial employment because of the requirement for a certificate of character. And once they see that, they don't even bother to apply because they know the prejudice, they understand what they're going to face, and having gone through it a couple of times, they are demotivated. And they speak openly, in some cases, about the draw of illegal activities because of their inability to earn, even when they attempt to follow the correct path. And some of them are very open about it. So we support the principles of this. And this type of legislation, of course, we are walking a well-trodden path. It is found in the CARICOM, the Commonwealth, and beyond. And I want to say that this is legislation, as admitted by the mover and by the second speaker of Barataria San Juan, that was developed by the PNM and is now taken forward by the UNC. Mr. Speaker, the UNC has come into this House on a number of occasions to speak about what the PNM planned and did not implement. And of course, the member for Barataria San Juan didn't disappoint, always ready with the triviality and the bacchanal and the accusations and the puerility, failed bus marks. Mr. Speaker, someday his politics may mature, and we look forward to that. We live in hope. We live in hope. We are in a very serious discussion that has very serious implications for young people, especially. A very positive piece of legislation. And, you know, the member argues for about 10 to 15 minutes into this vague, vacuous, pointless discussion about treason. Mr. Speaker, we on the PNM side are serious politicians, and we reject the politics of innuendo. Whether it's engaged in by Barataria San Juan or the member for Tocos and Grande, who is another one that loves to do that, come here with substance and not bacchanal. We're not here to waste time. We're here to discuss the business of the people. Mr. Speaker, the PNM implemented a robust legislative agenda that would have continued if we were still in government. And that is clear because 1 year into the UNC's term, they're still implementing PNM policies and plans. Mr. Speaker, a good government plans ahead for today and for the period and leaves a legacy. And therefore, I want to tell you, the member for Barataria San Juan, that is what progressive governance is. He mentioned it many times. I am glad that the UNC is seeing the example of what progressive governance is. The PNM is not even in office, and we are helping the country to progress by our legislative agenda. That's why you have to say great is the PNM, Mr. Speaker. Mr. Speaker, continuity of policy is important. It is important, and it is the only way a country can really progress. So it is clear that the PNM was progressive in our legislative agenda, progressive in our planning, and it is to the UNC's credit that you are following the plans that we put in place. Good legislation must be brought to the Parliament. You met it there and you brought it. Kudos to the UNC, and we in the PNM are happy to support good PNM legislation, as we have to. Mr. Speaker, We have had similar legislation being enacted in the United Kingdom. Since 1974, they have had this type of legislation. They amended it in 2023 and made some changes to accelerate reintegration. In Jamaica, since 1988, they have had this type of legislation. Barbados would have introduced this in 2025. And countries such as Canada and Australia, they've had this as well, this spent conviction system. So we are going down a beaten path, a well-trodden path, and a progressive path in Trinidad and Tobago. In terms of the key features of the bill, it makes provision for certain criminal convictions to become spent after a specified rehabilitation period. So those who have demonstrated genuine reform can have their record treated as clean. Mr. Speaker, some constituents have expressed to me some concern because they fear that this will turn criminals free on the street. And that is understandable. If you just look at the bill without understanding and seeing the different clauses, then you may not get the exact purport and understand that it is not all criminals that this is that will be eligible for this. And I want to let those who have concerns understand and be clear that this legislation was well drafted by the PNM, and therefore we have taken care of all those things. UNC has brought it, and so those guidelines were in place to deal with all of this. So those who have fear, they don't have to worry about it. The PNM took care of that when we drafted the legislation. In Clause 8, it speaks to the clear rehabilitation periods which are based on the nature of the sentence. And that is important because then the schedule breaks down what is not eligible for the expunging of the records. Clause 6.4 speaks to the automatic expungement of some offences committed by minors. And once they remain conviction-free for that qualifying period, they are automatically given the opportunity to expunge, and then that automatic expungement is important for the young people. And I'll come back to that a little later on as I speak. Clause 22.1 speaks to strong penalties for employers who discriminate against persons with expunged convictions, and I'm going to come a little bit later to deal with that as well. And Clause 21 speaks to strict protections against unauthorized disclosure, which is important in our current environment of social media and what can get out there. So that is also good provisions that can serve to protect the bill. I want to deal a little bit with the social and economic impact of this bill, Mr. Speaker, because that's important, especially for persons who are not necessarily legal professionals looking on to see what would be the benefit of this bill for not only the persons involved, but for society. In terms of this bill, it addresses the root causes of crime. Lack of economic opportunity, Mr. Speaker, is one of the causes of crime, not just crime, but also it contributes strongly to recidivism, which means that persons may come out of prison, serve their time, and because they don't have economic opportunity, as I was alluding to, when some young people come to speak to you, they don't have opportunity, and therefore the draw of the illegal becomes stronger, even though they try to fight it. But the fact is that they are realities. Some of them have children, they have families, and they have to take care of them. And when they cannot get employment, as they say on the right side of the law, then the illegal becomes much more attractive to them. So this bill addresses that because it allows for an easier pathway to opportunity, I should say, for employment. And the evidence from the other countries that have had this type of legislation enacted before, it shows that these policies increase workforce participation, which is good for the country because it means that we achieve the potential of having our citizens work for us, and that increases the potential of a country, economic and developmental, and it reduces recidivism, contributing to safer communities. Another benefit of this type of bill, it strengthens families and communities. I spoke about the example of a family that broke up. A wife was waiting for her husband to come out, hoping for better days. When the husband came out of prison and could not get a job, then that was it. Family broke up. Problems for the children. So where you have a bill that is allowing an easier pathway to employment for those who have been in prison and can get their records expunged. It strengthens families and communities because it gives the person a time to be able to make up and to help their family and strengthen the unity and the stability and the prosperity. And as we know, Mr. Speaker, stronger families, stronger communities, stronger nation. Another impact, social impact, is that it improves outcomes for children and breaks the cycles of crime. Mr. Speaker, when parents have access to better employment, the children benefit, the family structure benefits, and therefore it reduces financial stress in the household. You can ask any teacher and they can tell you, children who perform poorly, there's a link between socioeconomic stress on a family, financial stress, and the way children are able to perform in school. Many times, the children who perform the worst have serious financial strain in the home. It causes anger, it causes frustration, and so sometimes what the parents are going through, the children exhibit it in the classroom. Any teacher can tell you that. And so anything that will help families to be able to have a stable income will increase their stability and break intergenerational cycles of poverty and crime. So this legislation has the potential to realize a true second chance, to use the language of Barataria San Juan. That is what it does. It includes a second chance opportunity, and that's why it was important to the PNM to draft it as well, because we understood that if we are reforming the system, it has to involve that. Mr. Speaker, it is restorative justice in practical form. It allows those who have transgressed an opportunity now to contribute to the very society that they would have transgressed against and be able to make a positive contribution. It correlates with lower recidivism rates and higher employment success for ex-offenders. And it has been shown to reduce reoffending by up to 30% in jurisdictions that pair rehabilitation with employment pathways. And I want to repeat that pair record rehabilitation with employment pathways. And this is where, Mr. Speaker, I want to spend a little time speaking about the gap between the law or the legislation and the lived reality. Mr. Speaker, a law like this will bring great hope to many who will benefit from its provisions, not just the actual persons who will benefit, but their families, their communities. It will bring hope. And many of these will be young people. The major hope that it will bring is that they can now more easily gain employment. Mr. Speaker, as a member of Parliament, I can tell you, people come to see you. If you see 10 people in a day, 8 of them are about employment, especially in this time right now, Mr. Speaker. Right now is a very, very difficult time. Many people have been sent home. Many people have no options. And within that April 28th to now, Mr. Speaker, I can tell you it has tripled in terms of the number of people that are coming to you with issues. And where there's problem for employment, there's going to be an increase in those who are lured into illegal activities. So many of the people who understand what this legislation is will feel hope because they have an avenue to gain employment. However, Mr. Speaker, the law is necessary, but it is not sufficient. There has to be an ecosystem of support created around this legislation to be able for individuals to benefit from exactly what the provisions intend. And I will explain a little bit more about that. If we want what it intends, which is reduce recidivism and increase productivity from those citizens who would have been debarred from the working class, then there needs to be more that has to be applied with this legislation to ensure that it has its intended effect. And there are 3 issues. The first issue is the inability of citizens with spent records to avoid employment discrimination. Mr. Speaker, the bill speaks to penalties for those who debar persons with spent records from gaining employment solely on the basis of their expunged criminal records. That's clause 23.2, and it mentions a fine of $100,000 and 5 years imprisonment. So there's a heavy fine, and there is the threat of imprisonment that goes along with discriminating against persons who have a criminal record and have had that record expunged. But what is the reality of this, Mr. Speaker? I want us to think about the persons who will have to undergo this. Trinidad is a small country. So someone may reasonably go for employment in an area. They have the expunged record, so that is not mentioned in the application. But it is very probable that someone in the company may know them, may be living in their community, and they may whisper a word to someone in the HR department. That's not an unheard of situation. We're not in a big country where you can go to a different state and it's like you're going to a different country. So it's very probable that even with an expunged record, someone can tell in an area, in a company, that you have been in jail. And that might lead to discrimination, just like what the law imagines and puts a penalty against. However, if that person does not get the job, and they believe it's discrimination, Mr. Speaker, what's the process for them to pursue this? To pursue this, they have to get legal representation. Even if you go to legal aid, it's a long process, we know this. And if you are contemplating a private action, then you have to engage a lawyer and all of that. Mr. Speaker, it is not within the realm of someone in that position to get easy representation for this matter, even though the law provides penalties for it. The member for Barataria San Juan spoke about how simple it is to even get your records expunged. Mr. Speaker, the reality is that there are many people, from the time you speak about legal action and a lawyer, they shut off because they understand that that is quite beyond their capabilities. And so they don't even bother to pursue it. And Mr. Speaker, this is what will take place with many people, even with your record expunged. If you get to that point, if you are discriminated against or you believe you are discriminated against, getting the required assistance, that is a barrier that many will not be able to surmount. So to deal with this issue, the suggestion, Mr. Speaker, is that the government links that provision with specific assistance to help persons who believe that they are being discriminated against to get legal representation. Just like my colleague from Laventil West spoke about the assistance to get their records expunged in the first place and putting something in place for that. It needs to do that and go further so that if there are discrimination cases, those persons can get assistance. Because if not, Mr. Speaker, even with the penalty there, you can raise it to 5 years, you can raise it to $1 million in fine. If no one is able to prosecute the matter and get justice, then it really comes to no account. And I'll give some examples of what exists in other jurisdictions later on. What I'm speaking about is not reinventing the wheel. Other jurisdictions have linked their rehabilitation legislation with assistance in this way, creating that ecosystem of support which I'm speaking about. So again, Mr. Speaker, I'm saying that the law itself is necessary, but it is not sufficient. The second issue I want to deal with, Mr. Speaker, is the importance of linking a spent record systems, or that systems of record rehabilitation, with employment pathways. As I just discussed, Mr. Speaker, employment discrimination, in spite of the legislation, is entirely possible. Very, very probable. We know the stigma. We have a small country. People talk. People know each other. And that's entirely possible. So the government, if we want to achieve the intent of the legislation, it's important to link it with programs to assist with employment, to ensure that the intention of the law become a reality. Remember, this law is going to be looked upon with a lot of hope. People are going to feel, yes, I can get employed now. That blur on my record, that comes off, I can be employed. And if that is not realized, dashing those hopes could have serious consequences. In the US, Mr. Speaker, I want to go through a couple of things that they have done to link the rehabilitation with a pathway for employment. The US Department of Labor has a Reentry Employment Opportunities Program, and they fund this program, and it is directed specifically at formerly incarcerated adults and justice-involved youth to help them gain skills and employment. So there's a program run by the Department of Labor that is targeted to give training and employment to those who were formerly incarcerated. The American Job Centers. These centers provide specialized free career services, helping them with resume building, job search assistance, and access to federal bonding. And I'll go to what the federal bonding is. So you have the Department of Labor doing something. You have American Job Centers, a career one-stop, which helps with career guidance for those who have been incarcerated. You have the federal bonding program, and that is a government program that provides 6 months of employment for at-risk employees, including those with criminal records or spent records, and assists them now to get into the job stream. Then you have the Work Opportunity Tax Credit, where employers who hire individuals that need a second chance, they get a tax credit so that it makes it more attractive for them to be able to do that. And then you have the Clean Slate Clearinghouse, a joint project of the Department of Labor and the Department of Justice. And that is where it helps them to go through legal procedures to get their records expunged and to assist them with employment. So I have gone through 5 programs offered by the US that help to contribute to this ecosystem of support that goes along with the legislation, helping those to really achieve the intention of the legislation. So as I said, the legislation is necessary, but it may not be sufficient so that those who really have to lean on its provisions would be able to get what it intends. So there must be targeted intervention by the government. We have to go a little further than just legislation to ensure that the intention of the law becomes the reality and the lived experience of those that we expect to benefit from it. I'm moving to the third issue, Mr. Speaker, which is the importance of linking a spent record or an expunged record with training opportunities. Mr. Speaker, youth crime has been a reality in Trinidad and Tobago for some time, as it is around the world, but we have a specific problem in Trinidad and Tobago. As late as 2023, the then Commissioner of Police was quoted as saying 50% or even much as 60% of violent crime is committed by young people under the age of 25. Now, the provisions of this bill does not generally contemplate expunging records of serious violent offenders. However, youth are very involved in crime, sadly, in Trinidad and Tobago, and therefore, the ones that will be affected by this bill, many of them will be young people. And they stand to benefit a lot. And that is why we are happy to see this bill come to fruition, as it was in planning by the PNM. However, many of the young people that stand to benefit from this law, when it comes into practice, many of them are not educationally equipped for sustainable employment. We have a number of studies done by the Parliament even years ago that show this, and the situation has not necessarily gotten better. There are a lot of young people that will benefit from this legislation, have their records expunged, but they don't have the skills to be able to find sustainable employment. So they will be technically employable, but practically they will not be. And that is a serious gap that requires the attention of the government if the intent of this bill is to become a reality. And that is why, Mr. Speaker, it is critical that youth training programs be linked to this rehabilitation legislation. And that is why, Mr. Speaker, the absolute shutting down of the youth programs under the UNC is regressive, objectionable, and does a disservice to the youth of Trinidad and Tobago. Mr. Speaker, in the debate that would have happened in this House on the Parole Bill, the Minister of Justice made heavy weather of the rehabilitation in prison. And he spoke about the fact that the UNC was going to put a lot of emphasis on building out that rehabilitation in the prisons. Mr. Speaker, the PNM was not waiting to rehabilitate people when they were in the prisons, you know. The PNM took preventative action. The PNM introduced an entire Ministry of Youth Development to ensure that before our young people could get involved in anything, they had those abilities to be able to be trained, to have skills, to be involved in positive engagement. We don't want people to get in the prison to rehabilitate them, Minister. We want to ensure that our young people have opportunities even before. And that is where the PNM was heading. And I take strong issue to the fact that in the 1 year, since April 28, member for Barataria San Juan, you're talking about treason. In the 1 year, there has been a total shutdown of these programs, Mr. Speaker. Where are our young people? Where are our young people to get the opportunity for positive engagement, to stop them from getting into the prison, to stop them from getting into skirmishes, to stop them from getting into a position where they will need to have their records expunged, and therefore you're not doing that. If you are not allowing our young people opportunities for development, then you are basically allowing them and leading them into a life of crime, Mr. Speaker. That is reprehensible for a government to do. Reprehensible, and they can say what they want on that side. That is your legacy, and that is your record. Mr. Speaker, our young people need the programs that are offered when we have a working Ministry of Youth. And there is a minister over on that side that has the responsibility for that. And we say, Mr. Speaker, get to work and help our youth to develop so they will not need to be rehabilitated. They will not need to have a record. Catch them before they get there, Mr. Speaker. We don't want you to wait until they get into prison to rehabilitate them. We had programs, and these are the programs that I suggest be reopened so that we are able, Mr. Speaker? I beg your protection.
Let the member continue in some silence, please.
Thank you. Mr. Speaker, in order for young people who benefit from this legislation to be able to get the skills that they need to have sustainable employment, they need skill training programs. And that will benefit not only them, but it will also benefit the thousands of young people who require a second chance, who have not been in prison. They may have been in school with different circumstances, but they need a second chance before they get to prison. And therefore, I am suggesting that some of the programs that were existing be revisited and paired along with this legislation to...
You have 15 minutes.
Sure. Sure, Mrs. Speaker. So I suggest that we reopen some of these programs so that those who have expunged records, young people, can have the benefit. Programs such as the UTech vocational training, which offered short courses in makeup artistry, culinary arts, preserving and pickling, barbering, hair braiding, weaving, and nail technology. That was present for young people. Bring it back, Mr. Speaker. Bring back. Well, not even the old time days. It was just a year ago they had it. Bring back Amplify, which gave our young people training in music production, video editing, digital photography, graphic design, voice training, stage presentation. Bring it back, Mr. Speaker. Bring back the Youth Agricultural Homestead Program, the YAP. Allow some of those young people who may have expunged records to do their 2-year training. Give them the land, give them the grant, and let them be involved in positive agricultural opportunity in this country. Bring back the drilling rig operations program drop, training in the energy sector. Bring back the youth training programs in Tobago and Trinidad, including agriculture, fabrication, carpentry, catering. Bring that back into alignment with the Ministry of Youth Development. We have a whole minister there. And what is happening to the young people? Not one thing, Mr. Speaker. Bring back the youth caravan. Go into the communities. As this legislation is enacted, go into the communities and tell them what is available from the Ministry of Youth to help them to develop, so that if we want reduced recidivism, if you want them to be able to get sustainable employment, if you want the economic benefit of our young people working in industry in this country and moving money along, then you have to bring back these programs so that they can get what they need. Bring back the Reach mentorship, bring back Fuse, bring back these programs, Mr. Speaker. The PNM has laid the track record showing you how to do it. Bring it back so that as you enact this legislation and young people have the opportunity to be employed, they have the skills that go along with the opportunity. The UNC must pair this program, this youth program with the legislation. Bring back the youth camps, open them. What has happened to them? They were under construction, almost ready to open. We have heard not a word. All of this has been happening for the development of young people in this country, and those who will benefit from this legislation definitely need this. So we say to the UNC, bring back the youth programs, the skill training, and the youth camps, and allow persons who are looking with hope to this legislation to get the skills to be able to really get the second chance that they are looking for. Mr. Speaker, the legislation is important. It is critical. The PNM knew that, and the UNC knows that. They have brought it. But along with that must come certain initiatives, some of which existed before, which will allow the intention of the legislation to be realized by those who are looking to it with hope, because they want stronger families, they want to be employed, they want to be productive citizens. But if they are given the chance, in principle, and their lived reality is different, Mr. Speaker, then what we get from this might be the actual opposite, as hopes are dashed and persons in anger and frustration turn back to the life that they are also trying to avoid. So, Mr. Speaker, again, there needs to be an ecosystem of support that goes along with this legislation. We support it fully on this side. It is PNM legislation, so we support it fully on this side. But we are also looking forward to what goes along with it, so that the citizens can really get the benefit, and the country can get the benefit of those citizens becoming productive and joining the national labor force. Mr. Speaker, I thank you.
Member for Toko Samuel Grandin.
Mr. Speaker, thank you for the opportunity to join this debate. Mr. Speaker, it has become a pattern of this government, this former government, now opposition. Yes, because government for them is about filling their pockets.
That's not appropriate. Come on, not for this debate.
Simply, yes, but let me respond by saying this. When someone has an interest, it is understood to be a practice of this House that if you have some benefit from something, you should declare it. So we heard a very passionate complaint about programs being closed down and almost begging for these programs to be reopened. But what they did not do, and what they must do, is when you are calling for these programs to be reopened, declare what interest you have, what monetary interest you have, here and in the other place. Members must declare their interests. So we heard about all the programs, and we know now that these programs are not for the benefit of anybody but the former government. For them monetarily, not for their supporters. They don't care about their supporters. So we are not bringing back programs to fill anybody's pocket here or in the other place. We are bringing programs and we are bringing initiatives that would actually work to help the people of this country. And you see, the thing is, it's in their DNA. You see, Port of Spain North, St. Anne's West coming here and fighting, seeking to outdo his own leader, sitting after sitting, undermining her. He came last week when he spoke last Friday to say that I was demonizing the people of Belmont. I never suggested...
Mr. Speaker, I rise on standing order 48-1. What is the relevance of this to the debate?
I think we could move along a little quickly on that.
I'll move along by making this point, by making this simple point. Because I'm responding to what was said. And don't let me get into... You see, what was said just now, and let me go back to it, they gave the impression, they sort of masquerade, that they had some sort of robust legislative agenda. Robust? Your legislative agenda wasn't robust. It bust. And it bust bad. It bust bad because let me tell you, every time we come with a bill, it's them all. Every time we come with some initiative, if NGC makes profit, it's them do it. If crime goes down, it's them do it. They said, and I remember Port of Spain South in particular talking about that, because the point was murders reduced by 42%, and they said, you know what? That was the result of their 10 years of planning. So 10 years of planning, the murder rate never inched down, but the minute they're out of office and we're in office, it dropped down by 42%. They only like to take credit, but they don't want to take credit for all the wrongs. So let me deal with this wrong that they're taking credit for, because they had, I think it was 2019 was mentioned, the year 2019, or is it 2022, when they claim, well, the bill was drafted. This was their idea, they say, and they want to say it was their idea, and we are now capitalizing on their good work. But if this was their idea for 6 years now, or 7, or how many ever, why you bring it? What's so hard in bringing it in 6 or 7 years that we could just, in less than 1 year, bring it? 1 year now. The Parliament has opened 1 year ago, and in 1 year we were able to bring about 5 or 6 pieces of legislation that they claim to be their own, that they couldn't bring in the last 10 years. But they want to take credit. Government for them is a sham, a mask they hold before their face. The truth is that just like a certain member, government for them is about recusing themselves so daddy and brother could make money.
48-6.
Member, all right. I don't think you're guilty of 48-6 in particular, but I think you're belaboring that point a little too much. Let's move on with the provision.
Sorry, I just wanted to rub it in. Because they like to pretend, because this bill is about giving second chances. Second chances to the people of Bella Road, Serrano Road, and incidentally, I was a fire victim and I lived at Sharford Courts at one time. So this is for people from Sharford Courts, many of whom get themselves in problems and now seek to benefit, because it would benefit them. And so if you really want to benefit, and since Port of Spain, North St. Anne's West, was in national security for 3 years and was a member of the National Security Council for almost the 10 years they were in government, he had the opportunity to ensure that this legislation was brought so that it would benefit his own constituents. But when you see him, it's just there to wear, he wear sneakers and he wear hat and chain up and hug up and everybody in Sharford Court because internal elections coming up and he wants to take over. He wants to outdo, he wants to undermine his own leader. Instead of what he should have been doing was bringing legislation like this. But all he was doing, if he was busy working, because I want to connect this to what he said last Friday, because I heard today that the Mercy Committee was overwhelmed with work. It basically has seized up, and we had to buy WD-40. But Friday, Port of Spain, North St. Anne's West, I don't know how this came out. Just the day after the Defense Council met, all of a sudden he come the next day and say, you know, the Defense Council couldn't meet in 5 years. Because they were busy doing everything else. They were busy seeking to recuse themselves instead of doing the people work. That is what we are here doing. We are not recusing ourselves. We are bringing meaningful change for persons who, like from Port of Spain, North St. Anne's West, and Port of Spain South in particular, find themselves having to need progressive legislation like this, which their elected representatives who were in power for the last 10 years didn't see it fitting to bring, because I guess it had no money in it or nothing to recuse. So let me briefly move on to Laventille West. And I'm not going to talk about the treason. I'm not going to accuse you of anything. I'm just going to rebut what you said. And it's not an attack, because I admire this young lawyer. In fact, this side of the bench is the future of the PNM. That's the history going up there on that side. Yeah, but it doesn't look so bright with San Fernando East at the helm. But, Mr. Speaker, my young friend from Laventille West made reference to Clause 17 and complained that after you make an application under Clause 17 and you fail, that you are, in essence, debarred from bringing any further application. And all I want to say is a failure. But the reality is, for those who have practiced long enough in the courts, when the courts recognize that your hands are going to be tied in situations such as these, a number of things happen. First thing, courts generally, if they notice your hands will be tied and you wouldn't be able to come back again, what they do is they advise the lawyer, listen, this is deficient, and if I rule against you, then your client is going to suffer. what courts generally do is tell you, listen, you are free to withdraw your application, and when you are better placed to make a better application, you can bring it back. That's one of the things they do. All of the courts I've seen do things like this. And they are particularly lenient on persons who either make applications themselves or persons who hire pettifoggers like, I don't want to call his constituency, but if you hire a lawyer and the court recognizes that the lawyer is a pettifogger and doesn't know what he's doing, sometimes the court would seek to go give some guidance and tell you, well, you know, young counsel or whoever, better you withdraw the application, or let me adjourn the application so that you can put in these documents or put in an additional affidavit or whatever is deficient, you can cure it. So that's two avenues that courts usually utilize. Now, if you, in essence, fail, that's not the end of the road. Because, and I know Laventille West means well, but maybe if he had looked a little further down in the bill, you would see that the powers of the president under Section 87, with respect to pardons and so on, is preserved. So that even if you fail under Clause 17 in this legislation, it simply means you will not be allowed to make an application again under this regime, but you are not precluded from going the other route and using the other regime, which is you approach the president for a presidential pardon, because it is still preserved. So although I said I feel you at the start, all is not lost, because there are so many avenues to get around what seems like a hindrance, but in reality, it is not. Now, I already dealt with the last speaker whose submissions was, in essence, that it was basically coulda, woulda, shoulda. That the PNM coulda do this, they shoulda do this, they woulda do this, but they didn't do this. There was a subliminal concession of failure on her part. And that's what the PNM did for the last 10 years. They have failed their constituents, more particularly the young persons. Now, the other part, in essence, of her submission is, in essence, that the law is not sufficient and that we should somehow find a link so that the government could be linking jobs. I don't know. The minute I heard it, I recall a proverb from the Student's Companion, which says, in essence, God helps those who help themselves. And that's the problem with this version of the PNM. Because they have created a dependency syndrome. Wow. Yeah, it's almost as if the government has to find work for you. It's almost as if the government is responsible for you. But the reality is, the government simply puts the framework. God helps those who help themselves. Yeah, we put the framework. And the framework is not, no, you're asking for headlines. You're asking that this would be the headlines. Your headlines was, Fitzgerald Hines, I'm not responsible for anybody's safety. That's your headlines. Your headlines was, who live, live, who dead, dead. That's your headlines. Our headlines would be, in essence, we recognize that forgiveness is one of the most excellent human qualities, and we are going to ensure that you are forgiven. This legislation, in essence, just like parole, just like probation, just like many of the pieces of legislation that now form part of our anti-crime tapestry, is geared towards not only forgiveness, but restorative justice and reintegration. Yeah, rehabilitation. That's something you all did not do. All you did was complain that it cost $28,000 a month to mine a prisoner, and you did nothing in the last 10 years to make anything work. But the pieces of legislation that we have brought it in recognition of the fact that recidivism is one of the root causes, as just accepted by the last speaker. So we are trying to deal with recidivism, and we have put this further piece in the tapestry to benefit a number of persons in a number of ways, and I'll go through the bill in a little bit to suggest how. But before I do that, let me make reference to, and tie it into what I just said. Throughout the submission of the last speaker, we heard about many people not having skills and many people not having the education and the skills to equip them to get jobs. I wrote it down. But Eric Williams must be turning in his grave, because that is what the PNMU is supposed about. Yeah, he's turning in his grave, because what you all have done is what you put there for the young people is only CPEP and URP. That's all you put there for the young people to aspire to. That's all you put there for the young people to aspire to. And now that we move it and we are trying to do something better, because URP was a source of serious violence and serious killings. CPEP was a source of serious corruption and benefiting, and I don't want to call nobody name here who benefited from having CPEP contracts, but with some of them right opposite I mean too. Yeah. But you see, this thing is, we have inherited the mass and morass of what you've done for the last 10 years. So we are seeking to fix it. And fixing it is not doing the same old thing that you all were doing, right? Fixing it is not continuing with a Ministry of Youth Development that you talk so much about, but what you didn't talk about is the fact that it was an abject failure. Who did it benefit? Who did it benefit? And you see, last week you made the point that all of these programs benefited the youth and would have led to a reduction in crime, when the reality was you had all these programs and crime just kept going up and up and up. So how all of a sudden when we disbanded, crime going down by 42%? It's because what you were doing simply did not work. You want to disturb me when I answer, you just complain. You want to talk about belly? You want to talk about belly? Big, bigger, biggest. Right? So we can get the belly out of the way. Lavantel West bigger, San Fernando East biggest. I hope that would silence you all.
All right, come on. I think you've had enough of that.
They interrupted me.
Yes.
And you're not getting.
You forgot we've done dozens of cases together.
Guided.
You're not easily that distracted.
Guided.
You're not that easily distracted. Come on, too. You're not telling me that story.
Yeah, guided. So, Mr. Speaker, let me now move on to some of the comments that I've seen on social media about this bill, because you see, there are many people in this country who do not buy into forgiveness or the need for forgiveness, not realizing that it redounds to everyone's benefit when people are forgiven. I think some part in the Bible spoke about unforgiveness and the deleterious effects it has on us. So I see that one person commented that this bill soften crime and it might let criminals walk free. Let me make this clear for the benefit of the listening public. It doesn't erase convictions, or at least only the most minimal ones. It creates a conditional legal status change after strict eligibility test, so that serious offenses are explicitly excluded. And one would note that the offenses which are excluded from the remit of this bill would be offenses, mainly offenses of serious violence. It doesn't mean that you cannot be pardoned, because there's still Section 87 and the power of pardon. But you cannot expect to engage in murder, in rape, and in such serious offenses against the person, and then simply walk away unscathed. Because the short point is, if you have a proclivity for sexual offenses, then a potential employer should know. Why should you benefit from that? Why should he hire you knowing the risk, there's a risk that hiring you can be injurious to himself or the women folk who he employs? So that's the rationale of excluding certain types of offenses in the bill. So this, in essence, is a calibration with respect to some of the offenses, and with exclusions in certain cases. Now, it's not blanket relief I've just indicated, because in the structure of the legislation, it's time-bound, and the court has, in essence, jurisdiction to pronounce and to make decisions as to whether records should be expunged and so on. And the eligibility depends, first of all, in large part on it being a first conviction, that there was full sentence compliance. In essence, your eligibility starts only when your sentence ends, unless, of course, if it's a non-custodial sentence, eligibility starts from the date of conviction. So it's first conviction only, full sentence compliance, and sustained lawful behavior over a period of time, and that is set out in the Act. So in essence, it's not automatic forgiveness, it is earned rehabilitation. Another asks, why should convicted persons get a second chance when victims don't? I want to say that the bill does not in any way diminish what happens with respect to victims, and that's why it is limited to only the most minor of offenses, and the offenses that may prove unjustly harsh if you are allowed to go on with this blemish on your character. Because at the end of the day, sometimes you hear people saying, look, I've served my debt to society by going to prison. That's true, and that's the punishment. Your punishment is the deprivation of liberty, or the fact of a conviction. So if you have been sentenced to 3 years hard labor, then that should be it. You shouldn't be paying for it for the rest of your life in terms of not being able to get employment, or if you are found out that you lose employment, or you are stigmatized. So that is what we are trying to remove. And again, it's only for the most, not necessarily trivial, but it's not for the more serious offenses, more particularly the offenses of violence. And of course, inherent in all of this is the court deciding, hearing the facts of the offense, hearing the plea mitigation, the court would then determine that maybe this is the sentence I should impose, and by imposing certain sentences, and the court can go up to a certain range, if the court sentences you to less than 6 months, then the applicable law changes to if it's between 6 months onwards. And if it's more than 3 years, then of course not. And what we are saying is the policy objective is preventing repeat offending, which ultimately, once we can get a handle on repeat offenders and recidivism, that obviously redounds to the benefit of all of us, including persons who were once victims of crime. So the real policy question is, do we reduce offending, or do we do as happened in the last 10 years, which is to ignore it? Because recidivism is a root cause of crime. And that is what they've done for the last 10 years. They have ignored that. They've allowed recidivism to continue so that half of the people who come out go back in, and that's why we've had a high crime rate. So what we are doing bit by bit, there's no magic bullet in crime, but every initiative you come up with, you chip away. You chip away so that bit by bit, if we know recidivism is responsible for a percentage, we seek to minimize that percentage so that bit by bit, come 2030, you'll see a very new, a paradigm shift, and you'll see how national security ought to work. Another asks if I can cut to the chase, because it's a rather long question, but in essence, she's asking, is this a national security risk? Well, on social media, they ask you all sorts of things, but we have all sorts of people make up the world and all sorts of questions, and there's no such thing as a stupid question. Well, let me withdraw that as I look across the bench. But is this a national security risk? The answer is no. And we say that because high-risk categories of crimes are excluded outright. And additionally, the security services and certain regulated professions retain full disclosure requirements so that the wrong people are not hired in the wrong places. And that the High Court retains, well, there should be Court of Appeal, ultimately retains final oversight. Another question, won't employers be misled if records are spent? In essence, once they are expunged, it in essence seeks to protect, and because the expungement is in recognition of the fact that the offender committed, he previously had a good record, committed an offense and has not offended since, and that in essence is demonstrative of the fact that he is on his way to reformation, that there is transformative change, and that he is someone who should be trusted back into society. You shouldn't be punished for the rest of your life on the basis of...
you have just about 15 seconds unless you want your 15 minutes.
I would like my 15 seconds and 15 minutes. So what the bill seeks to do, it's really a balancing exercise. So this is a balance. It's not concealment. It's transparency with proportionality. That's what it is. Why introduce this now is another, well, this is one of the better questions from social media. Why introduce this now? What problem are you solving? So in essence, we are seeking to prevent lifelong exclusion from society and isolation for rehabilitated individuals, because we all know that social isolation and exclusion is what leads to persons seeking company in gangs and other such ecosystems. And once you find comfort in these places, that is what would again lead to reoffending. So that it is, the bill is premised on the understanding that lifelong exclusion on the basis of one conviction when one was young or so many years ago, these things create, they act as a hindrance to employment. It continues recidivism cycles and so on. So we are fixing, in essence, a systemic failure that should have been fixed 7 years ago when they claimed they were going to bring this, and a systemic failure that, in essence, undermines public safety. I'll skip some of the questions and go to the better ones. Isn't this unfair to law-abiding citizens? The response is, on the contrary, it is not, because it benefits law-abiding citizens by promoting a reduction in recidivism, which would result, and statistically speaking, it has resulted in safer communities. There's stronger reintegration systems to reduce burden on policing, and so on. I see the noise is coming, but I don't know if you want me to start back to tell you something, and then you complain. Right, so public safety, in essence, improves when recidivism goes down, and this benefits everyone. And could this be abused politically? The short answer is no. It's more or less court-controlled and criteria-driven, and there's oversight by the High Court and the Court of Appeal. And in essence, with this framework, we are seeking to align ourselves with things that worked in other jurisdictions in the Caribbean, and Jamaica in particular, like Zoso, which you did not want. And it seems as if you didn't want this either, because if you did, you would have brought it 7 years ago. Yes. Mr. Speaker, can I ask how much time I have? Because I want to go through the bill, but because what
11 minutes.
I didn't hear you.
11.
Let me rephrase that. Let me rephrase that. Unlike the previous speaker, I want to go through the bill because the previous speaker was basically talking about ecosystems and how many programs were closed down, and almost crying to the point that we wondered if she lost something herself. You know, so if she lost her canteen. Oh, she lost her canteen. How sad. Dear. Yes. And Anna Ministry, yes. She was a waste of an education minister anyway. Yes. So
what? I honestly did not hear that.
The tune out, Mr. Speaker, but 48-4.
Yes. So clause 6 of the, that was like.
Joko, let's move on. Come on, forget the invective. It's too late in the evening for that.
How much time is that? Yeah. Yes. So if I could go quickly to clause 6, it provides a bit of a good news in the sense that this act applies to persons who were. So the persons who would benefit from this piece of legislation wouldn't be simply persons benefiting going forward, because under clause 6 of the Act, it applies whether the person was convicted before or after the coming into force of the Act. And since his conviction, he has not been convicted of any relevant offense. And yes, and in those circumstances, it's treated as a spent conviction. Reference is made to Section 2, again, as to what offenses are excluded. So it applies to convictions which occurred before the Act, providing that no other convictions happened since that conviction, so that you meet the criteria in terms of the rehabilitation period. 6.2, in essence, states the limitation, and you are not a rehabilitated person under this section unless it was your first conviction. 6.3, in essence, spells out that the sentence which was imposed must not have been a sentence in excess of 3 years, and it treats it how the law applies when a non-custodial sentence was imposed and there's no further convictions. It is automatically treated as spent. Clause 4, in essence, deals particularly with young persons. So if you were under the age of 18 years at the time of conviction and you were convicted in a court of summary jurisdiction and you've not been convicted of any other offense between the time of 18 and 21, between 18 and 21, then you benefit. If it's an indictable offense, then of course the rehabilitation period would be between the ages of 18 and 25, and you'll be treated in those circumstances as a rehabilitated person. The conviction will be treated as spent, and it shall be expunged from the record, and without the requirement for an application to be made. Under Section 5, a parent can make an application to the Commissioner of Police. And again, under Section 6, we see the retrospective nature so that the benefit is not limited to after the proclamation of the Act. And if it's convictions in foreign jurisdictions, that is covered by the Act. How the rehabilitation period is calculated in terms of when it commences is in Section 8. And of course, there are other sections which are very interesting for those who practice criminal law and which would change how cross-examination takes place in criminal trials. We all know the bad character legislation under the Evidence Act. I think it was Act number 16 of 2009, which made provisions for bad character legislation. It is now clear because up to this time, we in Trinidad and Tobago, we do not have spent convictions, but with the creation of, with these provisions, when once proclaimed, then the court can limit what questions can be asked and answered about a person who's giving evidence and who has had convictions which were spent. So it limits disclosure in courts and so on. This is something which the courts, since the days of Herbert Volney, have been crying out for. Yes, I don't think I need to go into too much detail about the positive duty to disclose, unless you want me to. Yeah, I could. Yeah, I see San Fernando East, who never has anything to say of value. But 11, a person shall, if requested to do so, disclose in relation to himself particulars of any spent conviction when seeking to be made a member of specific professions which are set out in the 3rd schedule and the 4th schedule and businesses in the 5th schedule. And of course, there are provisions dealing with false disclosure under Section 11 and the creation of offences regarding admission into these offences. Of course, again, we are on the issue of expungement of spent convictions, and the issue was first raised by the member for Laventille West, giving the jurisdiction of the High Court to consider applications for expungement of spent convictions, the powers to grant, to refuse, the balancing act that is carried out by the court in its decision whether to expunge or not, and what may be used by the court, the power to sit in camera, and so on. And subsection 15.3 deals with the contents of the application, and thereafter the date when eligibility is calculated, and it places a positive duty on the Commissioner of Police to expunge these convictions when there's an order of the court to do so. And then 16 and 17, in essence, what my friend from Laventille West referred to about the Court of Appeal and no further redress once the application fails. Of course, the hearing before the Court of Appeal is not on points of law, it's by way of a rehearing of the entire application. And so that there is further redress. It deals with publications of applications being a contempt of court, and how and the essence of what having a spent conviction being expunged means for the rehabilitated person. That's section 19, which in essence says that it is as if that person has never been charged with, prosecuted for, convicted of, or sentenced for any offense into which the Mr. Speaker, I'm being disturbed by San Fernando East. I'm not begging, but I got to tell him something just now. I got, no, come here.
San Fernando East, come on. Yes, I know you're getting restless, but recess is at hand. Come on, member.
I'm sure he didn't read the bill.
Yeah.
Oh, he sounds he never read the bill.
Well, it's clear that San Fernando East never read the bill. So, Mr. Speaker...
Some to read the wrong bills.
Mr. Speaker, you are sitting and watching him continue.
As I admonished St. Augustine last week, I'm not in the habit of taking on the seemingly impossible. Could you just come?
Right. So just to clear up, the sentencing types, Mr. Speaker, are set out in the bill, and I'm not reading from the bill now for the information of San Fernando East, who always seems to have this penchant for irrelevance. But I don't have the crayons to explain this part to you, so sit and listen. If it's a non-custodial sentence, it's the rehabilitation period is 3 years from conviction. Yeah. If it's imprisonment for up to 6 months, it's 5 years after release, 6 months to 18 months imprisonment, 7 years after release, and 18 months to 36 months, 10 years from release. And of course, if the sentence is beyond 36 months, then it's not applicable. I see, Mr. Speaker. 10 seconds. Can I? I've never seen them share.
Mr. Speaker, 48-1, Mr. Speaker. Relevant. 48-1.
All right, your time's up. All right, let's not continue with that. Stop that. Time is up. We'll take the break now, the evening break. It's no longer afternoon. I didn't anticipate that, but we'll resume now at 7. No sense breaking it up. So We're suspended. We resume at 7.
The Honorable the Speaker.
Member for Diego Martin West.
Mr. Speaker, I thank you for the ability to contribute to this debate and the opportunity on the Criminal Records Rehabilitation of Offenders Bill 2026. At the outset, I want to make it pellucidly clear the opposition's position is that we support the principle of rehabilitation. We support the idea that in appropriate cases, persons who have committed offenses, persons who have served their sentences, complied with the law for a meaningful period, and demonstrated genuine rehabilitation should not be condemned to carry one mistake for the remainder of their lives. Of course, that is a fair principle. It is a humane principle. However, support for the principle does not mean automatic acceptance of every clause, every process, and every omission in the bill. Before I go any further, I would like to address the two speakers on the other side that went before, Barataria Sanwan and Toko Sangrigrandi, although they are not in the chamber. You see, Mr. Speaker, when we come to this parliament, we come to deal with serious issues, issues of the people. And as an attorney that it could be considered senior, it is disappointing that we would come to this chamber and the member for Toko Sangrigrandi would spend 40 minutes on a bill not talking about the bill. I want to touch on a few things he said and did. So, for the member for Toko Sangrigrandi, he came and he read social media questions on the bill in Parliament. He could have just pressed reply. Or he could have done like Kuva North and done a video. Now, he mentioned how crime has gone down by 40%. We in our SOE, obviously, Toko Sangrigrandi. And he mentioned youth programs, and he went on to say the PNM built nothing except CPEP and URP. And here we have the member for St. Anne's is listing so many youth programs. And they ask who benefited? The thousands of young people who graduated benefited. It's thousands of people, Labrie. You could continue to bray, but it still won't work here tonight.
All right. I think we've had enough of that before the break. Stop this crosstalk. This is a very simple piece of legislation that we're debating here. So stop it now. I don't envisage we're going to be much longer in this, so let's just stop all of this.
Thank you very much, Mr. Speaker. Now, the general aim of this bill is to alleviate the problems faced by persons who must live with this damaging stigma of a criminal record, even where they have maintained a clean record thereafter. That is the moral center of this bill. It recognizes that a criminal record can outlive the sentence imposed by the court. It can follow a person into the labor market, into education, into housing, into professional life, into community life, and even into the way people in our society view each other. This is not a society where people easily forget. A person may have changed his life, built a family, like the member for St. Anne's would have mentioned, joined a church, started a small business, completed a training program, or gone years without further offending. But somebody somewhere will say, I remember him, I remember what he did. This is why this bill matters. It matters to the young man who made one foolish decision at 19 and is still being judged at 35. It matters to the single mother who committed a minor offense many years ago and is now trying to find stable work. It matters to the person who has paid the fine, completed the sentence, stayed out of trouble, and is now trying to become a taxpayer contributor to society instead of a statistic. It matters to families, communities, employers, and the wider society. Yes, I agree with what some of the members on the opposite side said, that this definitely contributes to crime prevention. Rehabilitation is not softness on crime. Let us not be in the business of keeping that person permanently locked out from legitimate opportunity. Now, this is not an abstract argument in terms of the way people can rehabilitate themselves. Trinidad and Tobago, we have some examples of the way we have become rehabilitated individuals. One of the clearest examples is the late Wayne Chance. Mr. Chance served 10 years in prison after being convicted on robbery. Upon his release, he faced the very temptation that confronts too many former inmates, the pressure to return to the familiar road. He was reportedly offered a gun for protection and was briefly tempted to return to robbery. But instead, he refused the path. He went on to build a home, a successful business, a family, and an organization dedicated to helping ex-prisoners get back on their feet. This is not theory. This is the Trinidad and Tobago experience. Mr. Chance is someone who personified restorative justice, noted that Vision on a Mission gave hundreds of ex-offenders genuine opportunities to reintegrate into our society, resettle, contribute, and create healthier, safer communities. That's his point, Mr. Speaker. When rehabilitation works, the benefit is not confined to the former offender, but it reaches the family, the community, the taxpayer, the church, and everyone around us. A person who is working, parenting, mentoring, farming, building, teaching, or serving is no longer formally an inmate. He can become part of the country's human capital. Let's look at local evidence from rehabilitation programs within the prison system itself. Guardian reported on a rehabilitation and retraining program at Golden Grove, where the program manager stated that about 80% of former inmates who participated were leading successful and productive lives. The program included technical and occupational skills, life skills, and information technology. And the same report identified one of the greatest challenges as the need for assistance and support after completion of sentence. When we look at Debbie Jacobs and her work and her book, Wishing for Wings, we see how individuals want better, but sometimes the process to rehabilitation makes it difficult for them, and they fall back into the recidivism paradigm over and over and over. So yes, we support this because, again, it is a bill where we see that Trinidad and Tobago has examples of people that have changed their lives. The lesson from local experience is also that reform does not happen by accident. Wayne Chance did not succeed because stigma disappeared. He succeeded despite stigma. Vision on a Mission didn't emerge because society made reintegration easy. It emerged because the need was obvious, and the barriers were real, as they continue to be. The prison retraining program did not identify post-release support as a minor issue. It identified it as one of the greatest challenges. That is why in this particular debate, We would also like to hear the government's take on how support services can be offered for those rehabilitated persons, or to get persons that may qualify for this in some years, how to get them support along the way. That's something that we would like to hear more of from the government in this particular debate, and not just gish galloping. We want to pass a law with just not noble language that leaves citizens to fight through confusion at the counter. The purpose of this legislation is not to pretend that the past never happened. The purpose is to recognize that in suitable cases, the past should no longer be allowed to destroy the future. Mr. Speaker, the bill does recognize the need for boundaries, and we applaud that. It does not apply to all offenses. The first schedule, as you know, excludes serious offenses such as murder, treason, manslaughter, robbery, kidnapping, arson, rape, grievous sexual assault, trafficking in dangerous drugs, firearms, terrorism offenses, trafficking persons, proceeds of crime offenses, and certain offenses under the Children's Act. That is important to note for the general public, because if we don't note it, it can be misunderstood and misconstrued, the purpose of this legislation and who it affects and who doesn't affect and who it will benefit and not benefit. The bill also excludes serious sentences, a sentence of imprisonment for life, a sentence of imprisonment for 36 months, or more preventative detention, detention during state pleasure, or for life, and certain sentences exceeding 36 months under legislation dealing with children and child rehabilitation centers are excluded sentences for the purpose of this bill. So, Mr. Speaker, the framework is not reckless. There's a serious attempt to draw boundaries. The question for this House is whether those boundaries are properly drawn, whether the process is accessible, whether the safeguards are strong enough, and whether the institutions charged with carrying out the law will be ready to do so. Something as well the government has not spoken on. The bill provides for rehabilitation periods. According to this bill, essentials, non-custodial sentence, attract a rehabilitation period of 3 years, imprisonment not exceeding 6 months, attracts a period of 5 years, imprisonment exceeding 6 months but not exceeding 18 months, attracts a period of 8 years, and imprisonment exceeding 18 months but not exceeding 3 years, attracts a period of 10 years. Now, this graduated approach, it's sensible in principle. It recognizes that not all sentences are equal, and that passage of time required before a conviction becomes spent should reflect the seriousness of the sentence imposed. A minor non-custodial sentence should not be treated in the same way as a custodial sentence approaching 3 years. However, the real test is whether the ordinary citizen will be able to understand and accept the benefit of the law. Too often, the law is recondite to the people that the law applies to. And that is why it's important for us in this House to discuss and provide clarity on the bills that we come here to debate. So, a person should not need to retain an attorney, search through multiple offices, interpret complicated provisions, and rely on inconsistent advice simply to determine whether a conviction has become spent. If rehabilitation is the policy, then accessibility must be part of the design. Something that my friend from Laventille West also highlighted. A second chance hidden behind bureaucracy is not truly a second chance. It is a maze with a nice signboard at the entrance. This is where implementation becomes central. If the legislation is to work in practice, it must be complemented by a clear implementation plan. The country should be told how many persons are likely to be eligible under the framework. We need to know these things. We need to understand how it will function. That preparation must include the Criminal Records Office, the Trinidad and Tobago Police Service, the judiciary, legal aid, professional bodies, public authorities, employers, and any agency responsible for issuing or relying on police certificates. There must be prescribed forms, clear timelines, proper record management, public guidance, internal training, and where possible, a simple digital process that allows eligible persons to understand their status without unnecessary cost, delay, or confusion. The bill should not create a legal right and then leave citizens to discover by trial and error how it may be used in their specific case. If the purpose is rehabilitation, the process must be practical, affordable, and understandable. And again, my colleague from Laventille West highlighted the support needed and necessary in terms of legal aid, and even asking for some charity in terms of the legal profession, helping out these individuals access this rehabilitation. A right that exists only on paper does not rebuild a life. A right that can be accessed in practice can. Mr. Speaker, the bill provides that once a person becomes rehabilitated, he is to be treated in law as a person who has not committed, been charged with, prosecuted for, convicted of, or sentenced for the offense which was subject of the spent conviction. This bill also restricts the use of spent convictions in proceedings before court, subject to specified exceptions. That is a very significant legal effect. It's not cosmetic. It's not merely an administrative note. It affects how the law regards a person. It affects how questions may be answered. It affects employment and professional opportunity. It affects the way a person may be treated by institution. Because again, the legal effect is so significant, the exceptions must be equally clear. The bill, it provides that spent convictions may still have to be disclosed in certain sensitive areas, including specified professions of employment and categories of business. The bill identifies disclosure requirements where a person seeks membership in specified professional bodies, appointment to specified offices of employment, or engagement in specified types of businesses. It's understandable. A society must be able to protect children, vulnerable persons, public trust, financial systems, law enforcement, and national security. The public would not accept a rehabilitation framework that prevents reasonable scrutiny in its positions of trust. However, disclosure must never become discrimination. If a spent conviction is disclosed for a sensitive role, the law should give and guide what happens next. The existence of a past conviction should not automatically mean exclusion unless the nature of the offense and the responsibilities of the role justify that outcome. The proper test in this scenario should be relevance and proportionality. The decision maker should consider the nature and seriousness of the offense, time that has passed, the age of the person at the time, and I'll come back to the age of the person and how relevant that is based on an experience with a young man who committed a crime and was able to become someone who influenced and mentored other people away from that life. The approach protects the public without making rehabilitation meaningless. It also gives employers and professional bodies a defensible basis for decision making. It prevents arbitrary exclusion while allowing reasonable safeguards. The Attorney General mentioned some jurisdictions with similar legislation, and I would like to touch on some of them. The Commonwealth experience supports this kind of legislation with careful balancing. In the UK, the Rehabilitation of Offenders Act framework provides that once a caution or conviction becomes spent, it does not have to be disclosed in most circumstances. While exceptions exist for sensitive areas, such as work with children and vulnerable adults. Understandably so, Mr. Speaker. Law enforcement, the legal system, high-level financial positions, and certain licenses. Then we look to New Zealand. New Zealand's clean slate scheme automatically conceals eligible convictions in most circumstances and allows a person to say that he or she has no convictions In New Zealand, subject to specified exceptions, where a full record may still be required. Let's look at Canada. Canada uses a record suspension process administered by the Parole Board of Canada. Its public guidance explains that a record suspension allows a person who has completed all sentences and obeyed the law for a set number of years to have the record set aside, helping to reduce stigma, open doors for them to employment, education, voluntary opportunities, and become a citizen that contributes to the whole. These examples show that Trinidad and Tobago, we are not acting outside of Commonwealth tradition. The real issue is whether we are designing a system that is properly suited to our own courts, police administration, public service, labor market, and our social realities. We all understand that Trinidad and Tobago is a society with our own nuances. Mr. Speaker, the bill places jurisdiction for expungement in the High Court. The court may hear applications for expungement and is required to balance the applicant's interests with the public interest in transparency. The court may receive relevant evidence, treat with sensitive matters, and dismiss frivolous or abusive applications. There's value in judicial process. The High Court brings independence, seriousness, and due process. But Parliament must also be realistic about access. High Court proceedings can be intimidating, costly, slow, and unfamiliar to ordinary citizens. Many of the persons who will most need the benefit of this law may find it very difficult to navigate a formal court process. A person who committed a minor offense many years ago may now be working in construction, security, maintenance, caregiving, transport, agriculture, retail, or the informal economy. That person may not have easy access to legal advice. He may not know how to prepare affidavits or even where to go, where to locate old records, file documents, or follow court procedure. If the route to relief is too difficult, then the law does not help transform. And that is where, again, I stand on my friend from Laventille West's point about the support systems, as well as my colleague from St. Anne's East. The support system needs to be there. When we look at Jamaica's legislation, it establishes a...
Whoever has that phone off, go outside and turn it on and come back in.
Sorry, Mr. Speaker. When we look at Jamaica, the Criminal Records Board, it functions with roles that include reviewing applications, issuing directions to record custodians, and reporting to the minister. It's also important to note what happens in St. Kitts and Nevis and Barbados. They use board or committee type mechanisms, while Trinidad and Tobago's bill adopts a more judicially framed approach through the High Court. Regional experience should not be ignored, and I was hoping when the AG mentioned these are the jurisdictions and the way they approached it, I was wondering how come we didn't decide to go that way of having a board. But hopefully he'll explain in his wrapping up as well. Again, the regional experience should not be ignored. Mr. Speaker, one of the troubling aspects of the bill is the restriction of further applications. When an applicant has been rejected or an appeal dismissed, the applicant cannot reapply. Now let's look at other jurisdictions with regard to this particular clause. In Jamaica, Barbados, and St. Kitts, where rejected applicants may generally reapply after a period of 2 years or such shorter period as may be determined by the relevant board or committee, an absolute bar on reapplication is too rigid. It does not sit comfortably with the rehabilitative purpose of the bill, and with the amendments submitted, we ask the government and we recommend that the government please consider the amendments put forward by the opposition. The law should allow for that possibility to reapply. And I know the member for Toko Sangrani mentioned we still have the way of going about presidential pardon. But think about what that would require in terms of the individual applying and think of the way that restricts certain people from even being encouraged to do it. A more balanced approach would allow a fresh application after a specified period. And like I said, the amendments have been submitted, and we ask the government to consider. If we believe in rehabilitation, the law must leave room for growth. A system that says one failed application ends the matter forever, it's not a law aligned with the spirit of second chances. Mr. Speaker, I also want to address the provisions dealing with young children and young persons generally. The bill provides that where a person was under 18 at the time of conviction and certain conditions are met, the person may be treated as rehabilitated and the conviction may be treated as spent and expunged. For summary offenses, the relevant period is tied to remaining conviction-free between 18 and 21. For indictable offenses, it is tied to remaining conviction-free between 18 and 23. I'll pause there on matters relating directly to the bill and take a side road, and we'll get back to the bill. During the time of the People's National Movement being in administration, there was a program called 40 Under 40. It was a program where the Ministry of Education worked with the Ministry of Youth Development and National Service, and even when it was the Ministry of Sport and Youth Affairs. What it was is where 40 of the most influential people in this country, under 40, from different walks of life, whether it be engineering, whether it be aviation, whether it be medicine, but people that would have done well in their fields, would go to schools and speak to mainly Form 3 and Form 4 students, influencing them into knowing and understanding different employment and job opportunities available to them. In that program, I saw one Sonny Bling. We went to Mova Laventil Secondary School, and he was able to speak to a young man who was abused and really influence his life in a positive way and be a mentor. One of the individuals in that program was a young man by the name of Nicholas Khan. Nicholas Khan served his time, and he came out of prison, and even while in prison, he actually competed in the Poetry Slam. By the way, the Poetry Slam is not funded anymore, but that's another topic for another day. So again, we see things that affect the young people of Trinidad and Tobago. So Nicholas Khan was able to go to schools, influence these young people as a rehabilitated adult, and show them the reasons not to get involved in crime, and speaking from the perspective of someone that was in it and came out of it, was able to influence positively. That's the effect of rehabilitation. Rehabilitation can change lives, and we could influence the next generation to do better and be better. And the member for Toko Sangriani, he said something that pinched at my nerves. He said, they only fought for those youth programs because those youth programs benefited them. But I'll tell you, everyone who was in that 40 Under 40 program was a volunteer. And that's what it is. There's the art of the Gish Gallop. I want to touch on this very quickly, Mr. Speaker. The Gish Gallop is a rhetorical technique where in a debate, the debater overwhelms an opponent, or tries to, by presenting excessive number of arguments, half-truths, inaccuracies, rapid succession, making it impossible to address them all within the allotted time. It prioritizes quantity over quality, often leaving the opponent unable to refute every point. Well, we don't have to spend any time refuting any points because that one is Gish, that one is Gallop. So again, we see many of these programs being removed that provided the opportunity for these young people. Young people should not lose the benefit of this law because of paperwork or institutional delay. If the state is prepared to say that certain youth convictions should no longer define a person, then the state must design a process that gives effect to that promise. Mr. Speaker, the employment dimension of this bill must not be understated. This is not only a criminal justice bill, it is also an employment bill, a poverty reduction bill, a family stability bill, and a public safety bill. Let's go into this a little bit.
Again, regular time.
I would take my additional time, please, Mr. Speaker. Employment is one of the most practical pathways away from reoffending. When a person has stable work, lawful income, routine responsibility, and a sense of worth, the chances of lawful reintegration improve. The reverse is also true. A person who has repeatedly refused work despite having served his sentence and remained conviction-free may become discouraged, dependent, angry, or vulnerable to the same circles that contributed to the original offense. And while we talk about rehabilitation, we are in an economy where over 100 businesses have closed down since this government is in office. So when we talk in rehabilitation, we must also talk about employment and employment opportunities provided or taken away by the current administration. So please, I beg you to take a look at the programs in terms of young people and in terms of reducing employment that you all have taken away on that side. The government should accompany this bill with employer guidance, public education. And this government does public education oh so well. They do public education amazing. Couva North, I love your videos. I see Couva South. I see Couva South putting up videos and pictures all the time. I look at my friends on the other side and they do public education well. But when it comes to matters of the bills that we bring to Parliament, it is absent. I am not obsessed with you. Trust me, I am not. Model recruitment, policies, guidance for human resource practitioners, guidance for professional bodies, and practical information for persons who may be eligible under the Act. The state must lead by example. Public authorities, state enterprises, contracted services providers, government training programs, and social programs must understand and apply the law consistently. St. Anne's mentioned some of the programs, but what she mentioned is far from the full dimension of the programs. She didn't even mention the All Set program. She didn't mention Amplify, Project Trending, Project Drive. I could go on CRISP, teaching young people how to fix ACs and refrigerators. Yes, I heard my friend for Shogunas, he say the youth career and education caravan, that was to eat a food. What are you talking about? When you do not know, do not say.
Mr. Speaker, 48-1. I don't know if he's deaf. I never said that.
But if the member didn't say it, you're going to have to withdraw it unless you're taking ownership of it.
Mr. Speaker, it was such a minor detail in crosstalk that I would take it. Can you let me finish, please, Shogunas East? I will take it back because it is such a minor point that I would not harp on it. Okay, Mr. Speaker? The youth caravan would go to houses in communities, knock on doors, encourage young people to come out and find out about the opportunities available from different ministries when the PNM was in government. That is how serious that program was. And again, it was removed. The member for La Hoketa Tal Paro, yes, we know you're supposed to meet with the sporting organizations and they're waiting for that. But all the youth programs, here's an idea. Do like Muruga Tableland, bring it back, rename it. We won't be vexed. The bill does create offenses and penalties for certain breaches, including unauthorized disclosure and improper exclusion from employment or professional opportunity. Muruga Tableland, I will not answer you.
Resist the temptation. Resist. Resist the temptation. You're the first to complain about crosstalk. So let's just move on.
Mr. Speaker, I did not start. I did not start. There will be a day, there will be a day. Before proclamation, the government should publish or lay a clear implementation readiness statement. That statement should explain the preparedness of the Criminal Records Office, the Trinidad and Tobago Police Service, the judiciary, the legal aid, employers, and professional bodies. Professional bodies like the Association of Chartered Certified Accountants, which I happen to be a member of. Muruga Tableland, I don't know about your qualifications. Mr. Speaker,
48-1, Mr. Speaker. I don't think this debate is about me and irrelevance. I stand on relevance.
Yes, well, well, first of all, both of you, I wasn't aware that the member had to direct her point of order to you, quite apart from that. Put that aside for a moment, the member did identify it. And more importantly, Diego Martin West, you've been making the same point for the last 10 minutes ad nauseum. I think you have exhausted the viability of that point. I think if you could literally squeeze blood out of stone on that point, you've done it. This bill has nothing to do with that. It's a simple legislative mechanism by which, if anyone wants to get a conviction expunged, it's an automatic process. I'm reading it, I'm sitting here listening to all the exchanges of points, and I'm wondering whether anyone has actually read the legislative provisions here. It's actually quite simple, and it really should not engender this kind of semi-vitriolic exchange that seems to be taking place here. So come, let's just carry on with it. You have a few minutes, let's move on and finish it off. It's an automatic process if you read it carefully.
Mr. Speaker, I take your advice, and I always take your advice, Mr. Speaker. Yes, I know. So again, Mr. Speaker, I'm just responding to my friends, Toko Sangri-Gandhi and Barataria Sawa, on their contributions, and unfortunately I had to deal with some others who decided to put their mouth in this debate but refused to stand up. Mr. Speaker,
I'm sure you've read Sun Tzu, The Art of War, right?
Yes.
Yes. You mustn't respond to every provocation. Sometimes a provocation is just to draw you out to identify your position. So apply Sun Tzu, please.
Mr. Speaker, I'll continue. There's also a slight drafting issue that should be clarified. Clause 6.2 provides that a person shall not be treated as rehabilitated unless the conviction was that person's first conviction, the person has served or complied with the sentence or condition imposed. Clause 6.3, however, refers to a person convicted of one or more offenses where the sentence imposed was imprisonment for not more than 3 years, or where no custodial sentence was imposed and where there has been no further conviction during the relevant period. The interaction between those provisions must be clear. The bill should expressly state whether multiple offenses arising from the same proceedings are treated differently from multiple convictions over time. It should also clarify whether the policy intention is to assist first-time offenders only or to allow relief in defined circumstances involving more than one offense. This is not a technical quibble. Eligibility is the heart of the bill. If Parliament leaves ambiguity there, citizens will pay for it later through uncertainty, delay, and litigation. The ordinary person should be able to read this law or receive simple guidance under the law and know whether he may qualify. Precision at this stage will avoid confusion later. Mr. Speaker, I also want to place this bill within the current national mood. Trinidad and Tobago is facing a high public concern about crime. Families are anxious, communities are under pressure, businesses are worried. Citizens want strong enforcement, better detection, swifter justice, and safer communities. In that environment, a bill dealing with spent convictions and expungement must be communicated carefully, and again, I urge the government to do that. Communicate clearer in terms of what this bill means, who it applies to, and how it will affect them in the not-too-distant future. So again, Trinidad and Tobago loves a redemption story. We applaud the government for bringing forth this bill, this rehabilitation bill. And yes, it was done under the PNM, and I acknowledge that, but continuance in governance, regardless of where it comes from, is important. So again, Clause 17 should be amended to allow a fresh application after a fixed period such as 2 years where there is new evidence or material change in circumstances. The power to dismiss frivolous, repetitive, or abusive applications should remain. The government should consider an administrative pathway for straightforward cases supported by a criminal records rehabilitation board or tribunal while preserving the role of the High Court for complex, contested, sensitive, or appeal matters. Mr. Speaker, recommendations are not designed to frustrate the bill. They're designed to make it stronger. A law of this nature will only work if it is trusted by the public, understood by administrators, accessible to eligible citizens, and defensible when challenged. The government should not treat committee stage as a formality. It should treat it as an opportunity to improve the legislation. In this House, the government, we know you all have the numbers, but the people outside will live with the consequences. So to the persons outside this chamber who may one day be affected by this legislation, this bill does not say that crime does not matter. Crime matters, victims matter, accountability matters, public safety matters, and a conviction is a serious thing. But one mistake should not make someone guilty for the rest of their lives. The lesson is not that Trinidad and Tobago must copy another jurisdiction. The lesson is that rehabilitation laws work best when they are clear, accessible, administratively supported, and carefully balanced against the public interest. Mr. Speaker, for those reasons, we support the principle of the bill. We urge the government to strengthen it. We urge the House again to take the next stage, the committee stage, seriously. Implementation must be planned before proclamation, not improvised after. And I urge that legislation be shaped into a law that is not only well-intentioned, but workable, fair, transparent, and worthy of public confidence. Mr. Speaker, I thank you.
Before we do that, I think Leader of the House.
Thank you most kindly, Mr. Speaker. Mr. Speaker, in accordance with Standing Order 15, I beg to move that the House continue to sit until the completion of the business before it.
Honourable members, the question is that the House continue to sit until the completion of the business before it. Those in favour say aye. Aye. Any against? Say no. The ayes have it. The business of the House will continue to sit until its completion. Member for Naparima.
I thank you, Mr. Speaker. I rise today not only as the Member of Parliament for Naparima, but also as a proud member of a government that is guided by vision, anchored in compassion, and led with strength and purpose under the distinguished leadership of our Honorable Prime Minister, the member for Siparia. And what a leadership it has been. Leadership that is not afraid to act. Leadership that does not hide behind committees and old talk whilst people suffer. Leadership that understands that governance is not only about maintaining systems, but more importantly, it is about transforming them. Because, Mr. Speaker, when this administration came into office, we inherited problems. We inherited policies that were incomplete. We inherited systems that were outdated. We inherited a justice framework that in too many instances punished but did not rehabilitate, condemned but did not restore, recorded mistakes but never allowed them to be erased. Mr. Speaker, this is classic PNM, but this government, this side, made a decision we would not manage
Point of order,
failure.
Mr. Speaker. 55(1)B. I've heard this 100 times. Tedious repetition. Tedious repetition.
All right. I want to contextualize this. If we were going to punish for tedious repetition, Diego Martin West would have spoken for 5 minutes, because Diego Martin West repeated almost entirely the speech of St. Anne's. So let's give the young member a chance. Go ahead.
Thank you, Mr. Speaker. As I was saying, we would not manage failure, we would fix it. And that is what great leadership looks like. So today, as I stand in this honorable house to support the Criminal Records Rehabilitation of Offenders Bill 2026, I do so with conviction, with clarity, and with an unshakable sense of duty to the people that elected me into office. Today, we debate legislation that speaks directly to the conscience of our very nation. Justice, Mr. Speaker, is not merely about punishment. Justice must also be about restoration, accountability, reintegration, and ultimately, hope. Mr. Speaker, we on this side understand that Lady Justice may be blind, but she does see in the dark. And what happens in the dark comes into the light. Just as our country came into the light a little over a year ago by giving the UNC an overwhelming mandate. Mr. Speaker, the state has a solemn duty to protect society, but also it carries the moral responsibility to provide a path for genuine rehabilitation. As the Latin maxim reminds us, fiat justitia, ruat caelum. Let justice be done, though the heavens may fall.
Mr. Speaker, point of order 55(1)B. He's repeating himself now.
That's the first time I hear that. You know I'm not a fan of perfunctory rulings, but this time I'm going to be perfunctory. Overruled. Member, continue. Leave the young member alone. Thank you, Mr. Speaker. Stop borderline harassment.
Thank you, Mr. Speaker, for your protection. For too long, our justice system punished but did not rehabilitate, condemned but did not restore, recorded mistakes but rarely allowed redemption. Many citizens who served their sentences continue to face barriers to employment, education, housing, and economic opportunity. Their punishment extended beyond the courtroom and into every aspect of civilian life. This bill changes that reality. It establishes a modern legal framework that balances public safety with humanity, accountability with opportunity, and order with compassion. It recognizes that rehabilitation must have meaning if justice is to remain credible in the eyes of our people. Mr. Speaker, laws are a reflection of our values. They tell our young people whether one mistaken choice defines them forever, whether hard work, reform, and discipline can allow them to rise again. This bill boldly declares that Trinidad and Tobago believes in second chances for those who have genuinely earned them. The Criminal Records Bill 2026 seeks to create a comprehensive legal framework for the treatment of criminal convictions. It introduces the concept of spent convictions, establishes rehabilitation periods, and provides mechanisms for expungement under judicial oversight. This legislation is not merely symbolic, it is transformational. It reaches into the communities and homes across Trinidad and Tobago and says to citizens who have demonstrated reform, your country sees your efforts and recognizes your humanity. Clause 6 introduces the legal mechanism by which certain convictions may become spent after prescribed rehabilitation periods. A spent conviction is not the denial of history, nor the abandonment of accountability. Rather, it is a recognition that the sentence has been served, the obligations fulfilled, and the rehabilitation achieved. As the Latin phrase teaches us, lex prospicit, non respisit. The law looks forward, not backward. And as we on this side understand, forward ever, backward never. This bill embodies that principle by allowing citizens to move beyond past mistakes once they have demonstrated law-abiding conduct over significant periods of time. This bill therefore recognizes a mature understanding of justice. Punishment must exist, but punishment cannot become eternal social exile. Once rehabilitation has genuinely occurred, the law itself must evolve in its treatment of the very individual. Mr. Speaker, let there be no misunderstanding. This bill is not an open door for dangerous offenders. I myself saw a fair share of those types of persons, having been a district medical officer for 6 years, and I am glad for the next provision. This legislation contains clear and rigorous safeguards to protect national security and public confidence. Clause 4 and the first schedule exclude serious offenses from eligibility. Crimes such as murder, treason, kidnapping for ransom, trafficking in dangerous drugs, and grievous sexual assault cannot benefit from these rehabilitation provisions. Those who commit especially heinous crimes are not afforded eligibility. Clause 5 further defines excluded sentences, including life imprisonment, preventative detention, and sentences of and exceeding 36 months of imprisonment. These offenses remain outside the scope of rehabilitation under this legislation framework. This demonstrates that the government is balancing mercy with responsibility. We are targeting individuals who committed relatively minor offenses, served their sentences, and demonstrated years of lawful conduct thereafter. The bill, therefore, does not weaken justice. It strengthens justice by ensuring proportionality, fairness, and structure. Mr. Speaker, those on the other side should take note. Salus populi suprema lex esto. The welfare of the people shall be the supreme law. Public safety remains central to this legislation. The bill establishes structured rehabilitation periods within the second schedule. These periods are intentionally rigorous. For non-custodial sentences, the rehabilitation period is 3 years. For imprisonment between 18 months and 3 years, the rehabilitation period extends to 10 years. These are not short periods, Mr. Speaker. They are substantial tests of character and commitment to reform. During these years, the individual must remain free from serious offenses. Mr. Speaker, commitment gives you a start. Consistency allows you to finish. But ultimately, it is your character that matters. Rehabilitation is therefore earned through conduct, discipline, and the respect for the law. Clause 9 is among the most transformative provisions of this bill. Once a conviction becomes spent, the law treats the individual as though they have not been charged, prosecuted, or convicted for that offense. This is not theoretical. It carries profound real-world implications. Citizens who were previously denied jobs, professional opportunities, or educational advancement due to old convictions will finally have a meaningful pathway to reintegration. Employers, institutions, and agencies will no longer be permitted to hold spent convictions against rehabilitated individuals. What matters is not only the mistakes committed years ago, but also the conduct demonstrated since that time. But for years in Trinidad and Tobago, Mr. Speaker, that was not the reality. For years, people carried the burden of a past mistake into every single opportunity. It was not easy to forgive and to forget. A young man from Barrackpore goes for a job, qualified, ready, willing, and one question stops him. A single mother from Lothians applies for employment, and one disclosure closes the door. A citizen tries to rebuild, and the system quietly reminds them, we have not forgotten. And as the old people say, every day is not Christmas, but every day they pay for one mistake. That is the reality that this bill confronts. Clause 9 changes that. It tells employers, institutions, and even the courts, this person has moved on, and so must you. It ensures that a spent conviction is excluded from court proceedings. It ensures that a person cannot be compelled to disclose it. It ensures that silence on a spent conviction is not deception, it is a legal right. Mr. Speaker, a society that permanently excludes rehabilitated individuals creates conditions for hopelessness and recidivism. A society that provides pathways to lawful participation strengthens social stability and economic growth. For years, Mr. Speaker, citizens carried the invisible burden of a criminal record into every interview, every application, and into every opportunity. One question on a form often determined their future before their qualifications were even considered. This bill confronts that injustice directly. It acknowledges that rehabilitation must be practical, not merely rhetorical. If a person has served their sentence, respected the law, raised their family, worked honestly, and contributed positively to society, the law should recognize that transformation. Clause 22 protects rehabilitated individuals from discrimination in employment and professional opportunities. It also prevents insurance companies from unfairly penalizing citizens for spent convictions that no longer hold legal effect. This is how nations reduce recidivism. This is how societies strengthen communities. Mr. Speaker, I have said this before and I would say it again. Strong communities lead to stronger constituencies, which ultimately leads to strongest countries. Mr. Speaker, people are less likely to return to crime when they are allowed to participate meaningfully in lawful economic life. The government therefore understands that security policy is not solely about enforcement. It is also about opportunity, reintegration, and social stability. Mr. Speaker, as the Latin principle states, nemo debet bis puniri pro uno delicto. No one ought to be punished twice for one offense. One of the greatest injustices within any society is when a citizen who has already paid their debt to the law continues to remain imprisoned by public perception long after their sentence has ended. While a court may impose punishment for a specific period, social stigma often imposes a punishment for life. That reality is precisely why this legislation is so necessary, timely, and transformative. For many rehabilitated individuals, the greatest challenge is not always incarceration itself, but reintegration into the social structure of society after release. The burden of a criminal record can quietly follow a person into every interview, every application form, every housing request, every scholarship opportunity, and every attempt to rebuild their life. Even after years of lawful conduct, some citizens remain permanently judged by the worst decision that they have ever made. Mr. Speaker, a society that refuses to forgive can unintentionally create the very conditions it seeks to prevent. If a rehabilitated individual cannot obtain employment, cannot access educational opportunities, cannot support their family, and cannot regain social dignity, frustration and hopelessness can take root. The law, therefore, has a responsibility not only to punish wrongdoing, but also to create realistic pathways toward lawful participation in society. This bill recognizes a simple but powerful truth. Rehabilitation must mean something. Redemption cannot merely be spoken about in theory while systems continue to deny people the opportunity to prove that they have changed. Mr. Speaker, I was stunned to hear the member for St. Anne's East say we are implementing PNM legislation, but it proves what everybody already knows. The PNM merely talks, the UNC acts. Every opportunity, Mr. Speaker, would quietly disappear for some people. How then can we expect that individual to fully reintegrate into society if society itself refuses to recognize their transformation? This bill addresses precisely that injustice. Social reintegration is one of the strongest deterrents against recidivism. International studies repeatedly demonstrate that individuals who secure stable employment, maintain family support systems, and feel socially accepted are significantly less likely to reoffend. When citizens are allowed to work, contribute taxes, provide for their families, and regain dignity, communities become safer. This is not merely compassion. It is practical governance. It is sound social policy, and it is smart national development. Mr. Speaker, this bill is not weakness. It does not render ourselves, in a manner of speaking, in a way that we cannot provide proper justice for all. For justice cannot simply exist as punishment without purpose. This bill acknowledges that human beings are capable of maturity, discipline, change, and positive growth. And if the law refuses to recognize genuine reform, then rehabilitation itself becomes meaningless. Mr. Speaker, the ability to participate within the social construct of society is deeply connected to dignity. Work provides dignity, education provides dignity, community involvement provides dignity, family responsibility provides dignity. A nation cannot expect stability if it continuously creates social outcasts. Mr. Speaker, I proudly represent the hard-working people of Naparima. These are citizens who wake before sunrise, cultivate the land, go to their jobs, teach their children, operate businesses, and strive daily to provide for their families. Thankfully, this is the norm. But despite this, sometimes a young person makes the wrong decisions. Should they forever remain trapped by a single chapter of their lives? This bill says no. And as I wrap up, Mr. Speaker, as I conclude, I want to just add this. I support this bill because it is just, it is necessary, it is balanced, it is compassionate, and it is long, long overdue. I support it because the law must protect society whilst also allowing redemption where redemption has been earned. The past must not permanently imprison the future. Trinidad and Tobago deserves a justice system that reflects both strength and humanity. This bill gives us all the opportunity not only to forgive, but to forget as well. And with those few words, Mr. Speaker, I thank you.
Martin Northeast.
Thank you, Mr. Speaker. Thanking the Speaker is 48-1? All right, I won't do it again. I won't do that again. Mr. Speaker, I want to compliment the last speaker on his précis of the bill essentials. That's all I have to say about that contribution. Now, I was asked to go easy on him, not just by you. So, Mr. Speaker, there are some nuances in this legislation that need attention. The first one I would like to address is the list of excluded offenses. Now, if you go to the schedule, let me see which schedule it is. The offenses where you cannot get your record expunged include two offenses which need some additional attention by the government. And that is in the first schedule, offense number 7 and offense number 8. And that is unlawful wounding and assault occasioning bodily harm. Now, I must say, unfortunately, for yet another time, the member for Barataria just tried to deal with this in a very superficial manner. But I think it's necessary to examine really what these offenses mean. Let me just go to what is the definition of wounding. In fact, I don't even need to go to my laptop. What's wounding? It is you're breaking the dermis or the epidermis. That's it. You're breaking the skin. That's what wounding is. And the whole point, the point that was made by my colleagues, is that if somebody is guilty of a very minor offense of wounding, this bill will exclude that person from seeking to have their record expunged. I don't know why you're shaking your head, Mr. Speaker. It says unlawful wounding. Wounding is covered in the summary. It's okay, Mr. Speaker. No need to draw you into debate.
Unlawful wounding has a specific legal meaning.
Yes, I realize. But when we go to our Mr. Speaker, I'm sorry, I'm not drawing you into the debate. When one goes to the Summary Offences Act, and one goes to the Offences Against the Persons Act, and the second act that I just called out there is the more important one. What I think the government should do, you're looking at offenses such as shooting with intent to cause grievous bodily harm. That is something where I could see you could equate that offense to other offenses such as arson, kidnapping, and so on. I cannot see how an offense of assault occasioning bodily harm, which in one of the laws I've just mentioned there, has a very minor sentence of imprisonment. Very, very minor. The other problem that I have, so I would like the government to look at these words. Unlawful wounding is far too wide. It will range from very minor wounding to serious wounding. Assault occasioning bodily harm also has a wide range of applications. Grievous bodily harm has a definition in law. Cutting off somebody's hand, for example, that is grievous bodily harm. Disfiguring somebody by throwing acid in their face, that is grievous bodily harm. But bodily harm is simply causing harm to the person, which could be minor, it could be major. So I would like the government to look at this definition, unlawful wounding and assault occasioning bodily harm, and see whether that is what you really intended when you wanted to exclude those offenses. I would also build on a point made by my colleague from Diego Martin West. When one looks at the Caribbean jurisdictions and other Commonwealth jurisdictions, I think it's important for us to understand how they deal with this thing. In Canada, for example, Mr. Speaker, there's a parole board that deals with this matter. And it's necessary to understand the composition of the parole board. It's an independent administrative tribunal. It contributes to the protection of society by facilitating the timely reintegration of offenders and the sustained rehabilitation of individuals into society as law-abiding citizens. It has a diverse membership. The members of the board are independent in their decision-making. They are not subject to any instructions or direction from the government. Their membership comes from the society, comes from various professions, including criminology, law, police, social work, medicine, education, business, and private and public service. And the Canadians are of the view that this is not a matter, the whole question of expunging somebody's record or suspending their record is not a matter for the police. It is a matter for an interdisciplinary, diverse group drawn from the society. Because these people, the criminals, come from the society and they have to go back into society. So that is how Canada deals with it. In Barbados, Mr. Speaker, there is a similar approach to the body that deals with the whole question of expungement of sentences. In Barbados, the Criminal Records Offenders, Rehabilitation of Offenders Board, again is drawn from diverse groups within the society. In Jamaica, they just very recently, and the Jamaican experience is interesting. Jamaica also has a board, also drawn from diverse groups in the society. And in Jamaica, they just increased the size of that board to 9 people. And what was interesting in the report that I have on the Jamaican experience, Mr. Speaker, is that in December, so it is not to say that this government was not aware of this, because this happened over 4 months ago. But in December, the Jamaican government amended its bill that deals with this specific matter. They have a bill called Criminal Records, Rehabilitation of Offenders, an act, sorry. And they brought an amendment bill, and they did some interesting things. They expanded the size of their Criminal Records Board, the board that determines whether records should be expunged or not, and they made it more diverse in terms of representing the whole society of Jamaica. But what they also did, they have extended the term of imprisonment for which you can apply for expungement from 3 years to 10 years. So Jamaica is using its own experience in terms of rehabilitation of offenders and has come to the conclusion that a sentence of 3 years or less is just insufficient. I've looked through some of the penalties in the Summary Offences Act. I've looked through some of the penalties in the offences against the person. Some of them are 4 years. So you just might find yourself on the wrong side of a judicial officer and you might get a 4-year sentence. That's it for you. And you may have done something. I want to go again to this whole question of 3 years of rehabilitation for a non-custodial sentence. Now, a non-custodial sentence could be something as simple as a fine. And the Summary Offences Act is very instructive where that is concerned. What are the offences under the Summary Offences Act? It's a very old act. It has a lot of irrelevant and archaic, anachronistic offences in it. But I think it's necessary to read it for members because you could be convicted of one of these offences and you apply for expungement of your record, but you have to serve a period of rehabilitation for 3 years before you qualify. And let us look at some of these, I will have to say, ridiculous offenses in the Summary Offences Act, probably were serious matters 200 years ago. Section 18 of the Summary Offences Act makes unlawfully taking fish an offense. If that were not ridiculous enough, a particular section deals with killing pigeons. Wounding pigeons is an offense under the Summary Offences Act. But the one that I found that is relevant in terms of this debate is Section 46, and that deals with disorderly persons. Let me go to Section 46 of the Summary Offences Act at this point in time. When I read it, I hope members will understand that to make a person do 3 years of rehabilitation for an offense where a fine is $200, because let's go to 45 and 46 of this bill. 45 is idle and disorderly persons. A person committing any of the offenses mentioned below may be deemed to be an idle and disorderly person and shall be liable to a fine of $200 or imprisonment for 1 month. And this is any person wandering or placing himself in any street to beg. Any person found sleeping or loitering in or under any building. And it goes on to describe other places. Any person who, without leave of the owner, affixes any placard or notice upon any building. Any person pretending or professing to tell fortunes. All of these attract a fine of $200. If you get convicted of that, and there's some more interesting offenses as we go along. If you get that fine of $200, that's a non-custodial sentence. You're going to have to do rehabilitation for 3 years. So I am asking the government to take a look at this whole question of rehabilitation for 3 years for non-custodial sentences. And I'm asking the government to look at it as a whole. There's a very interesting institute that looks in particular at rehabilitation of offenses. It's in Scotland. Just a minute, Mr. Speaker. iPad is not my laptop of choice. So it is not my laptop of choice. But there's a very interesting Scottish institute, and it deals specifically with the whole question of rehabilitation of offenders. It does a lot of research on the matter, and it publishes many, many papers on it. And in it, they look at things like the rehabilitation period, and I was just reading it, and they indicated that there is a trend throughout the world of seeking to reduce the rehabilitation period. They've done a lot of research on this, and they've looked at recidivism, and they have looked at the frequency of recidivism as time goes by, and they actually made a finding after looking at thousands of convicted prisoners who went back into society, that after 7 years, your risk of committing an offense is the same as somebody who has never committed an offense. And based on that research, they are recommending a reduction in all of these periods of rehabilitation that find their way into various laws. So I would like the government to look at that, to look at this whole question of a 3-year rehabilitation period for something as simple as wounding a pigeon, or being disorderly, or drunk and disorderly. If you're drunk and disorderly in a public place, Mr. Speaker, that attracts a fine of a couple $100. And we know people who are drunk in a public place. We know of them, we've seen them. We've seen them on television, giving a performance. And if you are convicted, oh, they're laughing, I ain't calling no name. And if you are convicted of being drunk and disorderly in a public place, and you get your sentence of your fine of $200, rehabilitation for 2 years. So I would ask the government to look at that aspect. The other aspect in terms of the periods, there's a huge jump from a person who has a sentence of imprisonment not exceeding 6 months. He has to rehabilitate, or he or she, for 5 years. As soon as you pass 6 months, so 6 months and 1 day, your rehabilitation period jumps to 8 years. And this is not the modern practice with respect to these things. They are sliding scales, and also the boards that I've mentioned, there's one in Barbados, there's one in Jamaica, there's one in Canada. There are boards all over the world that deal with the expungement or the suspension of criminal records. And they look at things on a case-by-case basis. They look at the severity of the crime and so on. And then from that, there's a formula, and out will come a period of rehabilitation. So I find this is a bit extreme, that if you served a sentence not exceeding 6 months, you have to rehabilitate for 5 years, but 7 months is 8 years. And then the next one, after 18 months, it goes to 10 years. Now that same, one of those summary offenses, the period of imprisonment is 2 years, So it's 10 years rehabilitation for you after serving a period of imprisonment for 2 years. So again, I would urge the government to take a look at that. If I go to the fourth schedule, because my colleagues have already raised the issues about your first conviction, and there are some ambiguities in Section 6 of the Act. If you look at 6.2, it speaks of your first conviction. If you look at 6.3, it talks about more than one conviction. So that needs to be tidied up. And then there is the ethical side of it. Suppose you were convicted of drunk and disorderly behavior in a public place 15 years ago or 20 years ago. And then you get convicted 20 years later of being drunk and disorderly in a public place. A minor infraction. You can't apply for expungement of your record. So it is the whole question of the black and white nature of the schedules in terms of how offenders are being treated. I would urge the government to look at that. I would also urge the government to look at what clearly to me is an anomaly in the fourth schedule. The fourth schedule gives you the categories of employment where persons are required to disclose whether they have been to jail or not. And the one that jumps out at me is hotels. Because under hotels, it's all categories of employment. So if you want to go and work in a hotel and you have a conviction, you have to disclose whether you want a job as a cleaner, as a handyman, as a driver, or whether you want a job as a manager of the hotel. It's the same requirement for disclosure. I don't know anything about double palm. Is that a hotel? But when one goes to insurance companies, Mr. Speaker, look at insurance companies. In insurance companies, the categories of employment are defined as director, manager, secretary, salesman. Now, there are multiple occupations within an insurance company. They are not confined to just director, manager, secretary, salesman. All kind of people. Cleaner will work in an insurance company. So if you want to get a job as a cleaner in an insurance company and you have a conviction, you don't have to disclose. But if you go in a hotel, you have to disclose what, it doesn't matter, if you're the garbage collector in the hotel, you have to disclose whether you have had a conviction before. That needs to be looked at. And it really needs to be confined, in my opinion, to persons who would be dealing with hotel guests and persons like that, and persons at management level and so on. In banks, it's everybody, whether they're cleaner or not. But then in unit trust schemes, it's only the manager and the trustee. Now, we have a very sophisticated Trinidad and Tobago unit trust. And they have all sorts of people working inside of there, all sorts of categories. But this bill says it's only the manager and the trustee. So if you want to work as a security guard in unit trust, you don't have to disclose. But if you want to work as a cleaner in a hotel, you have to disclose. So this fourth schedule needs some looking at, and it needs some adjustment, Mr. Speaker. The other thing that I think my colleagues touched on, but I think requires some, I'm not repeating anything. I know you're confused, but I'm not repeating anything. The other thing that needs to be looked at is the whole question of automatic expungement. And this comes up with the child. Mr. Speaker, I don't know what the Minister of Finance problem is. The child, when you deal with the child, it says you don't have to apply under Section 15. Now, Section 15 is the adult application for expungement of the record. But it then says your parents or your guardians had to apply to the Commissioner of Police. Now, why is that necessary? In so many jurisdictions, for trivial offenses and for children, there's an automatic expunging of the record once you have fulfilled the various requirements. You've served your time, you've done whatever period of rehabilitation. Mr. Speaker, I don't know what the Attorney General's problem is. I don't know what the Attorney General's problem is, because perhaps it seems to me the Attorney General hasn't read the bill.
Well, perhaps it is the same one you had when the member for Naparima was making his contribution. Come on, let's continue.
Seems to me he hasn't read the bill. So I think that the government needs to look at a structure with a non-governmental agency and a system that automatically expunges criminal records, if they are trivial or minor, Mr. Speaker. That is my view. What I realize is going on with this legislation and other legislation, like the one we did just before this, and my colleague from Port of Spain South made the point a few days ago. They're definitely sacrificing quality for quantity. There's no two ways about it. I mean, let's look at the whole question of disclosure. Let's look at whether the Data Protection Act is covered in this legislation. It is not. There's no express reference to the Data Protection Act. In the UK and other jurisdictions across the European Union, for example, spent and expunged convictions are determined to be sensitive personal data. They should be in this bill as well. They should be declared to be sensitive personal information that cannot be in breach of the Data Protection Act. There are so many things wrong with this legislation. in terms of how it's going to operate in practice. If you don't bring in the Data Protection Act into the legislation, how are you going to prevent breach of sensitive and personal information in terms of a conviction? How are you going to protect that? That's something that needs to be dealt with. The other thing is what about the victims? Why it is a victim is not being informed that a record, somebody that attacked somebody, a man who raped a woman, and the fella has served his time, he applies for expungement, he serves his period of rehabilitation, and they say, all right, we're taking that off your record now. What about the woman that was raped? How come you're not bringing into this law a requirement for the victim to be informed of the process? That's missing from this legislation as well. Mr. Speaker. Mr. Speaker, I just want to make it very, very clear that this piece of legislation is a necessary reform. The points I am making, and I know the Attorney General is just too proud to accept advice, but perhaps in his quiet moments he will remember what he's being told. What we are trying to do here is to improve upon the legislation. Yes, it's a major step forward. Yes, it is required. Yes, it is good. But there are so many pitfalls in this legislation that when it is actually put into operation, the whole question about a single conviction, for example, as I said, if I was, not me, I wouldn't be, but if somebody in this parliament was convicted of being drunk and disorderly 20 years ago, and then it happened again, they get drunk again, and they get convicted again, that person could mount a challenge that is unequal treatment under the law. It's a disproportionate application of the law. A single conviction for a very serious crime, an offense against a person, that person could get a record expunged. The other person, the drunkard, who drink twice in 20 years, that person cannot get a record expunged. These are things I heard the Attorney General say when he was introducing the bill, that there are constitutional issues. They looked at it and they're satisfied that it does not require a special majority. I would suggest the Attorney General look at that again. So to summarize, Mr. Speaker, I didn't speak about the member for Toko Sandigrandi at all, because he didn't speak about the bill. So there's no requirement for me to speak about the contribution of the member for Toko Sandigrandi. I would ask the Attorney General to re-examine the fourth schedule to see whether it is necessary for all employees in hotels to be subject to the requirement for disclosure, and whether it is necessary for in insurance companies to only have the categories that are there, and in the unit trust scheme, only the categories that were there, and even in the security service organizations, it's limited to director, manager, security guards. There are multiple occupations within a security organization. So I would urge the Attorney General to look at that. I would urge the Attorney General to look at the application of the 7th and 8th offenses in the first schedule, and I would urge the Attorney General to look at, in the second schedule, whether these rehabilitation periods make any sense, especially the rehabilitation period of 3 years for a non-custodial sentence. And we are supporting this bill, so let's not get into any old talk about whether the PM is supporting it or not supporting it. We will vote yes. And with those words, I thank you, Mr. Speaker.
Honorable Attorney General.
Mr. Speaker, I'd like to be brief, and I'm going to try my very best to to be brief tonight. I'll start with in the obvious place, with the last speaker, and with his penultimate sentence. He said that the Attorney General is too proud to take advice. I'm hearing something from that side. I might have got what he said wrong. It's 25 to 9. My bedtime is 7 o'clock. And I am almost asleep, as he put it. But not so asleep that I can't deal with him. Okay? So that I'm not too proud. I'm a proud black man from Bella Road. Like my friend, Mr. Sturge. But I'm not too proud to take advice. But I cannot take advice from someone who is telling me that the offense of wounding has something to do with breaking the epidermis. Okay? I can't take advice from that kind of person. I look at the law books. I don't try to give advice to engineers. My Prime Minister tells me, stay in my lane. And I am firmly in my lane, which is the law. So having said all of that, let me just get to the points that I think were raised. Bearing in mind that half asleep, okay? I can deal with him half asleep. Yeah. So, I think the fundamental point that I heard repeated several times was why a board and not a court? And some of us who are not lawyers might not see the connection between that and the constitutional point that I adverted to during the presentation of the bill. I didn't go into it, but I propose to spend a moment or two while I'm awake dealing with that now. You see, we have a separation of powers in this country. Basic constitutional law, the executive, the legislature, the judiciary. Sentencing is a judicial function. Legislating is what we do. Boards are creatures of the executive. Now, I and my team looked at the models in the Caribbean. We examined the favorite cases of my friends opposite, Surat and Suraj. Those cases are separate. They don't deal with separation of powers. They deal with proportionality. We felt that the safest thing to do was to stay in our lane. If sentencing is a judicial function, then the remission of sentencing, we felt, as a first step, should be a judicial function. So we put that function in the High Court. That's the reason for it. There's authority. I could cite that authority ad nauseum at 20 to 9 tonight. It would not help my friends opposite who are engineers and who believe in the epidermis. But But it will help, I am sure, my colleagues on this side and and my colleague from Port of Spain South, and perhaps my colleague from Aruca Lupino. So what we did was to look at what they have done in New Zealand. And we looked at the New Zealand Criminal Records Clean Slate Act of 2004. Section 10 of that act provides for an individual to apply to a district court for an order that the rehabilitation period and so on should be dealt with. We stuck with that model. We felt it was safer, and that was the way we went. This is our first try at this thing, and we don't wish for a court to come at some point in time and to say what you have done breaches fundamental principles in Heinz and R, and it is unconstitutional. That's the answer. It's not rocket science. It's not epidermis. It has nothing to do with the epidermis, and it has nothing to do with engineering. It is law. It is common sense.
That's why you don't understand.
Now, on the point of the data protection, I'm hearing some mumbling about a special majority from persons who refuse to give special majority to Zoso bills and so on and so forth and what have you, and think that I will come here. I born yesterday. I born in Bella Road, Belmont. I'm not coming here with no legislation to give them the right to say, well, this requires a special majority. I'm sorry. It's just not happening. Okay? So this is the way that we have chosen. And you know what? You know what, colleagues? It is precisely the way that the Law Reform Commission adopted to go when they were in power. And I'll tell you another secret. That thing about the Data Protection Act and, well, this is rush legislation. I think the problem is that we just are doing too much for them. Because the very same piece of legislation, drafted in 2022, 11 years, when they were in power, 11 years after the Data Protection Act, guess what? No reference to the Data Protection Act in there. So it was okay then, but it's not okay tonight. So rushed tonight, but not rushed then. Now, onto some of the other points. I don't want to spend too much time on the epidermis, but I just want to remind members that under the Offences Against the Persons Act, this has nothing to do with Google or AI or ChatGPT or one of those things. I don't know anything about that. I keep away from it. But I do know about the law. The Offences Against the Persons Act in Section 12. It provides for a definition of what is unlawful wounding. And this is what it says. Shooting, wounding with intent, the offense is punishable by 15 years. Wounding itself, spectrum, it goes up to 5 years. No apologies for having this where it is in this piece of legislation. Now, there are some other, what I call the softer things, and I'm not good at those. I stay in my lane. And a lot of the discussion this evening had to do with programs which were shut and so on and so forth. Now, what I do know and what has come across my lane is that there were programs when we came into office that were fueling gang-related violent crime. And what we did, because our focus is on avoiding Haiti in Trinidad and Tobago, what we did was to say, let us stop this. We will find another option or other options. We are stopping this because on that side, persons became half-billionaires. I'm not talking about millionaires. Half-billionaires off of some of these programs. And that's what we've been able to see so far. Half-billionaires offered some of these programs. And what we do know is that stretching right back to the police commissioner who they appointed, Mr. Griffith, he kept telling them, y'all are employing, I could call names. If I call those names, they will be in the Hansard, and in record time they will be by the police commissioner. But he know the names too. You are employing these people, and these people are using money to buy guns and to do badness. We don't want that. We're creating states of emergency to put those same people down in Tetron for Mr. Alexander and I to go and visit every month. We don't want that. So what I say is that we do not rejoice in the fact that some of these programs have had to be restructured, but restructured they must be. They cannot continue as they were before. You know why? Because the country could not continue the way it was going before. It's as simple as that. Mr. Speaker, there were a number of other points raised by my colleague for Diego Martin West. I must confess that half asleep, I have forgotten them. I do not wish to degrade the member. He's a young man and he's tried his best this afternoon, and I encourage him to continue to try his best. But perhaps you could write to me and I will write back to you. But Mr. Speaker, with those few words, I beg to move.
Honourable members, the question is that a bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters be now read a second time. Those in favour say aye. Aye. Any against? Say no. The ayes have it.
A bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters.
Honorable Attorney General.
Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Criminal Records Rehabilitation of Offenders Bill 2026 be committed to the Committee of the Whole to be considered clause by clause.
Honorable members, the question is that the Criminal Records Rehabilitation of Offenders Bill 2026 be committed to the Committee of the Whole to be considered clause by clause. Those in favor say aye. Aye. Any against say no. The ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 to 16.
The question is that clauses 1 to 16 stand part of the bill. The question is that clauses 1 to 16 now stand part of the bill. Those in favor say aye. Aye. Any against say no. The ayes have it. Clauses 1 to 16 now stand part of the bill.
Clause 17.
The question is that clause 17 stand part of the bill. Member for Laventille West.
Deeply grateful, Mr. Chairman. In relation to clause 17, I have circulated for consideration the proposed amendment for clause 17. Mr. Chairman, this clause excludes persons who have made applications to the High Court and those who have appealed their decision pursuant to section 16, that they are unable to reapply under this section. What we are proposing is, one, to delete, in terms of deleting clause 17 in its entirety, and proposing two new subsections. The first being that a person who appealed under section 16 is not entitled to make any further application under section 15 in relation to the spent conviction of that application. So that is in keeping with the general principle in terms of the appeal and not allowing a second bite to the cherry. But subsection 2 allows persons to make further applications in relation to section 15, clause 15 of the bill, to only in circumstances where they can establish a material change in circumstances. That the rationale behind same please, Mr. Chairman, is to allow for circumstances where there might be some procedural error in the application of the applicant, if the applicant is a litigant in person, or in cases in relation to some technical issue that might cause an application to be thrown out in the first instance, and to give them an opportunity for consideration later on.
Honorable Attorney General.
We think that I want to thank the member for Laventille
West.
We believe that the courts have an inherent jurisdiction to cure procedural issues, and as a matter of policy, we reject the idea that other than for procedural reasons, someone should be able to repeatedly go back to court. So the amendment is rejected.
Okay. All right, so let's put the amendment first, and then we will, it being rejected. The question is that clause 17 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. All right, the noes have it. Honorable members, the question is that clause 17 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 17 now stands part of the bill.
Clauses 18 to 28.
The question is that clauses 18 to 28 stand part of the bill. All right. The question is that clauses 18 to 28 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 18 to 28 now stand part of the bill.
Schedules 1 to 3.
The question is that schedules 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Schedules 1 to 3 now stand part of the bill.
Schedule 4.
The question is that Schedule 4 now stand part of the bill, right? The question is that Schedule 4 now stand part of the bill. Member for Laventille West.
Deeply grateful, Mr. Chairman. Mr. Chairman, in this schedule, there are, in terms of the offices of employment, it includes the GLSC, civil service, etc. We are making a recommendation to include the members of Parliament, House of Representatives and Senate, and to include all in this section, in this schedule, please.
Thank you.
The question is that the schedule be amended as circulated in
After whatever yeah. Honorable Attorney General. As soon as the response is amended.
Chair, it's a matter of policy. We don't agree and the clauses is rejected. Thanks. Respect.
Okay. That's the extent of your response, Honorable Attorney General.
Correct.
Grateful. All right. The question is that the fourth schedule, Schedule 4, be amended as circulated. Those in favor say aye. Aye. Those against say no. No. The noes have it. The question is that Schedule 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. All right. The ayes have it. Schedule 4 now stands part of the bill.
Schedules 5 to 6, 5 and 6.
The question is that Schedules 5 and 6 stand part of the bill. The question is that Schedules 5 and 6 now stand part of the bill. Those in favor say aye. Aye. Any against say no. The ayes have it. Schedules 5 and 6 now stand part of the bill. And that's it. All right. All the clauses having been exhausted. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill will now be reported to the House. Honorable Attorney General.
Mr. Speaker, I wish to report that the Criminal Records Rehabilitation of Offenders Bill 2026 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Criminal Records Rehabilitation of Offenders Bill 2026. Those in favor say aye. Aye. Any against? The ayes have it. Honorable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters be now read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters be now read a third time and passed. Those in favor say aye. Aye. Any against? Say no. The ayes have it.
A bill entitled An Act to Make Provision for Certain Criminal Convictions of Offenders to Become Spent, to be expunged from the record, and for other related matters.
Honorable Attorney General. Which one are you going to?
Mr. Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Bail Amendment Bill 2026 listed in the appendix be now considered.
Is that the Senate amendments to the Bail Amendment Bill 2026 listed in the Appendix 1 be now considered. All in favor say aye. Aye. Any against? The ayes have it. Go ahead.
Clause 3. In the proposed definition of bail source hearing, delete the words, comma, either on its own motion or at the request of the prosecution, comma.
Honorable Attorney General.
When the bill was approved in the other place, the definition of bail source hearing in clause 3 was changed because to delete the words either on its own motion or the request of the prosecution. Essentially, the amendment was made because the definition ought not to contain substantive law. The amended definition of bail source hearing would now read, bail source hearing means an inquiry conducted by a court with a view to determining whether the source of cash or real property used by the accused or the surety to secure bail was derived from legitimate means. I beg to move.
Boris Winsau.
Mr. Speaker, why did we have to come back from the Senate to have an amendment that was proposed right here before you, before this House? I think that, Mr. Speaker, it vindicates our submission on this side that we made, because this was, Mr. Speaker, when this was debated, we were of the view that this clause was offensive in the source hearing, and also as it was here. Well, when we go to the other 6, I will make those submissions. But, Mr. Speaker, the simple point we make is that these were submissions made by us here. We were ignored, and we come back now to have it, what we said before, endorsed by the Senate, and we agree with it because this was our position ab initio. So we are happy to support it now, Mr. Speaker, because this was our view from the very outset.
Where am I here now? Yeah. Which clause? Clause 3? Honourable members, the question is that this House agree with the Senate in the amendment to Clause 3 of the Bail Amendment Bill 2026. All those in favour say aye. Any against? The ayes have it.
Clause 6. In the proposed subsection 6B1, delete the words "a court shall" and substitute the words "a court may" at the request of the prosecution, comma, or on its own motion, comma.
Honourable Attorney General.
Mr. Speaker, again, the amendment is to delete the words "a court shall," substitute the words "a court may" at the request of the prosecution or on its own motion. It was accepted that it would not be jurisprudentially correct to mandate the court to hold a bail source hearing. It should be a matter of discretion. I beg to move.
For the spin out? Huh? Okay, I think I have to pose the question first. Honourable members, the question is that this House agree with the Senate in the amendments to Clause 6 of the Bail Amendment Bill 2026. For the spin out?
Thank you, Mr. Speaker. The words of the Honourable Attorney General echoes the words of our submissions made before this House when this clause was discussed before this very House, when this bill was introduced. Mr. Speaker, it was not right then that it should have been mandatory for a court to do such a hearing, and it is not right now. We would have preferred, Mr. Speaker, that the entire clause be omitted, but at least now the judicial discretion is there, and we are sanguine in this approach, and we are fortified that we will correct again. Thank you, Mr. Speaker.
Honourable members, the question is that this House agree with the Senate in the amendment to Clause 6 of the Bail Amendment Bill 2026. All in favour say aye. Aye. Any against say no. The ayes have it. Leader of the House.
Thank you most kindly, Mr. Speaker. Mr. Speaker, I beg to move that this House now adjourn to Friday, May 15th at 1:30 p.m. Mr. Speaker, the government will pursue bills number, just to make sure we get it right. Thank you, Mr. Speaker. The government will pursue, Mr. Speaker, as presented on the order paper, bill listed as Bill number 3, will entitle an act to amend the Administration of Justice, DNA Act, Chapter 534, as well as, Mr. Speaker, the bill listed as Bill number 5 on the order paper, bill entitled an act to amend the Public Health Ordinance, Chapter 12, number 4. Thank you kindly, Mr. Speaker.
Before putting the question on the motion for the adjournment, honourable members, leave has been granted for one matter to be raised on the motion for the adjournment. I will now call on the member for San Fernando East, I think it is.
Thank you, Mr. Speaker. Mr. Speaker, it is safe to say that the HDC to date has been nothing less than an unmitigated disaster, Mr. Speaker. Throughout San Fernando East, there has been an absence of services from this institution. San Fernando East, as you may know, has several of the largest HDC communities in Trinidad and Tobago. There's been no garbage collection, Mr. Speaker. No cleaning of drains, Mr. Speaker. No cutting of grass. No services at all coming from this deadbeat institution with this deadbeat minister in this deadbeat government, Mr. Speaker.
Have a seat. All right, let me read your motion for you in case you've forgotten it. The word drain is not mentioned here at all. Oh, it is. So confine yourself to that. It's a 10-minute motion and refrain from calling names. You are the first to complain about name calling. Refrain.
Thank you, Mr. Speaker.
Mr. Speaker.
I only use the word
Mr.
deadbeat
Speaker.
because they failed to keep their
Standing order 48-4. The member must withdraw the reference he made to the minister and be called upon to apologize. For any member he made a comment on the side of the House.
Withdraw the reference and apologize.
Mr. Speaker, I said deadbeat because they're not taking
Withdraw
care of the responsibilities.
Mr. Speaker, 48-4.
Mr. Speaker,
The member must withdraw and apologize.
I withdraw and I apologize.
We would not want
Did not mean to offend
tell him who was
Kuvasaw.
deadbeat inside here.
I didn't realize.
Apologize and continue.
I apologize. I didn't realize Kuvasaw was so sensitive to the
Mr.
words.
Speaker, he must withdraw and apologize properly.
He already did. He already did. He already did. He already did.
Yeah, I know. Don't prolong the agony. Just withdraw and apologize and move on.
I once again withdraw and apologize, Mr. Speaker.
Move on.
Mr. Speaker, in the last year, the people of San Fernando have to endure uneven garbage collection throughout every single HDC community within the constituency, Mr. Speaker. The sad part about it is that many of these residents are also paying their monthly maintenance fees, Mr. Speaker. And we understand that the collection is due to non-payment to garbage collection contractors, Mr. Speaker. This is the same institution, the HDC, that could somehow find $3.4 billion to hand contracts to friends, family, and financiers.
Motion. Is it that you wrote it so long ago you can't remember it? Did you refresh your memory before coming into the chamber?
Yes, sir.
Well, plainly not.
Sir, I said the lack of garbage collection was due to a lack of funding.
No, you went on to say something else which was quite offensive and outside the scope of the motion which you filed. You drafted.
Right.
And you came here prepared to argue. Stick to the text of your motion.
No problem,
If
Mr.
you
Speaker.
want to go outside of it, you know the procedure to do so.
No, I was talking about funding, so I didn't think it was outside
Stick
of the funding
to the
issue.
motion.
Mr. Speaker,
No
standing
problem,
order
Mr. Speaker.
48-6, please. The member talked about friend, family, and financier. The only friend, family, and financier that had in HGC was Pikal. And he knows very well who that belongs to.
Okay, let's not engage in that. Remember, you have 6 minutes more, you know. So make use of it.
6 minutes, is that all, sir? Mr. Speaker, the good people of San Fernando East, under this Minister of Housing, have had to endure filth, rodents, all of that, Mr. Speaker, all while paying their monthly maintenance fees to this HDC and this ministry, Mr. Speaker. Every time I see this minister speaking about his ministry in the news, it's always, I don't know what's going on. So I don't know if to direct the question to him or to the chairman of the HDC, Mr. Speaker. Because this minister never seems to know what's happening in his ministry. But, Mr. Speaker, the people of San Fernando East feel as if we are being discriminated against by this minister, by the HDC, Mr. Speaker, and we are not going to tolerate it. And it's not just garbage. It is also drain cleaning. It is also grass cutting, none of which is taking place, Mr. Speaker. Mr. Speaker, I'm done. Thank you so much. We've had enough of it. Thank you.
Honourable Minister.
Speaker, thank you to allow me to join this. Clearly, the member of San Fernando East doesn't have a home to go to. I think he looks like a toffee bag at some point in time. Okay, I withdraw. Stop that.
Withdraw and apologize. Withdraw and apologize.
I apologize.
Minister, stick to the text of the
Mr. Speaker, this gentleman, I don't even know if he is aware of where the agency communities are in his community. All right? Mr. Speaker, I want to read something to you. Quoted by this gentleman on this matter here. The member. Relax, Diego Martin Ortiz. Not tonight. Not tonight, Diego Martin Ortiz. Not tonight. Mr. Speaker, 20th November 2024, a Facebook post by the member for San Fernando East. The MP for San Fernando East has been in discussions with the AGC and has been assured that garbage collection in the current Hills, current close community will resume from today. The AGC apologizes for this inconvenience and a permanent solution is being crafted to end this unacceptable situation for good. Thank you, he is saying, thank you for your patience in this matter as we continue to work for you. You know, when they were in government, Mr. Speaker, they were in charge with garbage collection. And they were complaining. He is complaining about something when they were in government, Mr. Speaker. Let me tell you, under this government, what we did for San Fernando East community. Garbage collection, I read, Mr. Speaker. Garbage collection services within the AGC cooperation communities in San Fernando East are governed by a clearly defined and consistently executed schedule. Collections take place 3 times per week, Tuesdays, Thursdays, and Saturdays, if you are not aware, across Ridgewood Gardens, Phase 2, Naparima, Mayara Road, Pleasantville, Village Plaza, Monrepo, Orchid Gardens, Pleasantville, apartment buildings, and Taruba Heights, Phases 1 and 2. So you're not aware of where you live. You're not aware. In addition, bulk waste is collected once per week to ensure that large items are properly disposed of and that communities remain clean and sanitary under this government, under AGC. Let me also tell you, underneath them, Mr. Speaker, underneath them, what used to happen with bloated contracts. Oh, yes. Bloated contracts for their friends and families. Bloated contracts.
Mr. Speaker, thank you. Thank you, Mr. Speaker.
Mr. Speaker, underneath them, Mr. Speaker, what they used to give out.
Mr. Speaker, sorry, 48-1. I too wanted to speak about bloated contracts, and I was not allowed to.
Mr. Speaker, the only thing bloated is San Fernando East, Mr. Speaker. The only thing bloated is San Fernando East.
Stop that. That is entirely uncalled for.
Mr. Speaker, at least I am not out on bail. Thank you.
All right. Okay, this is out of control. This debate is done. I'm putting the question on the motion. This is done. Let the minister finish. Minister, you have 1 minute again. Please stay relevant.
Yes.
Otherwise, I'm shutting it down.
I want to assure the member
Mr. Speaker, I rise on a point. Mr. Speaker,
No.
I rise. Mr. Speaker,
it's too late.
I rise on a point of order. I rise
too late
on
now to listen to.
Mr. Speaker, if I may.
To watch
both of you
sit. Beetlejuice, Mr. Speaker.
Both of you sit. This is now out of control. Minister, all members, no, we're going to bring this, we're closing this debate. This motion is closed. We're moving on. Member Faruqa Lopino. Clarification.
Mr. Speaker, listen. Thank you. Mr. Speaker. Mr. Speaker, can I speak in silence, please, Mr. Speaker? Thank you. Mr. Speaker, at the start of today's proceedings, my colleague from Couva South boasted that the government was prepared to answer all questions on notice and questions on the order paper. As of this point in time, Mr. Speaker, there are 2 questions for written response, and my last check with the Parliament is that they have not received the written responses from the Ministry of Public Utilities.
Mr. Speaker, I did have a word with one of the clerks, and the information was furnished to the Parliament. Sometimes it's sent to a different email address, but before I leave here today, I'll make sure that that is sorted, but it was sent to the Parliament.
Thank you very much. I propose to put the question on the adjournment now. Honourable members, the question is that this House do now adjourn to Friday, May 15th at 1:30 p.m. Those in favour say aye. Aye. Any against? Thankfully no. This House now stands adjourned to Friday, May 15th at 1:30 p.m. Thank you all very much and good night.